Summit 2023. Feel free to turn to the person at the back and also stretch your hand and say hi to them. And in case you would like to step out of your chair and say hi to 3 more people, you're very allowed. We give 1 minute to do that, to warm the room up and say hi to our neighbors. Because it will be catastrophic if they ask you, the person you're seated with, on this auspicious occasion, and you're not able to tell. My name is Samuel A. Bakutana. I am a certified executive coach, an award-winning leadership consultant, a global speaker and author. My most recent book, the 17th, being Blossom in Your Job and Business. I am the CEO of Inspired Leaders International, an international leadership development firm that empowers leaders to transform nations. Married to 1 wife, Honorable Charity My Watermelon. Blessed with 2 children, a boy and a girl, Petra and Prosper. And it's my pleasure this wonderful day to be leading the program as your moderator on this National Alternative Dispute Resolution Summit 2023. I welcome all of you, ladies and gentlemen, this morning. Would like you to feel at home, feel at ADR, and I believe that we are going to have an amazing time, not only today, but also tomorrow. So as we begin our program this morning, I would like to join me and we welcome the Honorable Lady Justice Monica Mugenyi, the Justice of Appeal, to kindly come and lead us in an opening prayer. Make her feel at home. The moment you stop clapping, she may also stop walking to the front. Honorable Lady Justice, you're welcome.
Let's humble ourselves and pray. Dear Father, we thank you for bringing us all together today to discuss alternative dispute resolution, to discuss other ways of settling our disputes. We ask for open minds. We ask for the Holy Spirit to guide us and lead us in all our deliberations. In Jesus' name we pray.
Amen. Thank you very much. Where I come from, after such prayers, we clap our hands for the person who has led us. I could seek your indulgence, DCJ, to do the same here. Having done that, I would like to welcome the CR, Madam Sarah Langa, to help us read out the protocol so that as we go along, for us to be able to manage our time well, we do not need to repeat it every time, every now and again. So I'm going to request the Chief Registrar, Madam Sarah, to kindly come and present the protocol so that it will help us to manage our time well. And it's okay to welcome her. It's okay.
Thank you, Sam. Let me add my voice to welcome all of us this beautiful morning to the first high-level national summit on alternative dispute resolution. And I must say it's a wonderful morning, and we thank God for making it possible. And I believe by the end of 2 days, it will be a worthwhile journey that we have had at the start of this week. So you have heard Sarah Langasiu is my name. I'm the Director of Programs for this event, and I'll have 2 assistants along the way, one being Mr. Sam Bakutana, and also His Worship Jamson Karimani, the Public Relations Officer. We will run with you through to the end of this summit. Otherwise, my Lord, the Honorable, the Chief Justice, who is attending online, my Lord, the Honorable, the Deputy Chief Justice, my Lord, the Chief Justice Emeritus, the Honorable Ministers present, particularly the Honorable Minister of Justice and Constitutional Affairs, my Lord, the Honorable, the Principal Judge, my Lords, the Justices and Judges of the Courts of Judicature, both serving and retired, Your Excellencies, the Ambassadors, the Honorable Members of Parliament present, the traditional leaders present, religious leaders present, my Lord, the DPP, the Inspector General of Government, the chairpersons of constitutional commissions, the members of constitutional commissions present, the permanent secretaries who are present with us this morning, the Deputy Governor Bank of Uganda, the distinguished professors and the team from the Pepperdine University, Your Worships, the registrars, the President of the Uganda Law Society, the Senior Counsel present, and all the distinguished members of the bar, all members of the Administration of Justice Program institutions, the academia, members of the Fourth Estate, distinguished participants, ladies and gentlemen. You are all most welcome once again. This is a hybrid summit. We have physical and virtual attendance. And among the people attending virtually is our very own, the Honorable, the Chief Justice. I request us to clap for him. We will be making a number of introductions as we go along with our program. However, I wish to inform us that the official opening by Her Excellency, the Vice President, will take place this afternoon. As we speak right now, she is chairing cabinet. And so we will start running the program with a few adjustments, but we shall ensure that we keep it to the time that we have planned. So I will be coming after the first speaker to make some recognitions of the distinguished participants that we have here. Otherwise, I wish us the very best of this summit. And now I invite Mr. Bakutana to come and invite the first presenter. Thank you.
Thank you very much. Sarah Langa Siu, our CR. As you have heard, we have lords and ladies and gentlemen in the house. When she was mentioning the lords that we have in the house, it reminded me of a story that one of my friends told me about, where the word Lord caused some good problem. You know, in some faith circles, the bishops are called my Lord the Bishop. So this bishop was going to have a number of bishops visiting him, and he called one of his servants and said, when you hear them come, I will invite you. And when you reach here, just say, my Lord, your servant is here, and I will give you instructions. So when the time came and the bishops were all over the place, this young man came, and when he saw all of them in their regalia and looking awesome, he was confused about what he had been told beforehand. Instead of saying, my Lord, your servant is here, he looked at the bishop and said, my servant, your Lord is here. I believe that this morning, since Madame Sarah has helped us to unravel the intricacies of the protocol, we will be saved of that. So when you come to make your remarks, it will be prudent that you immediately get into the substance. All right. So before we invite the first person to give the remarks, let me request the people in the control room to play for us a 2-minute intro video for this auspicious National ADR Summit 2023.
Welcome to the ADR Summit, Alternative Dispute Resolution, which is really aimed at helping resolve conflicts and disputes without resorting to the court situation.
We have been handling cases mainly by ordinary litigation. It takes time, it's costly, and as a result, our courts are congested.
Previously, when you went to court, you entered only one door that led to litigation. But now, with alternative dispute resolution, the court could refer you to another door, which could be negotiate and settle.
We should utilize alternatives to ordinary litigation. There are a number of these. There is mediation, there is arbitration, there is conciliation.
Remember that traditionally, our forefathers and our grandfathers used to resolve disputes through mediation and through negotiation. And most times the people would go away satisfied.
These have been tried in our court system, and they have proved to be effective and useful in terms of time spent for disposal of disputes.
We're going to be working with participants so they really understand why mediation works.
And we're also using resources of people who have been using that in other countries and have found it to be useful.
The judiciary, the Bankers Association, the insurance, the other corporations, MTN and others have come on board and think this should be developed.
It takes a much shorter time and it is much less expensive.
We think this will resolve the issue of backlog in courts.
Director of Public Prosecutions in Uganda and as a judge of the High Court of Uganda. His other positions as a lawyer have included State Attorney at the Attorney General's Chambers, Private Secretary for Legal Affairs in the Office of the President of Uganda, and Assistant Commissioner in the Commissioner General's Office at the Uganda Revenue Authority. He holds a Bachelor's of Laws degree from Makerere University, a diploma in legal practice from the Law Development Center, and was called to the bar in Uganda in 1990. He also holds a Master's of Law in International and Comparative Law from the University of Iowa, a certificate in ADR from Strauss Institute of Dispute Resolution, Pepperdine University, and currently he's pursuing a Master's of Dispute Resolution from the same university. Kindly put your hands together and you welcome the Honorable Justice Mike Chibita.
Thank you very much, Mr. Bakutana. And let's give Chief Registrar a hand clap for saving me from the protocol list. On behalf of the organizing committee, it is in that capacity that I'm here to address you this morning. You are all welcome to this first ever National Summit on Alternative Dispute Resolution. Article 126 of the Constitution of Uganda implores us to dispense justice in a timely manner, without due regard to technicalities, and to promote reconciliation. The National Development Plan 3 highlights the necessity for access to justice with alternative dispute resolution as one of its key components. The Judiciary Strategic Plan 5 identifies the need for strengthening ADR in case disposal, and African traditional justice systems practiced prior to the introduction of the colonial legal framework bespeak of ADR. The legal framework and foundation for alternative dispute resolution are therefore well laid out in the documents aforementioned. It's therefore timely and legally appropriate for this National Alternative Dispute Resolution Summit to be convened to engage on how to resuscitate and consolidate the various efforts clamoring for direction in this very important area of our day-to-day lives. Prior to the convening of this summit, several stakeholder engagements were held with a view to gathering ideas and building consensus towards formulation of a national ADR policy. Indeed, after these stakeholder consultative engagements were held, important views were harnessed that have been incorporated into the draft policy. Suffice for now to say that several bottlenecks were identified that hamper effective and expeditious dispute resolution. Such bottlenecks include, but are not limited to, the following: case backlog, delays, corruption, loss of confidence, elitism, lack of penetration of the law, cost of justice, to mention but a few. It's important that the various categories of individuals comprising the social strata of society are all represented in the justice system. The ability to afford a lawyer and speak English should not, by that very fact, put one at an unfair advantage over somebody who cannot afford a lawyer or cannot follow proceedings in a court of law. It has been said that justice delayed is justice denied. We have to ask ourselves, what is the cost of justice in this country? And what is the cost of delayed dispute resolution? How much does it cost a citizen to register a complaint and get the result? And what is the cost in terms of time, money, emotional distress, and opportunity cost? As we delve into this scintillating discussion, whose menu the summit will serve us over these 2 days, allow me to thank the following, without whose tireless efforts, hard work, and cooperation, this summit will not have taken place, and the list is not exhaustive. The Honorable the Chief Justice and the entire judiciary, Honorable Minister of Justice and Constitutional Affairs, the Solicitor General and their staff, President Jim Gash, Vice President DeWalt, Professors Shoes and Co., and the entire Pepperdine University fraternity, Uganda Bankers Association, International Development Law Organization, the European Union, the cohort of the Masters in Alternative Dispute Resolution, Uganda Law Society, and the specific law firms that will be mentioned later in the program, the media, and of course all of you, ladies and gentlemen. As I conclude, Max Lucado, I will quote him, he said, "Conflict is inevitable, but combat is optional." May the good Lord bless us all abundantly for God and my country.
Conflict is inevitable, but combat is optional. Yeah, let's chat together. Let's talk together. So conflict is inevitable, but combat is optional. Thank you very much, Honorable Justice Mike Chibita, for those important remarks. Now, ladies and gentlemen, I would like you to know that this is a paperless conference to some great extent. You already have some pieces of paper on your tables, but many documents are not going to be given to you, as printouts on your tables. Most of the documents are going to be uploaded on the conference website. And on your tables, you're going to see some QR codes. So at the appropriate time, you will be guided on how you can log in and access most of the documents. At this moment, I would like to welcome one of our key partners, a representative from one of the key partners and sponsors of this important summit, the Uganda Bankers Association. The mission of the Uganda Bankers Association is to promote a sound banking environment through research, innovation, advocacy, good governance, and best practice. And UBA is led by none other than Ms. Sarah Aropta, who happens to be the chairperson of the association. So I would like you to put your hands together kindly and welcome Ms. Sarah Aropta to give us her remarks.
Good morning to you all. I echo my thanks to the Chief Registrar for serving me the long list of protocols. On behalf of the Uganda Bankers Association, as a co-host of this summit, I welcome you all and thank you for choosing to make time to attend this important summit on the high-level national alternative dispute resolution. The need for promoting alternative dispute resolution has numerous justifications and benefits, especially in this part of the world, since it not only supplements the existing judicial court system as a fast, co-efficient, and less acrimonious alternative, but also assists in providing the much-needed assurance and attractiveness of an investment destination if commercial disputes can be resolved in a timely manner to free up capital for further deployment in the economy. Frameworks such as the ADR that help in building confidence and de-risking investments across various sectors not only enable channeling of more resources, but also helps in ensuring that challenges in investment are not tackled in isolation of other factors, but rather holistically. This year, we had planned to theme our annual Bankers flagship event, the July Annual Bankers Conference, around the subject area of arbitration and mediation. However, when we learned that the Ministry of Justice, together with the Judiciary and Pepperdine University, had in mind a symposium with similar objectives, including a training, it made so much sense for us to request a joint session to fully optimize the synergies to achieve these intended objectives. We thank you for that. The judiciary is an incredibly important and critical stakeholder for the banking and wider financial sector. And in 2019, we signed an MOU with the Judicial Training Institute, JTI, to collaborate and provide a platform for UBA to share emerging trends and developments in the banking and broader financial sector in the spirit of capacity building, as well as sensitization to judicial officers on various aspects of commercial banking, including our products, services, processes, and the compliance requirements. The banking industry commends the judiciary for the steps that have so far been taken to address the issue of case backlog, notably the establishment of the Case Backlog Committee, the creation of a party-led small claims court, the promotion of various other alternative dispute resolution mechanisms, such as mediation, and of course, most recently, the development and implementation of the electronic case management system, whose objective is to expedite and ease cost processes and cases. This ingenuity by courts in making use of ADR mechanisms has paved way for resolution of disputes and dispensation of justice, and its use has been considered a key case backlog management tool, even though case backlog remains prevalent in the sector. As an industry, we are equally very grateful, and we applaud the judiciary for providing clarity and guidance in the market recently regarding cross-border transactions involving foreign-based credit providers. This clarity and guidance will, in our view, go a long way in keeping Uganda as an integral part of the global financial credit system, boosting both lender and investor confidence, and further facilitating the flow of the much-needed capital in our economy, and boosting the trade investment for economic growth and development. The ADR mechanism for arbitration is now supported by various private entities, and it is against this background that, working together with the Uganda Law Society, we championed the establishment of ICAMECK as a private sector-led arbitration center. We are most grateful to the Ministry of Justice for the tremendous support we have received to date, including the issuance of an instrument of appointment of the ICAMECK. During the next 2 days, we plan to reinterrogate the various ADR forms to speak to multifaceted participants who seek the resolution of their ever-growing, complex, and wide-ranging disputes, and as such, the summit has been structured first as a conference to assess the place and role of ADR utilization in light of emerging national, regional, and global trends, and secondly, a knowledge and capacity building symposium for the judiciary on the one hand, and practitioners as well as users on the other hand. By the end of this summit, we're hopeful that we will take away concrete action items addressing not only the evolving landscape of financial disputes, but also propose more building blocks required for us to harness the numerous opportunities presented by players in the different sectors, including fintech, construction, energy, oil and gas, and the overall business environment to enable our country leapfrog development stages. We are looking forward to learning from Pepperdine University, blended by the rich crop of resource persons lined up for this summit, and we're hopeful that this collaborative summit involving various stakeholders will provide us all with the key transformative directions required to unlock the potential in alternative dispute resolutions. Last but not least, we look forward to the policy pronouncement from the Ministry of Justice, as well as the strategy direction of the judiciary on alternative dispute resolution mechanisms. I thank all the teams that have been working hard to put this summit together and call upon you all to give this summit your best. Thank you for listening and have a wonderful day ahead.
Thank you very much. I am sure we will do better with the next speaker, but thank you very much for the appreciation of the one who has just spoken. Growing up, I was taught that gratitude is the greatest attitude. So whenever somebody addresses us, ladies and gentlemen, let's give them a good round of applause. So next on our program is Mr. John Fisher Kanyemibwa, who has been a practicing advocate of the High Court of Uganda for over 21 years. He is a member of the International Bar Association, the East African Law Society, and Uganda Law Society. And in addition to his legal studies in Uganda, he received a Master's of Laws in Commercial and Corporate Law from the University of London. Because of his wealth of experience and training, John Fisher plays a major role in the corporate and commercial practices of the firm. He is frequently engaged to provide legal opinions pertaining to legal compliancy and a number of regulatory issues to the firm's clients, especially to banking and financial institutions. As he comes to speak to us this morning, he is recognized as one of the leading legal practitioners in Uganda by the Chambers Global and other reputable law publications. Would you please put your hands together and welcome John Fisher Kanyemibwa to speak to us right now. Kindly welcome him, please.
Good morning. I re-echo Madame Arada's remarks, and I thank our Chief Registrar for presenting a protocol of all who are here. I know some of you are wondering, where is John Fisher? I'm not John Fisher, but I'm ably representing John Fisher. I'm not his twin. Clearly you can see there's an unmistakable dissemblance, but nonetheless, I'm pleased to make his remarks on his behalf. It is with great pleasure that I join you at the first high-level ADR summit. On my own behalf and that of the board of ICAMECK, on which I serve, and Secretariat, I wish to thank the Judiciary and Ministry of Justice and Constitutional Affairs for inviting me to join you for this occasion. The International Center for Arbitration and Mediation in Kampala was launched on the 25th April 2019 as a complementary, independent, Arbitration and Mediation Center, offering alternative dispute resolution mechanisms for resolving commercial disputes. The center is empowered by a legal instrument signed by the Minister of Justice to appoint qualified arbitrators, mediators, and conciliators to resolve disputes, and has been doing this since September 2019. It gives us great pleasure to share with you, our friends, colleagues, participants at this conference, the achievements we have registered since our young fledgling institution was launched in 2019 towards the growth of ADR in Uganda. ICAMECK opened its doors for business in September 2019. Our mandate was to help in decongesting the courts and other adjudicative bodies. The center is steadily building its reputation for dispute resolution, and it has since registered 60 arbitration cases and published 47 arbitral awards. This, in our view, is a great vote of confidence by the users in the ICAMECK institution. By way of capacity building and training, as a mandate of the center to promote and maintain a standard of skilled alternative dispute resolution practitioners and to fill the ADR education gap in Uganda, the center offers an unrivaled training experience. The courses are intensive, structured so that participants can apply the strategies and techniques essential to achieving significant results in ADR. ICAMECK has conducted a total of 13 trainings. We have trained 246 participants in arbitration, mediation, and construction claims, as well as hosted webinars on the same. The attendance by professionals from different disciplines, arbitrators and mediators, has been significant and has demonstrated that there is need and an audience for the knowledge and skills being imparted. The center's trainings are all accredited by the Law Council of Uganda, and it hopes to partner with the judiciary to offer similar trainings in the future. By way of partnerships, ICAMECK has forged strategic partnerships with key players, and one of those key players we forged a strategic partnership with was the Chartered Institutes of Arbitrators Kenya branch, through which we submitted Uganda's application to create a chapter here. The Chartered Institute of Arbitrators UK approved the creation of the Uganda chapter, and it was launched by the Honorable Minister of Justice and Constitutional Affairs on the 23rd of September 2022. This development propels alternative dispute resolution in Uganda in a positive direction as accreditation becomes more easily accessible at a domestic level, making ADR a more attractive practice and growing Uganda's pool of arbitrators and mediators. ICAMECK has put in place a secretariat and established systems essential for the smooth running and operating of the center. The Secretariat assists parties in filing disputes, constitution of the arbitral tribunal, and the Secretariat also exercises quality control over the arbitral process, the mediation, and time in order to assess the extent and quality of service offered. The center notifies parties on final awards and monitors their enforcement. The center provides room for mediation and arbitration as well as other secretarial facilities, efficient and cost-effective. The rules are referred to when dealing with both domestic and international arbitration. And as I've said, these rules are based on the best international best practice. We also developed a practice note that encompasses a clear set of guidelines and principles that are benchmarked against industry best practices on efficient running of arbitration and mediation centers. This note currently guides the operations of the center to ensure the resolution of disputes within a consistent framework. We've also developed a code of conduct to govern the conduct of both arbitrators and mediators. The code is designed to serve as a fundamental ethical guideline for persons appointed to serve as either arbitrators or mediators. We also have a disciplinary committee which is in place to ensure the full implementation of the code of conduct. ICAMECK sent out a call for arbitrators and mediators on the 22nd of August 2019. We have a substantial list of both arbitrators and mediators who have been vetted and are now enrolled on the center's panel of arbitrators and mediators. Currently, the center maintains a comprehensive roster of arbitrators and mediators. And these arbitrators and mediators are drawn from different professions. And this, I think, is the hallmark of ICAMECK. We have, as part of our arbitrators and mediators, we have surveyors, accountants, lawyers, architects, and engineers. So it's a cross-disciplinary panel of arbitrators and mediators, which then enhances the understanding and the delivery of justice in the form of awards. We also launched a conciliation arm in October 2018. This conciliation arm was launched by the Honorable, the Chief Justice of Uganda, and we thank him for this notable development. And our conciliation arm is a mandated appointing authority under the instrument that Mrs. Sarah Arapta referred to, and we therefore invite the public to embrace this form of dispute resolution as well as both arbitration and mediation. Going forward, the ICAMECK's principal strategic goals for 2020-2023 include building a robust institutional capacity in pursuance of its mission, promotion of and enhancing the utilization of ADR services in Uganda and in the region, building a credible private sector-led best-in-class ADR center, and fourthly, building a sustainable center. As I close, I would like to take this opportunity to acknowledge and to thank various people attending this high-level summit today. First of all, we would like to thank the judiciary of Uganda. The judiciary of Uganda has been very accommodative. It has played a very constructive role in as far as ensuring this fledgling institution is able to take root and to be able to grow. We would also like to thank the Uganda Bankers Association for working with us on this long journey. In the person of Mr. Wilbur Ward, who is with us this morning, it has been a very tenuous journey, but they've walked the distance with us. We would like to thank the Bank of Uganda, who also have been very supportive of this institution. We would like to thank the Ministry of Justice of Uganda, ably represented by the Honorable Minister this morning. We would also like to thank the Uganda Law Society, various private sector firms who have contributed financially, morally, and with their time to ensure that this complementary, as I said in my opening remarks, this is an independent complementary center to other institutions that have been set up in our country. I thank you all very much for listening to my remarks on behalf of Mr. John Fisher. Thank you very much.
Thank you very much, Mr. Adrico Moses, SC, on behalf of John Fisher. Now I know better. The next time I invite anybody, I would say, oh, his or her representative. so that I will be safer today. Thank you very much once again, Adrico. And in case you don't mind, please let's once again appreciate him with a round of applause. At this moment, we would like to have somebody speak to us who is online right now. This is Madame Barbara Clay, the country manager of the International Development Law Organization, IDLO. IDLO believes in creating a culture of justice. And IDLO has been supporting the judiciary and the government of Uganda in many different initiatives. In fact, IDLO has been funding the national ADR policy that's been put in place, the development of the judiciary alternative justice policy, and a number of other initiatives by the government of Uganda and the judiciary, to be specific. So I'm going to request the people in the control room to kindly allow us have Barbara Clay online to speak to us right now. Barbara, you're very welcome.
Thank you very much and for your kind introduction. Indeed, today is an auspicious day, and I am grateful to see all of you in attendance and those of you joining in online as myself. To the Chief Justice, allow me to adopt the protocol already laid down by the Chief Registrar of the Judiciary, and in doing so, allow me to proceed directly into my remarks. As indicated, IDLO is the only global intergovernmental organization that is exclusively devoted to promoting the rule of law, to advance peace and sustainable development. IDLO works to enable governments and empower people to reform laws and strengthen institutions to promote peace, justice, sustainable development, and provide economic opportunities. Through the financial support from the Embassy of Sweden in Uganda, IDLO is implementing a community justice program which seeks to enhance the accessibility, quality, and sustainability of justice services delivered for the rural, vulnerable, and marginalized communities in Uganda. So to do this, we do work with the state and non-state institutions to empower grassroots communities to claim and uphold their rights, while at the same time strengthening capacities of and linkages between formal and informal actors and systems to support the effective redress mechanisms for justice seekers. So why is IDLO here with you today? IDLO is here because we believe in alternative justice systems and alternative dispute resolution mechanisms. Because alternative justice systems are the comprehensive, organic, non-state mechanisms of laws, norms, customs, and social and legal systems that govern and regulate a people's livelihood and their way of life. The pursuit of such systems, being primarily restoration, is critical to enhancing and deepening access to justice. So why support IJS again? Now, one of the core principles laid down in Article 126 of the Ugandan Constitution is to guide the administration of justice and the exercise of judicial authority, and the requirement to embrace, promote, and incorporate cultural and customary values which are consistent with the fundamental rights and freedoms, human dignity, and democracy as espoused in the constitutions, which are all emboldened in different AJS mechanisms. This constitutional requirement is the foundational basis of the community-based approach to the idea and concept of justice. Ugandan communities have for generations developed their own justice systems that have continued and continue to hold societies together. Now, while justice dispensed by the court has occupied the center stage in the administration of justice, the reality is that the vast majority of disputes are resolved by the people through their community-based processes, begging the question of whether they are truly alternatives to the main formal justice system, or is it that the actual formal justice system is an alternative to the community-based systems. I would remind us to look at the 2020 Hills Justice Needs Survey report for Uganda, which states that there are 12.8 on average million legal problems in Uganda each year. Now, many of these problems are resolved, but most remain unresolved. And for most, sometimes the resolution is found to be unfair. Now, each year in Uganda, 4.7 million legal problems are abandoned without fair resolution, according to the Hill report. 1.9 million disputes are ongoing, and 2.13 million are considered to be resolved unfairly. Now, this is a significant justice gap. But just to expound on that, just to note that only 4% of such disputes actually do get before the court. What does this mean, therefore? That it behooves the judiciary to communicate or to collaborate and to coordinate with the different justice systems that exist outside of the judiciary. And justice for women and other marginalized populations who experience systemic exclusions in such systems are compelled to have a constructive engagement with legal pluralisms to realize access to justice for all. This belongs as a mandate for the judiciary. AJS systems offer low-cost opportunities to generate a commitment to the rule of law and improving the capacity of those systems to operate inclusively, accountably, and in complementarity with the formal state-based justice system. This is likely to advance the rule of law and enhance inclusive development broadly. Additionally, AJS systems offer low-cost opportunities to enhance respect for human rights while addressing the needs of justice seekers, including a preference for restorative rather than retributive justice options. It is in the recognition of the above and the provision of Article 127 of the Constitution of Uganda that IDLO lauds the judiciary, the Minister for Justice and Constitutional Affairs, for recognizing the role of these justice systems that exist in parallel to the judiciary, as well as the different dispute resolution mechanisms as tools for deepening access to justice and critical potential for the provision of the full spectrum of access to justice services, while ensuring that there are safeguards that will recognize the right of individuals who do seek redress. IDLO considers the judiciary strategy on alternative justice systems as a significant framework for the recognition and enforcement of the outcomes of AJS processes that are in conformity with the Constitution. Accordingly, IDLO also recognizes that the ministry's draft policy on ADR as a significant framework for providing an enabling environment for the recognition of and the enforcement of ADR outcomes. This does provide a true foundation for the involvement of the people in the delivery of justice. In changing the landscape for the delivery of justice, we believe that the AJS strategy and the ADR policies will provide an opportunity for not just the judiciary, but for the people to take hold and to provide reconciliatory and people-centered justice. That the policy and the strategy will direct production and promotion and dissemination of information on the different ADR and AJS mandates. That the two will also guide the adoption of principles of natural justice and encapsulate human rights-based approaches in the delivery of justice through such mechanisms prior to their recognition by the courts. We also believe that they will facilitate the appropriate cooperation, linkage between the courts and the ADR and AJS mechanisms to enable referral of cases between them and improve the reconciliatory approach of justice. Further, we note that these two documents will provide the framework for the capacity development of the people and the judicial officers and the practitioners on appropriate applications of the agency principle on the jurisdiction of ADR and AJS and the operational doctrines of that interaction. We hope to see, as IDLO, a curriculum and guidelines for training of practitioners on AJS, on ADR, and not only the practitioners, but also the public and the judicial officers on the application of AJS and ADR. We also hope to support in the construction of an independent audit mechanism that will enable the review of existing legislation and judiciary guidelines to ensure coherent implementation of both the ADR and the AJS strategies. Finally, given the legitimacy accorded to AJS systems in the communities, I call on all justice sector actors present to capitalize on the public legitimacy of these systems and to integrate them into their broader efforts to achieve justice for all, consonant with SDG 16. I thank you all for listening to me. I congratulate the judiciary led by the Honorable Chief Justice on the development of the strategy and the Minister for Justice and Constitutional Affairs on the publication of the policy. I hereby reiterate IDLO's commitment towards working with both the ministry and the judiciary and other justice sector actors to deliver people-centered justice approaches while promoting the rule of law. And I hereby wish everyone present an objective and successful ADR Summit. Thank you for listening to me, and back to you, Mr. Moderator.
Barbara?
Yes?
Sorry, we are having a technical glitch here. Currently, just hold on. Kindly just hold on, please. We missed the other parts that you ended with. Shall get back to you. Is that fine?
Okay.
Okay.
Thank you.
All right, Barbara, we were having a very involuntary commercial break, but right now you're welcome back to continue with your remarks.
I'm not too sure where I dropped off from. Maybe you could guide me. But all in all, I do wish to thank the Minister for Justice and Constitutional Affairs, and I wish to thank the Chief Justice and the ADR Strategy Committee that worked together with the IDLO team to come up with the drafts. And I do wish us all an objective ADR summit, and I restate IDLO's commitment to support the process to its finality. Thank you all, and I wish you the best.
Thank you very much, Barbara, for those important remarks. We appreciate your time, your wisdom, and all that you have shared. If you don't mind, ladies and gentlemen, let's appreciate her once again. And at this moment, I would like to give us the good news that we are transitioning to the keynote address of the morning. Our keynote speaker is the Professor Jim Gash, who happens to be the 8th president and the CEO of Pepperdine University since 1st of August 2019. And you must be already seeing that Pepperdine University is featuring quite prominently in this National ADR Summit. He is the first alumnus to lead Pepperdine as president. He has served the university in a professional capacity since 1999. Professor Gash, prior to assuming the presidency, was the Associate Dean for Strategic Planning and External Relations at the Pepperdine Caruso School of Law, where he provided operational oversight for many signature development initiatives. As a 20-year Caruso Law professor, his primary areas of focus included evidence, torts, and international human rights. Recognized globally for his transformative work in international justice reform, Professor Gash has devoted himself to advancing the rule of law in developing countries, and since 2010, he has visited Uganda nearly 30 times with Pepperdine students and alumni. You better clap better so that he he wants to come back 30 more times. He has come back to Uganda many times, more than 30 times, with Pepperdine students and the alumni to support the judiciary of Uganda, having served as the special advisor to the High Court of Uganda since 2012. And in 2016, Professor Gash published his first book called Divine Collision, An African Boy, an American Lawyer, and Their Remarkable Battle for Freedom. What a title. This book chronicles how his life and the Ugandan criminal justice system were dramatically changed as a result of meeting a Ugandan teenage prisoner during his first visit to Uganda. The following year, Revolution Pictures released the award-winning documentary titled Remand about the work of Sadru Global Justice Program at Pepperdine Law, which our keynote speaker this morning, Professor Gash, led as its director from 2012 to 2019. And upon graduating from Caruso Law in 1993, Professor Gash worked for the litigation firm DeSimon and Tropio and clerked for the Honorable Edith H. Jones, the United States Court of Appeals for the Fifth Circuit in Houston, Texas. In recognition of his ongoing efforts abroad, Professor Gash received the 2013 Warren Christopher Award, which annually recognizes the State Bar of California's International Law of the Year. And he's here today to give us the keynote speech in this first ever National Alternative Dispute Resolution Summit 2023. Please make him feel at home in Uganda once again.
Good morning. Mr. Deputy Chief Justice, I adopt all protocols that have been observed previously, and thank you, Chief Registrar, for saving me of that burden. I would like to thank the Honorable the Chief Justice and the Honorable Minister of Constitutional Affairs, Minister of Justice and Constitutional Affairs, for organizing this important and groundbreaking conference. It is my great honor to be invited here this morning to share a few thoughts about your ambitious vision for Uganda taking a leadership role in ADR across Africa. A vision that I believe is achievable through the wisdom that is gathered here in this room. As was noted, Uganda has been my second home for this past decade, and it holds a special place in my heart. In 2012, my family and I moved here for 6 months. I love the culture and I love the landscape of this country, but more than anything, I love the people of Uganda. The judiciary and its leadership have become some of my dearest and closest friends in the world. As we have collaborated to help reduce the case backlog and overcrowding in prisons through the implementation of plea bargaining in nearly every prison in this country. In fact, at this very moment, the judiciary, in partnership with the Directorate of Public Prosecution and a team from Pepperdine, are collaborating on 2 plea bargaining camps in Mbarara and Bushenyi, where several hundred remandees will be receiving access to justice this week. The leadership, the foresight, the determination, and the perseverance shown by the prior Chief Justices, the prior DPPs, of course, and the current DPPs and Chief Justices as well, the Deputy Chief Justices, the principal judges, together with many, many of you, High Court judges, Court of Appeals judges, and Supreme Court justices, along with the Chief Registrars and Technical Advisors, have made plea bargaining in Uganda a phenomenal success. I see so many friends here today who have made the growth and success of the judiciary in the Republic of Uganda their life's work. Let me add my special thanks to my dear friend, Justice Bart Kecherebe, for delivering an address at my inauguration at Pepperdine University in 2019. Thank you, my Lord. But don't take my word for the fact that Uganda is leading ADR across Africa. The evidence is compelling, which is why I believe Uganda's desire to take its place as the leader in ADR across this country is achievable, across this continent is achievable. Other African countries have seen the fruits of Pepperdine's partnership with Uganda. First, Ghana called and asked them to help implement what Uganda has done in plea bargaining to enhance access to justice and to reduce case backlog and prison congestion. Next, Rwanda called and asked the same, and they have already begun implementing plea bargaining, following in your footsteps. Then Nigeria and Liberia have called, and those processes are just beginning. As you can see, Uganda's pioneering spirit and leadership are having an impact across the continent already in dispute resolution in the criminal justice realm. Relatedly, over the past decade, Pepperdine has assigned fellows to serve as mediators in the commercial court and in the family division. And I want to reiterate our commitment to continue working with you to realize a robust ADR regime. In addition, we have collaborated over the years to host other groundbreaking conferences, including 2 conferences on women and leadership with Chief Justice Kachirebe and the Christian Lawyers Conference with the First Lady Janet Museveni and Chief Justice Owini-Dolo, who was DCJ at that time. I would be remiss, of course, not to mention the profound and inspirational leadership of our dear, dear friend and colleague, the late Supreme Court Justice Stella Arach-Amoko. Our relationship with Lady Justice Stella goes back to 2006, and she was a force of transformative leadership in her various roles. And she did so with such joy and sweetness. We are missing our dear friend. May her soul rest in peace. The present global conflict has awakened the world to the truths Africa has known and has practiced for centuries. The fundamental importance of unity, of community, and of peace. And the world would be better for learning from the rich history of dispute resolution in Uganda. The ADR we are talking about today is merely a modern expression within the formal justice system of the timeless and effective truths that heal human nature and restore harmonious relationships. And as Providence would have it, Pepperdine is the home of the Strauss Institute for Dispute Resolution, which just so happens to be the #1 ranked dispute resolution training institute in the United States for the last 20 years. And we offer our continued partnership with you on this worthy initiative. Over the past decade, we have had numerous delegations of Ugandan leaders travel to the United States to visit Pepperdine for civil and criminal ADR training in contemplation of this initiative. As you may know, Pepperdine's campus is located in beautiful Malibu, California. But we also have campuses in London, in Heidelberg, in Florence, in Buenos Aires, in Washington, D.C. And we will be opening campuses soon in Japan and, God willing, in Jinja. Next week, we officially expand our global influence when we open our new 67-acre campus in Vevey, Switzerland, overlooking Lake Geneva, called the Chateau d'Hauteville. As CJ Owini-Dolo will be referencing in his talk, Pepperdine has agreed with excitement and delight to co-host with Uganda the countries of Africa for a Pan-Africa ADR Summit in Switzerland next year at this campus. It is a great honor for me and Vice President DeWalt, along with distinguished professors Jack Coe and Selena Schultz from our Strauss Institute, to be with you here today, participating in the Dispute Resolution Summit. The summit's theme, the role of ADR in transforming Uganda's dispute resolution landscape, speaks to the pressing need to address institutional, attitudinal, and policy constraints that have unfortunately impeded Uganda's goal of having substantially more parties or institutions choose Uganda as a seat for commercial arbitrations. Refinement in Uganda's arbitration laws can aid in becoming an effective ADR destination. The principal law governing arbitration and conciliation in Uganda, of course, is the Arbitration and Conciliation Act of Uganda. While I am confessedly not an expert in this act, Section 6 seems to allow a party to arbitration agreements to apply to the court before or during arbitral proceedings for an interim measure of protection, and a court may grant that measure. Additionally, the Civil Procedure Act and the rules contained therein bestow upon the court inherent discretionary powers to entertain any matter in the exercise of its inherent discretion or jurisdiction. Such provisions, of course, create substantial risks of abuse of arbitration by parties who seek to undermine the arbitration. It almost goes without saying that in order for parties to be willing to enter into international commercial arbitration agreements, arbitral independence is both assumed and imperative. And yet these wide inherent discretionary powers could threaten to undermine Uganda's attractiveness as an arbitral seat due to the readily apparent risks of potential court interference. Another important challenge is the ACA's lack of immunity for arbitrators from individual suits. This failure to insulate arbitrators from personal liability threatens to undermine the arbitrator's neutrality and the party's interests in finality. For these reasons, these rules are different than other jurisdictions. For example, in the United States, the Uniform Arbitration Act provides that an arbitrator or an arbitration organization acting in that capacity is immune from civil liability to the same extent as a judge of a court acting in a judicial capacity. The absence of such a provision disincentivizes arbitrators from serving in Uganda and signals that Uganda may be out of step with much of the rest of the world on that particular score. Likewise, international commercial arbitration practice can thrive in Uganda if, and only if, constraints on foreign counsel are removed. Again, the laws of other jurisdictions are instructive. For example, under the laws of the United Nations, England, Germany, Sweden, and the United States, there are no restrictions on who may act as a party representative in an arbitration. In contrast, the Ugandan Act does not explicitly provide for this. One of the leading characteristics of popular seats of arbitrations are clear, relaxed rules of who can appear and represent parties in arbitrations. At the same time, it is imperative that those who practice international commercial arbitration are well trained. Consequently, it's critical that Ugandan ADR practitioners, Ugandan students taking the bar, and students in Ugandan law schools undertake continuous training in this area to enable them both to grasp the concepts of ADR and to be able to be accredited both domestically and internationally. In order for Uganda to take its place as an ADR leader on this continent, it is also crucial for this country to develop a national ADR policy that will give important direction both on matters concerning ADR in general and on the appointment and accreditation of ADR practitioners in particular. Doing so would bring Uganda in line with most other countries who set criteria and qualifications for arbitrators at a high standard. Uganda needs to have a fully equipped arbitration bar in order to be competitive with other potential arbitral seats. I'm pleased to be present today when this policy is being widely introduced, and I'm confident that it will pave the way for making Uganda an attractive ADR location. An important part of this effort will be the establishment in Uganda of an arbitration registry, perhaps in coordination with ICAMECK, that clearly meets international standards, where parties and arbitrators can file documents and receive important information and training about international arbitration rules and standards. Another important factor in improving Uganda's attractiveness as an ADR hotspot for this continent will be infrastructure. While this includes roads, it also includes continuing to upgrade the information superhighway, the internet. We were just reminded that sometimes it's not always as reliable as it could be. Those who come to Uganda to resolve complicated, high-value disputes will be looking for efficiency in both transportation and in communication. This is not to say that substantial improvements have not been made. The airport bypass was a game changer in getting to and from Entebbe. Additionally, access to high-speed internet has vastly improved over the past decade. Let me humbly encourage you to continue these important advancements to increase your attractiveness as an arbitration seat. Another important feature is alignment with international standards. For example, Singapore is one of the countries known to have a highly rated ADR system. This is because the government has aligned its laws with international standards. Uganda should continue to endeavor to do likewise. This can be done through ratification and domestication of international treaties and conventions. For example, Uganda can ratify the Singapore Convention on Mediation, which would readily allow for global enforcement of mediated agreements reached in Uganda. Another possibility would be for Uganda to consider using its tax policy and flexible investment laws to promote the establishment of robust arbitral institutions that would aid in transforming the country into a regional hub for settling disputes. The Honorable Minister of Justice and Constitutional Affairs has previously stated, and I hope he will repeat that here, that we ought to seek to partner with international arbitration institutions in growing mediation and arbitration in Uganda. For instance, the London Court of International Arbitration, LCIA, entered into an agreement with the country of Mauritius, which has greatly enhanced the reputation of Mauritius as an arbitration seat. In a bid to realize these proposals, Pepperdine University, at the request of the Honorable the Chief Justice of Uganda, customized a Master's in Dispute Resolution program for 11 senior government officials led by the Chief Justice himself. At my direction, the university extended a scholarship of 80% to enable these high-level students to undertake the course. Let me take this opportunity to thank the Honorable the Chief Justice for the wisdom and leadership that he has given. And indeed, the fruits of this Masters in Dispute Resolution are reflected by the fact that this summit today was organized by that cohort of 11. Likewise, this cohort drafted the alternative justice strategy for the judiciary and drafted a national ADR policy that addresses many of the issues that we will be examining in great detail over these next 2 days. I commend them for their leadership and sacrifice to pave the way for this conference and vision. Please also allow me to commend the leader to make this happen, Pepperdine Vice President Danny DeWalt, Professors Jack Coe and Selena Schultz, and the technical advisor to the judiciary and Pepperdine professor, Andrew Hauha. Let me close my remarks by reiterating Pepperdine's commitment to working together with you to support you to advance these great initiatives. God bless you, and for God and our country.
Thank you very much, our keynote speaker this wonderful morning. I strongly believe that he deserves a better round of applause, ladies and gentlemen. In the next couple of minutes, we will be taking a health break. But before we do that, I would like to welcome our CR, our Chief Registrar.
With the Chief Justice, who is online, but again, we can appreciate him for being with us online. We already saw the Honorable Justice Mike Chibita. My Lord, it is good to have you, together with the Honorable Lady Justice Elizabeth Musoke, who are here from the Supreme Court. My Lords, you're most welcome. Refired from the Supreme Court is the Honorable Justice Eldad Mwangusha, and the Honorable, actually he's the one who gave me that book, and now it is refired and not retired. We also have the Honorable Justice Paul Mugamba. My Lord, you're most welcome. We have their lordships from the Court of Appeal, and there are 9 of them. My lords, allow me in the interest of time not to go through the names, but their lordships from the Court of Appeal, you are all most welcome. We have judges from the High Court, quite a number of them. My lords, you're most welcome as well, both from the divisions and the circuits. Thank you so much for coming. Let us appreciate them. But in a special way, allow me to introduce retired Honorable Justice David Wangutusi. My lord, you are very, very most welcome. We have with us Ambassador, His Excellency Matthias of the German Embassy. Very, very good to see you. You are most welcome with us. We have heads of other tribunals, and we have Francis Gimara, PPDA. You are most welcome. Mr. Gimara is also a senior counsel. We have senior counsel Ruth Sebatindira, who is also a member of the Judicial Service Commission. We have the, from Law Reform Commission, we have Dr. Pamela Tibihikira, you're welcome. And from the State House Anti-Corruption Unit, we have Brigadier General Henry Isoke. You're most welcome, Brigadier, here with us. We have the Director of Public Prosecutions, the Honorable Lady Justice Jane Francis Abodo. My Lord, you're welcome. From the Law Society, we have President Bernard Oundo. President, Law Society, you're welcome. The Solicitor General is with us, Mr. Francis Atoke. You're most welcome. We also have the Administrator General, Charles Kasibayo. You're welcome. We have the Permanent Secretary of the Ministry of Justice, Mr. Robert Kasande, is also here with us. Civil Society representing LASPNet, we have Dr. Sylvia Namubiru. You're welcome. We have Mr. Frank Othembi, the Director of the Law Development Center. You're most welcome. We have Professor Ronald Naluwairo, the Principal of the School of Law, Makerere University. We also have Professor Amolade Olomola from the Cavendish University. He's the Dean. You're welcome. Representing different development partners, we have a team from IDLO here. We have Mr. Samson Asimwe and Miss Caroline Shemeri. You're very most welcome, our dear partners from IDLO. We also have our partners from UNICEF, where we have Irina Chom Oluka. You're most welcome. From the Austrian Embassy, we have Dr. Katia. Dr. Katia has been with the judiciary for a long time. Thank you. And from UNDP, we have Martha Agaba. You are most welcome again. We have registrars of the courts of judicature. Your worships, for you can stand at the back there. Let us see you. You're welcome. Your worships, let us see you. They are there. We have different senior counsel. We may not have all of you with their names, but I request all the senior counsel in the house to please stand. Senior Counsel Fiona, I see you there. Senior Counsel Sebatindira, seen you. Yes, Senior Counsel Adrico, you're all most welcome. All the advocates in the house, may you please stand up for recognition. Advocates, we have, thank you so much for coming. And let me request President Gash mentioned them, but the team from Pepperdine to stand up for recognition. You have already seen the president, but we have the vice president, Professor Dan DeWalt. Please stand up for recognition. Thank you so much. Professor Jack as well. Yes, you're most welcome. Professor Selina, we are happy to have you. And of course, our own Andrew Kauka. Get out of the corner and stand here where we can see you. So thank you, and thank you very much. We will come back certainly with another round of introductions. But I'm happy we are within our time and we are doing very well. Group photos and break tea. Sam, come and take us to the next level. Thank you.
we were just making a quick consultation. We realized we forgot to introduce one more person, and I would like to take the pleasure to introduce the person. And that's somebody seated next to you whose name was not mentioned. Turn to them and say, you are also here and you are welcome. You are also here, my neighbor, and you are very welcome. You are important, you're worthy. It's good to have you in the house. All right. So at this moment, we are going to take a break, a health break, for about 30 minutes. It is a coffee tea break. And we will have a cup of tea, a cup of coffee just outside the room, on my right where I'm pointing right now. And we would like you to relax, chill, take the tea, take the coffee, stretch a bit. It's really important that your blood is able to flow through your body before you come back to sit for another 30 or more minutes. And then after that, after the 30 minutes of break, we will be coming back to have a panel discussion. We will have a panel discussion on the keynote address. And it will be moderated by Ms. Rachel Odoi-Musoke, the Senior Technical Advisor, Governance and Security Program. And therefore, at this moment, I would like the team that is going to be on the panel to kindly stay back for just about 3 or 4 minutes to put some things together in preparation for the panel time. And that's none other than Honorable Justice Geoffrey Chiriabwire, the Justice of the Court of Appeal, Ms. Anne Juko, the CEO of Stanbic Bank, Ms. Judy Rugasirachanda, the MD of Knight Frank, and Mr. Moses Adrico, Senior Counsel, the partner at Max Advocates. Let me request you, together with Ms. Rachel Odoi-Musoke, to stay back just around here for very few minutes as we go for break. Ladies and gentlemen, enjoy your break and come back 30 minutes after now. Thank you. Panel. Ms. Rachel Odoi-Musoke, kindly come to the front and together with the panel you're going to be leading and agree on a few things.
Recording stopped.
Možda ja će Bože
В Алане работает союз рейдеров, морды в пол и слушаем указания.
Военсовет нас в бой зовет, ведь от тайги до британских морей Красная армия всех сильней, уже красная.
The first time that I saw you, I must admit I was mesmerized.
Africans, shut up, shut up, Africans.
People everywhere. More people everywhere. Can't see like that.
Ты так же симпатична.
Was just like
Shruti band.
It's like
Africans, you guys
Ты рукой помахал, помогал в ответ, ты пошел ко мне навстречу. Это было так глупо, ведь за спиной моей стояла моя подруга.
the sound of your voice in the night. The sound of your voice in the night.
Dan Kalora.
The sound of your voice in the night. Such a sweet serenade. A sweet serenade. Sweet serenade.
Yeah.
Я должен просто защитить всех людей. Я думаю, наша безопасность и детей. Но я не могу предотвратить гибель людей на земле. Но это надо объяснять. Уничтожение мира, что надо допустить, что самолет садить. Абсолютно лучше. Абсолютно.
Закрываю двери, чаю все любила, недоступен для любимых, потому что я влюбилась в тебя. Такого найдется его же. Я увидела пускай собственными ты рукой помахала.
Чел хорош.
Dear delegates, we request that we could roll back and then embark on the program. We request that we come back and settle and get back on the program.
Recording in progress.
Ladies and gentlemen, welcome back. I would like to request everybody who is still outside the room to kindly find their way inside the room, and we continue with this National ADR Summit 2023. In case you have somebody standing or seated next to you who is still enjoying the conversation, feel free to tap on them or tap on him or her and let them know that it's time for us to take the next step on this important summit. If you're happy and you know, clap your hands. If you're happy and you know, clap your hands. If you're happy and you know and you really want to show. If you're happy and you know, clap your hands. If you're happy and you know, clap your hands. If you're happy and you know, clap your hands. If you're happy and you know and you really want to show. If you're happy and you know, say I am. Yeah, sometimes that's what it takes for us to be back into the session. And I would like to welcome all of you, ladies and gentlemen. Once again, turn to your neighbor and say, you are lucky to be seated next to me in this summit. Because you don't know who you're seated next to. You don't know who you're seated next to and when you will need them. So I welcome you once again to the National Alternative Dispute Resolution Summit 2023. And we are going on with our program today, and right now we are going to the panel discussion on the keynote address. Professor Gash has already given us the keynote address that tackled many salient issues, many critical areas of focus, challenges, opportunities, things we need to pay attention to as the judiciary of Uganda concerning the alternative dispute resolution system. And so now we are getting into a panel that is going to be looking at the keynote address and the different issues that were raised, and then they have a discussion around it, making sense of different things, sharing their own opinions, their own expertise and experience on the critical issues or the matters that were arising out of the keynote address. So without further ado, I would like to right now welcome Ms. Rachel Odoi Musoke, the Senior Technical Advisor, Governance and Security Program, who is going to be the moderator of the panel. Kindly welcome her, please, as she takes her place. You used to be more generous than that. I don't know what later happened, especially after a cup of tea. You're very welcome, Rachel. And we have the following panelists that are going to be having a conversation with Rachel. Please put your hands together and welcome Honorable Justice Geoffrey Chiriagwire, the Justice of the Court of Appeal. Honorable Justice, you're welcome. And also to be with us on the panel is Ms. Anne Juko, the Chief Executive Officer of Stanbic Bank Uganda Limited, My Bankers. Well, let's clap and look forward to Anne. I think I should do what I did previously a few minutes ago. Anne or her representative. Yeah. So let's welcome the representative from Stanbic Bank, Uganda. You see, that makes me safer. Also, to join the panel, this awesome moment, is Miss Judy Rugasira Chanda, the Managing Director of Knight Frank. Please put your hands together and welcome Judy, an awesome, intelligent lady at the helm of real estate management under Knight Frank. Judy, you're welcome. And finally, I would like us to put our hands together and welcome SC, Senior Counsel Moses Adrico, the partner at Max Advocates, right here to join the panel. Welcome, SC. So, ladies and gentlemen, we have the panel here with us, a concentration of expertise, undiluted experience, great wisdom in the house. I'm going to right now hand over to Ms. Rachel Odoyi Musoke, the Senior Technical Advisor, Governance and Security Program, to lead the conversation of the panel. Once again, receive them, please, with a hand clap. Rachel.
Thank you very much, RMC. Allow me, in the interest of time, to adopt the protocol as ably laid out by Her Worship the Chief Registrar, and to welcome all of you to this session this morning, just before the afternoon. I have with me a very illustrious panel who are going to help us to assess and understand a little bit better the keynote address and to share their perspectives and their expertise on the question of ADR. Allow me to introduce them to you before we begin the session. On my immediate right, I have with me the Honorable Justice Geoffrey Kiriawire. Justice Kiriawire is a Justice of the Court of Appeal of Uganda. He has been serving in that position since 2013, and he previously served as a judge of the Commercial Division of the High Court of Uganda as the head of the division from 2003 to 2013. He has also served as the Vice President and Justice of the Appellate Division of the East African Court of Justice. And before his judicial appointments, the Honorable Justice Kiriawire served as a legal assistant to the Minister of Justice and Attorney General of Uganda. He has served as a Senior State Attorney for Civil Litigation in the Office of the Solicitor General. He also served as Company Secretary and Legal Counsel at Panworld Insurance Company and as Acting General Manager and Chief Executive of the same institution. During his legal career, he has participated in 4 national commissions of inquiry, including into the failure of banks in the late 1990s, the purchase of junk helicopters by the UPDF in the 1990s. He was a secretary to the Porter Commission of Inquiry into the mismanagement of criminal cases and secretary to the Commission of Inquiry into allegations of corruption in Uganda Revenue Authority. Justice Kiriawire holds a Bachelor of Laws degree from Makerere University, a postgraduate diploma in legal practice from the Law Development Center, and was called to the bar in 1987. He also holds a Master of Laws in International Law with a bias in International Economic Law. He holds a certificate in Alternative Dispute Resolution from the Strauss Institute of Dispute Resolution of Pepperdine University, and he's also currently pursuing a Master's in Dispute Resolution from the same university. His Lordship is a Fellow of the Chartered Institute of Arbitrators, London. Please join me in welcoming Justice Kiriawire. On my immediate left, it's not Anjuko, just for those who may be confused. I have with me Mr. Wilbrod Humphreys Owor. Mr. Owor is the Executive Director of the Uganda Bankers Association. He holds an MBA in Strategic Management from Esami Maastricht School of Management and a degree in a Bachelor of Commerce from Makerere University. He has been in the banking sector, rising to the rank of Managing Director and Chief Executive Officer, and he has over 25 years of experience spanning across key sectors of the economy, including manufacturing, trade, commerce, international development agencies, and the NGO world, as well as consulting and advisory services. He has business development and management experience in financial and consumer services institutions, with practical experience in financial management, business development, skills development, and banking, financial products and services. He sits on several boards in the areas of FMCG, I'm sure he will explain a little bit about what that is, and deposit insurance, investment advisory, and financial services training, among others. Please join me in welcoming Mr. Wilbrod Owor. On my far left is Ms. Judy Rugasira Chanda. She's the Managing Director of Knight Frank, a United Kingdom-based real estate firm in Uganda. She has served as the Vice President of the Association of Real Estate Agents of Uganda from 2012 to 2014, and as Director of the Africa Real Estate Society. She's an honorary member of Enterprise Group Uganda. She's a member of the Royal Institution of Chartered Surveyors, which demonstrates qualification and work experience to the highest industry standards. Ms. Rugasira Chanda holds a Bachelor of Science degree in Land Management and a Master of Science degree in International Real Estate from the University of Reading. Please welcome Ms. Judy Rugasira Chanda. And on my far right is Senior Counsel Moses Adriko. He's a partner at Max and co-head of the firm's litigation team. His legal practice focuses mainly on corporate and commercial law, civil litigation, intellectual property, and international criminal law. He's the current chairman of Sanlam General Insurance Limited, as well as chairman of Standard Chartered Bank Provident Fund. He is a certified adjudicator accredited by the Kuala Lumpur Regional Center for Arbitration and has served on the IBA Human Rights Institute as a council member. Previously, Mr. Adriko served as the president of the Uganda Law Society and chaired the African Forum of the International Bar Association. Mr. Adriko has served as a member of the Public Procurement and Disposal of Public Assets Appeals Tribunal and the Transitional Justice Issues Committee of the Government of Uganda. He also served as a non-executive director of Standard Chartered Bank, Uganda Limited. Mr. Adriko is a solicitor of the Supreme Court of England and Wales. He holds a Bachelor of Laws degree from the University of East Anglia and a diploma in legal practice from the Law Development Center. Please welcome Senior Counsel Adriko. I think you will agree with me that the panel we have here are the best people to help us to understand a little bit more about how ADR can work and can function within our society. I'll go straight into the discussion, and I'll invite each of you in just a few minutes to just give me some insights and thoughts on, one, whether you feel ADR actually has a place in our justice system, and what do you think we can do from your industry perspective and your expertise? What can we do to make Uganda a more attractive destination for alternative dispute resolution? And I'll start by inviting my Lord Justice Kiryabwire to share with us his thoughts on that particular issue. My Lord.
Thank you very much, Rachel. A very good morning to everybody here, all protocol observed. I'd like to start by thanking President Jim Gash for his very insightful paper on how ADR can transform Uganda. And I'd like to agree with you, sir, that ADR can be one of those things in a toolbox that can transform this country. In order to understand that, you need to understand, and I want to take a perspective from the courts. You need to understand the 121 years that our court system has been in Uganda since it was instituted in 1902 in the Order of Council, and therefore see what has happened over these 121 years. And of course, we remember very clearly that the present court system as we know it replaced a traditional justice system that was in existence before. That traditional justice system really, in resolving disputes, emphasized community, wellness, harmony, restitution, a win-win strategy, and really was an opportunity for people to discuss how to resolve a dispute and get out something that was more of a win-win. It was quite speedy and seemed to resonate very well with the population. On the other hand, 1902 brought in the system of adjudication, which was based on litigation. A very different model. It was largely you either win or they lose, or alternatively win-lose with the various layers of appeal. And new players came in new players came into the fold, we had the advent of judges like me. We had the advent of attorneys like many of you. And this brought a different flavor to dispute resolution. And this is important because the power of dispute resolution largely moved from those who are in dispute to those who are part of this new system, the lawyers, the judges. And over time, we saw that even though this new system had some sprinkling of alternative dispute resolution, for example, our Arbitration Act, the first one came in 1930, it was very, very limited. And therefore, over time, this system, which didn't fit very well within our society, led to a situation where, okay, we have what we now have as case backlog. The workload went up because the players became fewer. Those in dispute resolution were fewer. And therefore, it was not an easy thing to dispose of. And I think the change came in around 1995. 1995 is when we had the Platt Commission of Inquiry into Judicial Reform. And it is that Platt inquiry that said, look, we must consider the use of what? Alternative dispute resolution. And after that, the Commercial Court came in 96. And the very important hallmark of changes in the civil procedure rules, and I'm starting with the civil area, came with the amendment of our civil procedure rules to introduce what was then referred to as Order 10B, which eventually became Order 12. And so for me, I'd like to benchmark what is happening in Uganda from about 1998, when we had Order 10B put in our system, because it specifically provided for the first time an order dealing specifically with alternative dispute resolution. So what has been happening over the last 25 years is very important. And I think we have had a lot of progression in terms of creating a legislative framework. We created a legislative framework. We know that the Arbitration and Conciliation Act came in 2000, which is Cap 4 of the laws of Uganda. And prior to that, I also like to agree with President Jim that if you have alternative dispute resolution, it is very important for you to have it in the context of investment. And if you remember the Investment Code Act of 2004, later on 2019, in Section 25, specifically provided that investment disputes should be settled by way of alternative dispute resolution. And therefore, we have created the legal framework for doing that. And of course, around 1995, we have the Constitution also coming in under Article 126(2) and saying, look, if you're going to deal with disputes, you must deal with them very quickly, you must have reconciliation, and you must reduce the emphasis on technicalities. So you can see these frameworks are starting to come into place. Now, the Commercial Court started the area of mediation, starting with the rules of 2003, running through to the rules of 2013. Now, it is important to highlight that these rules were revolutionary, because for the first time, these rules allowed a settlement agreement that arose out of a mediation to be endorsed by the court as a consent judgment. This was a very important development in assisting in terms of enforcement. So our mediations, at least those that are court annexed, It is possible because President Jim was raising the issue of enforcement. But for us, we had that ability to do so. And in that, we were pioneers. And again, I want to agree with President Jim that we in Uganda have been pioneers in creating this system of alternative dispute resolution that is court-annexed. And we have, in this regard, supported countries like Lesotho, we have supported countries like Ghana, we have supported countries like Rwanda and
Recording
Malawi.
stopped.
These have benchmarked with us and have carried our model to their jurisdiction. So now after Order 10B or Order 12, we're looking at around 25 years. What is happening? Are we really able to transform Uganda? I say yes, we are able to transform because we have the legislative framework in place to reform both our civil and criminal justice system. And this is very evident when we talk about criminal, that we also have alternative dispute resolution walking into the criminal area. When I was at law school, they told us that you could not negotiate a criminal offense, that it was against what? Public policy. But now we see plea bargaining coming in 2016. And so you're creating an environment where, one, our judicial system is going to be more efficient and more effective. Now the question is buy-in. What is the level of buy-in? And there's a big debate out there. And I think this conference, this summit which is going to be annual, is going to inform that one. Because those of you who are out of this jurisdiction will know that around 2019, there were some amendments to civil procedure rules, and there was a sense that, oh, mediation has gone out of the window, which it has not. It was just an interpretative problem. In terms of foreign direct investment, I still think that it is important that we open channels to resolve disputes that come out of investments, because nobody wants to invest in a country which will lock up its capital in disputes. And therefore, we have the legislative framework. Yes, I agree with President Jim that the Arbitration and Conciliation Act, this is 23 years after we have enacted it, and it is time for review. But again, I just want to emphasize the pole position of Uganda. The Arbitration and Conciliation Act of Uganda was the second on the continent of Africa, after the Arbitration and Conciliation Act of Nigeria, which followed very closely the Arbitration and Conciliation Act of India. So you can see that in terms of creating that framework, we have been pioneers. Now, the real question is, are we using it? Are we leveraging it? Are we seeing how we can do it? How can we be a lead destination? Professor Jim has talked about Singapore, and I've had an opportunity to go to Singapore and benchmark. And this is the story that comes out of Singapore. Singapore, on the domestic level, in their civil cases, resolve them at 80% of cases filed. 80%. So already they had a track history. Uganda, we are struggling to hit 10%. When I was at the commercial court, we had hit 25, now we have gone back. But I would like to put this out there, that in order to be a big player on the international scene in ADR, you have to be a big player in ADR on the domestic scene. If we are going to benchmark Singapore, that is what we have to do. We have to up our game in the domestic arena. Training, 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 very critical. I don't think we can make that move unless we change our training to recognize the importance of alternative dispute resolution. I thank you.
Thank you very much, my lord. You've told us that we need to be a big player on the domestic scene as well as the international scene, and I think that's something very important for us to think about. And talking about that, let me turn to the bankers and the Bankers Association. We know that banking disputes are a large part of our commercial disputes. We hear of 8 trillion shillings locked up in the commercial court. What are your perspectives? And I know your members are operating both on the national and the international scene, but what are your perspectives on how ADR works now, what needs to be done, and do you think we have what it takes to be an attractive international destination for ADR? Over to you, Mr. Owor.
So thank you very much, Madam Moderator. I think that the same way the Lord Justice has spoken, we agree with Professor Jim Gash's remarks, largely, and at the risk of just repeating what the Justice has said, we agree and we concur, and I want to just highlight 2 or 3 areas and then speak to what we need to do. When we were, as co-hosts, mobilizing for this summit, as a banking sector, we did approach some key customers of the industry and players. And these include players in the oil and gas sector, you know, that's shaping in the country. The telecoms, they play a big role, and manufacturers. And we said, we have a summit on ADR, and this is an opportunity for us as business people to contribute, because we suffer the case backlog problem and money locked in. And 2 of them said, but you know, we have the option of court anyway, ADR and so on. I can still appeal to a higher. So I said, actually, that's the reason why we should support this ADR conference and understand it better and see the power of how quickly we can resolve disputes. So I think on the keynote speaker, on the section 6 that he spoke to, where, again, there's discretionary power to entertain other matters, even beyond the framework for arbitration, we would like to see that that is addressed so that it is clear both to court users and other users of ADR. And so we agree with Professor Jim Gash there. I think he also mentioned the issue of immunity to arbitrators and so on. Again, I think this would encourage many professionals.
Recording in progress.
When the chair of ICAMECK spoke, he spoke about the advert that called in arbitrators, mediators. If they are covered under this framework and they are comfortable, I think we are likely to see more. And lastly, the issue of alignment with international standards. I speak to this because our primary role in the sector is to mobilize money and funding and capital flows to support investment, trade, and facilitate the flow of money. And investors, global financial players, are more comfortable in an environment that has standards that are internationally benchmarked. They are comfortable that when money flows here and there's a dispute, not only can it be resolved properly and quickly, but using international benchmarks. No doubt we have made a journey. It's good progress, but I think there's a lot more we can do. And I'm continuing to learn. I think the Honorable Justice Chibita said what? Combat is optional. I've taken note of that. I think we should embrace that. When I was in North Court many years, the motto was, we either win or they lose, which was very challenging then. I think the point being made here is that we have come with a background of acrimony and fight it out. At the risk of upsetting legal counsels here, and I know we have many, and they represent us, we have this challenge of fighting battles even where we can cut losses as business people and continue so that we facilitate flow of money, more business. Instead of what we have seen, gymnastics to extend and create all sorts of reasons just to frustrate the process.
I learned at another session last year with the judges, something called forum shopping. We had a session here where, the same case is filed not just in the commercial division, in the land division, in the family division, and so on and so forth, just to delay a challenge. I think ADR then provides the opportunity for us to resolve these fairly quickly. I agree that we should invest in capacity building and have many, many more people specialized, prepared, and have the capacity. Again, for legal counsels, I think there can be money made on this side as well. Sometimes we see the amount of battle and money is involved, even in just legal fees. Could this be why ADR is not as preferred? But as business people, the best thing that works is to quickly cut losses through the ADR processes and proceed to do business at the end of the day. So I'm hoping that even in our law schools, LDC, I can see Counsel Thembi Frank here, the teaching, and I don't know the syllabus, also brings out the ADR aspect as prominently the way this other battle, combat side of the court and legal battles happen. Because at the end of the day, we want to do business. Most importantly, we want to attract big capital for our economy. And that happens when they are confident that there is a good ADR framework that then addresses those disputes quickly. Thank you very much.
Thank you very much, Mr. Owor. As we move on with the discussion, I'll invite Ms. Judy Rugasira-Chanda to speak a little bit to the fields of real estate, and I'm sure it touches a little bit on construction. These are areas that globally lend themselves well to ADR. What has been the experience here in Uganda in terms in that particular industry? The experience with ADR, is it working? And what do we need to do to make it a more attractive option for people in the real estate sector or in the construction sector?
Thank you very much, Rachel. It's a great pleasure for me to be here this morning. Thank you very much for the invitation. I have about 400 pairs of eyes looking at me. All of them are lawyers, so I'm feeling thoroughly judged, but I shall be strong. With regards to the real estate sector, 70% of the global net worth is stored in real estate. So that just goes to show the value and the importance of real estate to the wealth or the global scene in terms of wealth. In Uganda, the construction sector accounts for 12% of our national GDP and growing, and it has been growing steadily year on year. So such a high value investment class requires an environment whereby we can sustain value, we can de-risk investment into the country, and one way of doing that is to ensure that as you're investing into a country, the ease of doing business is there, but also you have means of sustaining and retaining the investment or the amount of money that you've put into that sector. And of course, disputes are going to arise. They arise all the time. We're talking about large sums of money, a lot of parties involved in the whole value chain. So there's bound to be disputes. But what investors really want to know is, what is my get-out clause? How do I remedy or resolve the disputes that I have at the end of the day? Yes, the court process is there, and it works to a very large extent, but it's timely, it's costly, and oftentimes there's a lot of risks also, litigation risks involved with real estate investments that are going to court. So what the investors really want to know is, what are the alternative dispute resolution solutions that we have? And fortunately, they are there, but what we would like to see is perhaps a faster way of resolving these disputes by getting or allowing for ADR centers that can have experts within that property field, because it's quite a technically specialized field, which will fast track the process of ADR as it is as well. So whilst we have litigation on the one side, we'd also like to see maybe, or the policy allowing for ADR centers which are which are allowed to handle disputes in the property sector, which is specialized. The second aspect I would like to speak to is with regards to secured lending in the banking sector. Obviously, a lot of this real estate investment is developed or built or bought on debt. Now, once you go to the bank for debt, you're assigning these huge contracts. Again, disputes are bound to arise, and we know that there will be need to settle quickly because we don't want to stop the development cycle. We don't want to stagnate or slow down the whole investment process. So having an ADR solution or a system that works well and efficiently is very good and conducive for creating a destination that is successful for FDI and even local investment. And the third one is to speak to the valuation sector with regards to property valuations. Secured lending constitutes a large percentage of revenue for the banks or for the financial sectors. We know that there's been a whole host of disputes and other litigious issues that have come out of property valuations in the banking sector. What we would like to see, and what I think the policy, what a panel of experts who are able to make a decision and guide on how the parties should resolve that dispute without necessarily going to court, because we find that that will then, again, fast-track that whole process and get to a solution which is fit for purpose, because it is being made by experts in the valuation sector, and then that can later on be ratified by the courts if necessary. So I think I'm happy that the ADR policy is being discussed right now. It's being forced us to know that there is another alternative way of resolving, never even reach a resolution.
My last panelist, but not least, I'm sure you are more at home with the audience, since you're one of them. Senior counsel, just to hear from you a little bit from ADR here in Uganda.
Thank you, Rachel. No, the 400 eyeballs don't intimidate me. I'm accustomed to having very many look at me on many occasions. First of all, I would like to join my other panelists in thanking Professor Jim Gash for his wholesome and incisive paper. And I would like to speak to three issues that arose from his presentation. The three issues that I'd like to speak to are, one, his proposal, or rather his exhortation to us to create a specialized bar that is capable of dealing with complex matters in arbitration, mediation, and conciliation. His second exhortation to us about appointment of foreign counsel. In other words, extending the principle of a party autonomy to include appointment of foreign counsel, possibly as arbitrators and indeed as counsel for the parties appearing before the arbitrators. And the third, about the difficulties with the administration of our current statute with respect to enforcement of awards. Speaking about the specialized bar, at the moment we have about 5,000 practicing advocates in this country. This is a very big number of advocates for the size of our economy. When I started out 25 or so years ago, I probably knew each and everybody at the bar, or at least the most prominent practitioners, and I certainly knew all the judicial officers. In the last 30 or so years, there's been an explosion in the number of practicing advocates, and indeed, the growth of our judiciary has been exponential. I mean, we now have circuits, we have specialized divisions, and so on. Concomitant with the growth of our judiciary and our bar has been the growth of a specialized, the emergence, if you like, of specialized practitioners. So today at our bar, for example, to find people who are specialized tax practitioners, you will find specialized mergers and acquisitions lawyers, you will find specialized intellectual property lawyers, and so on. And this is a recent development. This is a development perhaps that could be traced back not more than 8 to 10 years ago, where we have started seeing the emergence of specialized practitioners in specialized areas. And indeed, this is the case as well with alternative dispute resolution. We now have a specialized set of advocates who are renowned as alternative dispute resolution practitioners. We have a separate section in our bar that promotes meetings of these advocates. We have a forum on the internet where these advocates share latest decisions from the courts, latest global developments in ADR, and latest developments in mediation. And there are always robust debates on these forums, and clearly demonstrating the great wealth of knowledge that these practitioners have. We've also seen, as I adverted to in my remarks on behalf of the chairman of ICAMECK, of the emergence of the Chartered Institute of Arbitrators in Uganda. Now, in order to create a chapter of the Chartered Institute of Arbitrators, which is a renowned institution, a global institution, indeed my Lord Justice Kiriabwire is a fellow of that institution, you must have a minimum of 60 practitioners who have undertaken a course, a specialized course in arbitration, mediation, and conciliation. And the fact that we now have a chapter in Uganda of the Chartered Institute of Arbitrators is a further demonstration of the fact that indeed we are growing in specialization, that the bar in Uganda is becoming more attuned to what is happening globally, and indeed is in tandem with other bars across the world. Mr. Wilbro DeWall spoke to the issue about the training in the universities and at our Law Development Center. This morning when I looked at the newspaper, I saw that the Attorney General was concerned about the numbers of students at the Law Development Center. And he said, and the remarks, and I quote, there were over 2,000 lawyers at the Law Development Center at the various branches across the country. I'm not sure whether the curriculum at the Law Development Center now adequately reflects the importance of ADR when it is undertaking, imparting knowledge to these students. And indeed, I think the start of creating a specialized bar, creating a specialized group of people, cohort of people with knowledge in this matter, and encouraging interest, research, and development of this particular area of law would probably start at our universities. We have over 12 universities that have law courses, that have undergraduate law courses. So they have a big role, the Law Development Center and our universities, to ensure that ADR is part and as a central core aspect of the curriculums that are being administered. Part of the pedagogy must include ADR. The second issue was about party autonomy in as far as appointment of foreign counsel. In Uganda, for foreign counsel to appear before our courts, you need a license, a special license, and there must be good cause for the grant of such a license, because as I've said, we have a very large bar, and the bar, and this bar is clearly can deal with most of the issues that are before our courts. Of course, with arbitration, the importance of party autonomy is such that the parties appearing before the arbitrator, and indeed the arbitrator himself, must emanate from the choice of the litigants or the disputants. And certainly, as far as ICAMECK, with which I'm closely involved, is concerned, our panel of arbitrators includes foreign arbitrators who are not necessarily enrolled at our bar. We do also have other arbitral centers. I speak, for example, of CADA, the Center for Alternative Dispute Resolution and Praxis. I'm not too sure how they enlist arbitrators or panel or empanel arbitrators, but certainly, as far as ICAMECK is concerned, we have embraced the principle of party autonomy to include fact that foreign arbitrators can sit as arbitrators. I am not, and I'm sure they can also appear as counsel in matters where parties have chosen to have a foreign counsel appear. So that is as far as ICAMECK is concerned. As to whether or not there should be statutory legislation to embed that in our law, I think is still open, still an open question. It's still a developing area. I certainly think we should observe what is happening with those centers that have embraced the principle of ensuring that a foreign counsel can appear either as party representatives or arbitrators in particular matters. Finally, I'd like to speak to the challenges with the legal framework. My Lord Justice Kiriabwiri has spoken about our Arbitration and Conciliation Act, 2000 Act. There is a need to have amendments to this act. And I'm pleased that Professor, the chairman of the Law Reform Commission is here. And I believe there is a process underway to amend the law, but it's in need of some amendments. Justice Kiriabwiri spoke about the experience from Nigeria. The Nigerians have recently, for example, amended the Arbitration Act to include a very novel aspect. Part of that novelty in the act is an appeal from a decision of arbitrator to another level of arbitrators within the act itself. So this perhaps could check. Sometimes there's an abuse of arbitral power. And because it's very difficult to set aside an arbitral award, arbitration could be used as a vehicle for injustice. But they have introduced a very interesting novel aspect in their act, which is very, very revolutionary in my view, but something certainly that's worth careful study and maybe adoption in due course. This is just one of the amendments and one of the issues that perhaps we could look at in general. The second is about how we go about enforcing awards. Sometimes we find that there's a reluctance. And I don't want to go into great detail about this because there is a problematic case before our courts. But the whole point about attracting international foreign investment is that awards must be enforceable. So if we are parties to the New York Convention and a foreign-seated award has been made, there shouldn't be any difficulty in enforcing these awards. Indeed, if we are reluctant or we seem to be, pulling ropes, to use our local vernacular, when it comes to enforcing awards, then we send very dangerous signals to our friends, the bankers, the owners of international capital. So this is a concern, and I think that's something that we should address. There should be a uniformity of practice in as far as the enforcement of awards is concerned. I think that I'm very happy that there's been this national forum where we can discuss policy, and I hope, as you've said, it's going to be an annual forum. I think also within the Judicial Studies Institute, it's important that as we encourage Law Development Center and the universities to mainstream ADR, I'm not sure what the practice is at the Judicial Studies Institute, but I also think that if it could equally be mainstreamed, especially for the lower bench and so on, I think it would go a long way in promoting ADR as a possible method of ensuring that we deal with our case backlog. Finally, I would just like to say that we as a country, we have gone a long, long way in ADR. I recall when I first started practicing, it was unknown, for example, for there to be mediation, or indeed for there to be, and if there was any arbitration that was carried out by a few people like Justice Kiriabwiri here, they were all ad hoc. arbitrations. We did not have real center administered arbitration. We now have 3 centers. This is quite an amazing phenomenon, and this is within the last 5 or 6 years. And ICAMECK alone has got over 60 disputes. I'm not sure what the numbers are for CADA or Praxis, but to move from ad hoc arbitration to center administered arbitration, for me, is a very big step forward. It just goes to show that ADR has found very fertile ground, and it will continue to grow. The second encouraging factor is what the judge spoke about, mediation. I recall in the mid-90s when mediation was first introduced, it was very novel. It was a very, very novel concept. But over the years, we've got over 5,000-6,000 people who have been trained in mediation. And indeed, I was very pleased to hear IDLO say that we now want to take it to the grassroots. Because once we embrace, first of all, mediation at the grassroots, then we begin to build a culture of ADR. And once we begin to build a culture of ADR, it's a very short journey to becoming a center for excellence in ADR. Because as the judge said, if we do not have a strong domestic ADR system, then it's very difficult to attract foreigners to create this as a seat for arbitration, whether regionally or indeed on the continent as a whole. Thank you very much.
Thank you very much, Senior Counsel, for those thoughts that you've shared with us. Just to follow up on a few issues from the keynote address and from our discussions, and I'll turn first to Justice Kiriabwire. My Lord, Council has spoken about the enforcement of the awards. You gave us a very good insight into the history of how the legislation has developed. President Gash, in his remarks, talked about the balance between the arbitration agreement and the inherent powers of court. How can we find that balance to ensure that the arbitration agreements are honored, are respected by the court system, and that the industry professionals, the investors, have the confidence that when they put these agreements into their clauses, they will be respected? And how do we balance that with the inherent powers of the court? I just wonder if you could share your thoughts on that particular issue.
Thank you very much. In terms of the courts on the one hand and the arbitral tribunal on the other, I think we are very fortunate in terms of our legislative framework under the Arbitration and Conciliation Act. First, Uganda New York Convention of '58. There are very many countries which are, and therefore reciprocity in terms of recognition, that is number one, and two, enforcement is possible. And it is also, the New York Convention is also domesticated within the Arbitration and Conciliation Act. We also have, under Section 34, the legal framework for challenging an award within the Act itself. And therefore, really, what the court needs to look to are those elements. Is it a New York Convention award? Is it a subject of challenge within Section 34? And probably that is it. You see, it is not for the court to say that I would have come to a better decision. It's not for the court to say that I would have handled it differently, provided that they fall within the parameters that are within the New York Convention, then enforcement will take place. I had the opportunity to deal with one of these when I was a judge at the commercial court, and we really had no problem whatsoever in working towards enforcement of an award that had come out of London. I think there's a major international cotton trading association in London, and an award was made against a Ugandan exporter. What resulted at that point of the proceedings is that we did not really have to go to the point of making the award, because the parties entered into a settlement as to payment. And therefore, the very fact that I think the parties were able to see that an enforcement was possible in Uganda, which I think at one stage the Ugandan lawyers were a little bit surprised, they then agreed to arrange with the parties a payment. So there is not too much discretion. For me, I call arbitration private justice. If the parties have chosen that route to resolve their disputes, then we must cede to that, provided it falls within those parameters. So I think there's not much room for the courts. And again, it is a challenge. Again, the language must be very clear, because senior counsel was talking about these innovations. What is happening is that instead of challenging the award, there's a tendency to treat it like an appeal that would happen in the normal appellate courts. Thank you.
Thank you very much, my lord, for that. In the keynote address, there were also some remarks by President Gash with regard to the ADR policy and the space that it creates, for Uganda. And I want to give the Honorable Minister just a few moments to share his thoughts and to tell us a little bit of what that's going to do for us. And following that, I'll invite just a few questions, because we're coming to the end of this session. Just a few questions before we wind up and move up. But Honorable Minister, we just want to hear from you a little bit. We talked about the policy. What ground does that open for us in terms of ADR?
We believe that ADR should be regulated. There will be a measure of regulation by the state, but largely it should be self-regulated. We also believe that there should be stringent standards to be adhered to by practitioners. So this is work in progress. After this summit, I will be announcing a national Alternative Dispute Resolution Advisory Committee comprising a number of people to advise your Minister of Justice and Constitutional Affairs so that he can, alongside the judiciary, lead the process of the necessary law reforms that are being recommended here, and probably creating a body which is above the practitioners. I don't think it is healthy to have one of the centers to be regulating other competing centers or alternative centers. We are studying cases from other countries like the Philippines that are fairly well advanced. So this policy is basically to declare the posture of the government in support of ADR, and also recognizing the stance by the judiciary that the people should participate in the administration of justice. And there is no better way for the people to participate than through ADR, where we don't have to wait for a judgment, orders and decrees, but rather we can even have mediated settlements, we can have arbitrators. The policy will also create an environment where people, men and women of character, will bring their moral authority to bear in resolving of disputes. Sometimes we think it is only people can help in resolving disputes. It's very serious. People value character over knowledge. Thank Thank you.
Thank you very much, Honorable Minister. We have just a few more minutes left in this session, so I'll just take maybe 2 or 3 questions for the panel for them to wind up. So if there are just 2 or 3 urgent questions that we can take right now, before I pass back to the panelists for their closing remarks. I can see the president of the Law Society and one person at the back of the room, so I think. Okay, so I'll just take the president of the Law Society. There's one hand at the back, and then His Worship.
Thank you, moderator. I just have one question in regard to the remarks on the issue of constraints on foreign counsel should be removed. And I think in light of the global conversations happening, and whether it's the Global Financial Summit last week, whether it's BRICS, resetting the New World Order, and all these conversations happening, how do we harmonize the need for us to be able to build the capacity of our local lawyers and so that we are not left behind in the name of trying to ensure that foreign counsel can be able to practice here? Because going to class and getting an LLM in dispute resolution is one thing, but being able to handle the matter is another. And that matter is a deliberate process that the government, that all the other stakeholders must take. Otherwise, we'll be left behind. Thank you.
Thank you very much. I will take also Justice Chihika, just on this side, before I go to Mr. Resida at the back of the room. So, Justice Chihika.
I would like to thank the presenters for their brilliant presentations. A couple of clarifications here. Number one, the participation of foreign counsel or foreign lawyers in the arbitration process in Uganda. Strictly speaking, when you're talking about an arbitration, I do not know of any law that prevents a foreign lawyer from representing a party to a dispute where people have agreed to arbitrate, because the dispute resolution mechanism excludes the arena of court. The foreign lawyers will be required to obtain the practicing whatever or special certificate if the dispute is being adjudicated in our formal court structure. So I just wanted to make that clarification. There is no impediment for a foreign lawyer to come and represent a party who has agreed to enter into a dispute resolution mechanism via arbitration. Number two, from a macro perspective, I think it's important that we must concentrate our efforts directed at the buy-in of local lawyers into the arbitration mechanism here in Uganda. And why is that? This is because we as a developing country have a dire need for foreign direct investment. And as has been stated,
a mandate to adjudicate. So we can have it as additional or appropriate or accelerated method of dispute resolution.
Thank you very much, Your Worship. I think that is noted. I am going to turn back to the panelists to just give us a quick response to any issues that have been raised or any comment that they want to make in their closing statements. But I'll also allow the chairperson, the Uganda Law Reform Commission, to just quickly say a few things about the proposals that are being made with regard to ADR. So I'm just going to ask Dr. Pamela Tibihikira Kalyejira to say something very quickly, and then I'll give the panelists each just a minute to comment and wind up on the presentation. So just Dr. Pamela, if she's here.
Recording in progress.
Thank you very much, Ms. Moderator. Not to waste time, what I have done, I've shared a study report that we carried out on the Arbitration and Conciliation Act. We did this in June 2021 and shared with AG our recommendations. There are several. I've also shared it with Professor Kauka, so hopefully he could upload it onto the conference documents so that we save time. But we did touch on many of these areas. Thank you very much.
Thank you very much, and we look forward to receiving that document. So allow me now to turn back to the panelists, and I think I'll start maybe with the Senior Counsel Adrico, if you have any closing statements or closing remarks or comments to the questions raised.
I thank my Lord Justice Kihika for pointing out, obviously, that arbitration is, as Justice Kiriabwire said, private justice, so the parties can certainly decide whether to appoint foreign counsel or not. But obviously there are complications where it's a Ugandan-seated arbitration and you have to navigate the peculiarities and perhaps the ambiguities of our Arbitration and Conciliation Act. So naturally, it's a question for the parties to decide whether they would want to risk having foreign counsel appear in a Ugandan-seated arbitration. But certainly, if Uganda were a seat, then that's something that they have to take into consideration. What I would like, my closing remarks would be that my learned senior friend, Alex, said, what about the lawyers in as far as becoming accomplished, skilled arbitration, ADR practitioners, to use that term in its broadest sense. First of all, we've seen, as I said, a growth in the specialized bar. We already have over 40 members of the Chartered Institute of Arbitrators. This is just one professional accreditation body that is renowned worldwide. And indeed, there are continuous trainings. Even this year alone, I think they have 20 or 30 people registered to train to obtain that particular qualification. So we are taking steps. It's really a question of interest at the bar to acquire this knowledge. And as far as disputes are concerned, yes, very welcome advice to partner with foreign practitioners. Obviously, the nature, our economy is not a very sophisticated or complex economy. Some of the transactions that come across are fairly simple and straightforward. And as far as disputes are concerned, of course, as the economy grows, the disputes will become more complex and there will be need for some form of partnerships. But obviously a partnership of equals. If you do not have the requisite qualifications in the first place, then the partnership will be very lopsided. Thank you.
Thank you very much, Senior Counsel Adrico. And I'll turn now to Judy, if you have any final comments or any issues that you'd like to, any closing remarks.
Thank you very much, Rachel. Mine is just really in closing to say that I'm looking forward to the policy. And I would like to perhaps say that if we could be given an opportunity as a Surveyors Registration Board or the Institution of Surveyors of Uganda to perhaps participate and or contribute towards the policy to see how we can fit in and provide some input in how the specialized disputes would be resolved at that level, say for example for valuations or for any other property-related disputes. So it would be good for us to have an input into that and see how we can plug in and provide a specialized input.
Thank you very much. Mr. Orr, do you have any closing remarks to make that you'd like to make?
Yes. As a sector, we are really happy that this is happening for the pure reason that we would like more money to flow in the economy. And we do business and grow the economy. That's why we are interested. And today we have everybody here. Senior Counsel Alex, Resident Justice Kihika have mentioned that they are key stakeholders. The legal fraternity are in the center of this. That's why in my remarks I said, even this side you can make a lot of money. And there's money to be made as well. So I want us from today's takeaway, whatever it takes, if it is policy, Honorable Mao, my brother who succeeded me in Makerere, is here. Let's lobby. Let's do what it takes. The banking sector is behind this to see the much needed change, whether it's in legislation, policy, or otherwise. I think the registrar had said they are retired. She said they are rehired. We have experts I remember the principal judge refired, taught us a lot and said, this is an avenue for unlocking the potential in business. Let's lobby, let's do what it takes. There is business on this side, but more importantly, there is capital, and we must together make this country an attractive investment destination and minimize gymnastics that take long in court and frustrate the flow of money. That's really my last message. Thank you.
Thank you very much for that passionate last message. And allow me now to turn to His Lordship Justice Kiriabwire for the final word from this panel. My Lord.
I think after the bankers, what more can you say? 121 years of adjudication, formal adjudication, 25 years of formal ADR. That is where the push and pull is going to be. And I would like to say that, yes, training is critical, and I can throw in a small advert for Director Thembi as chair of the Barcos Advisory Committee of the Law Development Center. We are going to streamline ADR in all processes of Barcos training beginning September this year. So that is certainly going to happen. Now, where are we? It kind of reminds me, those of you who like the old school music, remember Odyssey and going back to our roots? Eh? You remember that song? It seems like we are going to be starting to go back to our roots, which is more of win-win, expedited settlement, and greater party autonomy. This is the path that we must walk, and I think we're on the right path. I'm very glad to hear what the Law Reform Commission is doing in terms of reforms. I was not aware. I think we need to create a center of information so that we can all be able to participate and make it better. I thank you very much for this session. I think it has been quite rich. Thank you, Rachel. Thank you.
Thank you very much, my Lord. Please join me in appreciating our panelists this afternoon for their expositions and their information. And I thank you all for your participation and attention. I have now come to the end of my session, and I wish you all a good day, and let me hand back to the MC. Thank you very much.
A better round of applause, ladies and gentlemen, for this awesome panel. Like I told you, full of wisdom, concentrated expertise, and humongous experience. Thank you very much. Ladies and gentlemen on the panel, we are so glad that you were the one on the panel. I want to believe that we have picked quite a lot. I personally picked 5 key quotations I want to give. These are quotable quotes. Enough is enough quoting Mahatma Gandhi of India. Yeah? John Maxwell. We can also quote people local here. For example, Honorable Justice Geoffrey Kiriabwire said, nobody wants to invest in a country that locks up its capital in disputes. That's a quotable quote. Honorable Justice Mike Chibita in the morning said, conflict is inevitable, but combat is optional. Quotable quote. Ms. Judy Rugasira said, 70% of the global wealth is stored in real estate. Investors therein need to know the alternative dispute resolution solutions without holding up their investments. Critical thought. Senior Counsel Adrico made a powerful statement when he said, sometimes there is an abuse of arbitral power, using arbitration as a vehicle of injustice. An amendment to make provision for appeal to another level of arbitration is worth considering. Critical thought. And Mr. Wilfred Humphrey has made a very passionate plea when he said, make Uganda an attractive investment destination. We can't agree more. And I will end with this quotation that is outside the conversation we've just had, but very related. When I was seated down and I was watching the panel and taking notes, learning from them, another quotation from outside this room came to mind. And this quotation says, if someone brings a lawsuit against you and takes you to court, settle the dispute while there is time before you get to court. Once you are there, you will be turned over to the judge, who will hand you over to the police, and you will be put in jail. This was said by Master J.C., the Lord of Lords, in the Constitution of His Kingdom, Article Matthew, chapter 5, clause 25, GN translation. These are very important thoughts, ladies and gentlemen. At this moment, before we receive our second panel that will lead us to lunchtime, I think we have sat down for quite a long time, haven't we? And for the sake of our physical health, please, if you don't mind, kindly get on your feet. Let's do a small energizer to help our bodies flow and our blood flow well. Just for the sake of our health, in case you don't mind, kindly get on your feet and we become healthier. Help me to spell the word coconut. Let's go. C-O-C-O-N-U-T. Okay, so we are going to spell it using our bodies. This is letter C, using our arms. So let's spell C. Okay, we are spelling O. We are going to spell C, but now the opposite direction. Followed by O. Followed by N. Now N is quite interesting. Lowercase, not uppercase, lowercase. So this is leg number 1 of N, and this is leg number 2 of N. So let's make N with our back. And then we are making U. And then T. Be careful who is next to you when you are doing T. Okay, let's go. Okay, so there is a small song that we are going to use to stretch very well. Quite a common melody. Ta-da-da-da, ta-da-da, 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 ta-da-da. So that's how we are doing C. So it is C-O-C-O-N-U-T, N-U-T, N-U-T, C-O-C-O-N-U-T, N-U-T. Good to go? All right, let's go. C-O-C-O-N-U-T, N-U-T, N-U-T, C-O-C-O-N-U-T, N-U-T. So we are doing it for the last time, this time quickly. Ready? Tap on your neighbor and say, get ready, neighbor, get ready, get ready. We are doing it quite quickly. Ready? Let's go, let's go. C-O-C-O-N-U-T, N-U-T, N-U-T, C-O-C-O-N-U-T, N-U. Awesome, awesome, awesome. Round of applause for your neighbor, ladies and gentlemen. Feel free to take your seats. Our blood needs to flow if we are to remain healthy. That's the best way how you do an alternative dispute resolution with your body to stay safe. So that there is no need for physical litigation of your body and your health. At this moment, ladies and gentlemen, I would like us to welcome the next panel that is going to take the next 30 to 40 minutes up to lunchtime to help us now unravel the different intricacies around changing landscape of the financial disputes. So the second panel is coming to add their voice to what has already been ably clarified, not only in the keynote address by Professor Jim Gash, but also by the panel that has been led by Ms. Musoke. So I would like you to put your hands together and welcome Mr. Philip Karugaba, the partner at ENS Africa, who is moderating this conversation. My brother Philip, you're welcome. Right, welcome to take your place. And he will be leading this conversation with the following people. The Honorable Lady Justice Monica Mujenyi, Justice of the Court of Appeal. Let's welcome her to the podium. Very welcome, Lady Justice Monica. Also, the Honorable Justice Stephen Mubiru, the Head Commercial Division of the High Court. Let's welcome him to the front. Can see the moderator likes to welcome his team. I think he's doing arbitration and mediation in advance just in case there is a conflict during the panel conversation. Smoothing the ground. Let's welcome Ms. Angelina Namakula Ofono, the Chief Legal Officer or Company Secretary. Let's welcome Angelina. Very welcome. And finally, let's welcome Mr. John Ohaga, the Managing Partner, Triple Oak Law LLP, giving us the Kenyan perspective. Please welcome him to the front. So this panel is taking us through a conversation on the changing landscape of financial disputes. Over to you, Mr. Philip Karugaba.
Thank you very much. Good afternoon, all of you. Warm welcome once again. Protocol was observed earlier, and I'll continue to abide that tradition. I'm extremely honored and humbled to be leading this distinguished panel that has been introduced by the MC. We also have their detailed profiles online, very well done by the summit organizers. I would encourage you to look them up, and we save that bit of time. Thank you. As has been said, we will be exploring the resolution of commercial disputes and the use of ADR in keeping with the theme of this summit. Testing. 1, 2, 3. Okay, we're back. Thank you very much. So I warmly welcomed all of you. I observed the protocol. I thanked the MC for the introductions of the panel. And I was saying we will be exploring resolution of commercial disputes and the use of ADR in keeping with the theme of this summit. So we'll be asking a few questions to each panelist, and hopefully we will save some time for questions from the floor. I will start with Angelina. Maybe credit to the president of the Uganda Bankers Association who left on such an impassioned note. Angelina, you play a central role in our economy. You collect our money and lend it to other people. You provide safe custody, and you also give credit, which is essential to make the wheels of our economy spin. What is your preference when it comes to disputes? giving you two choices, arbitrate or litigate. And if you could share what it has been like, what has your experience been?
Thank you, Philip, and good afternoon, everybody. It's a tough choice between arbitration and litigation. For us in banking, as Wilbrod indicated, we are not in the business of litigation. Our business in the banking sector is around spurring the economy to ensure that we can be able to grow Uganda. So given a choice, we would always look for the fastest mechanism to get us out of a dispute. So I think for us, based on the discussions, we know that we still have a few challenges with our alternative dispute mechanisms, but we know that together we can be in a position to enhance those. So for us in banking, we do employ different dispute resolution mechanisms. If many of you who've been able to get some financing from banks, hopefully none of you has been in a situation where you're not able to pay back. So for those who've not been in a situation where they're not able to pay back, what we look at, we try and negotiate. So most of the industry players, you'll find they have departments which support with negotiating with the clients. And the intention really is to ensure that we can support our clients to be in a position to still pay back these funds. Remember, this is not our money, this is your money that you give us to keep for you. So we need to ensure that we get it back. And the fastest way we look out to get it back. So we start off with negotiations to try and do that. That's why you find we have a lot of restructures in place just to ensure that we can be able to support. We have to also appreciate the courts. They've also allowed us to proceed even when we are in the litigation phase. They do allow us to continue mediation with our clients. So we've had success where we've been in a position to get even consents when we are in full litigation. Our challenges, of course, remain the fact that in some instances, there's frustration from the courts. I have a case where we got a consent judgment about 7 years ago. To this day, we've not been able to enforce because the same borrower has used the litigation process, has gone back to the same courts to delay an execution, and yet they agreed to the consent. This is 7 years ago. So you can imagine, I think as we've indicated, for us in banking, we are holding over 8 trillion shillings in the court process. Imagine what that amount of capital can do to this economy. And ultimately, with the changing landscape that we are seeing in our country, we have big infrastructure projects coming in, oil and gas, roads, dams. Such projects cannot be financed by just us, the banking sector in Uganda. So we have to rely on sectors, on finances outside the country. Such finances, I'm not too sure, would want to be told that they can spend not less than 2 years in a litigation process. So ultimately, such financiers would want the quickest way to resolve a dispute, and this is this alternative means. So for us, Philip, ultimately, arbitration, mediation, negotiation is the way to go for us as a banking and financing industry. Thank you.
Thank you very much, Angelina. That's been warmly received. Mr. Haga comes to us from neighboring Kenya, and I would like to turn to him to bring in the East African perspective straight away. And Mr. Haga, my question for you is, what is your advice to your clients in dispute resolution? Is it always arbitration as the first choice? And if you could give us 2 reasons for your choice. Thank you.
Thank you very much, Philip. And thank you very much for your warm welcome, and thank you for having me at this summit today. It is my pleasure to bring greetings from Kenya, and I look forward to making some contribution. Now, in response to your question, Philip, And I suppose that your question is against the backdrop of a relationship between a banker and its customer, or a provider of financial services and one that is the consumer of those services. Now, if we start from the bedrock of the principles that we know are primary to the relationship between a banker and its customer, first and foremost, we know that confidentiality is one of the basic tenets of that relationship. Therefore, in my view, arbitration necessarily lends itself to the advancement of that principle, of that tenet. Because arbitration is conducted in an environment that upholds confidentiality. As we all know, the court process is a public process. It is one in which banker and customer necessarily put everything in relation to their relationship out in the public forum and therefore out in the public domain, therefore destroying that basic fabric of confidentiality. The next thing that I would like to suggest, I would advise my client, if it was a lender, would be choice of dispute resolver. And when I say choice of dispute resolver, I mean that arbitration gives you, as the parties, the ability to choose your conflict resolver. And that means, therefore, that you can choose your conflict resolver based on subject matter expertise, based on availability, based on the potential costs associated with the resolution of that dispute. When you go into a state court, and we know that a state court is one in which you have no choice as to the judge that will be allocated to hear your dispute. And we also know, and this is my experience, that judges do get transferred. Philip, in my experience in Kenya, I have had one matter in which I was acting for a bank, which spanned 12 years and which was heard by 5 judges. Now you can imagine, over the course of the lifespan of a dispute, each judge hearing a proportion of the evidence, and finally the last judge having to collate the evidence that was heard by all the 4 previous judges and reach a reasoned decision that is satisfactory to the parties. Needless to say, that matter is on appeal. We're in our 17th year of trying to unlock that dispute. And so, therefore, I would suggest that the choice of conflict resolver also means that as parties, to a very significant extent, you are able to control the timetable for the resolution of your dispute, because the parties work with the arbitrator to try and ensure that the arbitrator can firstly, in the case management conference or at the preliminary meeting, be able to essentially set out the roadmap for the resolution of their dispute and stay, so far as possible, within the parameters of that roadmap, and therefore resolve that dispute in a timely manner and therefore in a cost-effective manner. So there are many other matters that I would take into consideration, but you asked me for 2, and so let me limit myself to those 2. Certainly, without doubt, I would recommend arbitration. Thank you very much.
Thank you very much, Mr. Haga. This is becoming even more and more interesting, but we will take the advice from His Worship Kisauzi to say we should not weigh too heavy on the word alternative. I would not want to paint a beauty parade between ADR and litigation, but we should look at the two efforts to resolve disputes as complementary. And the next panelist that I'm directing a question to is the head of the Commercial Court, Honorable Justice Stephen Mobiru. I hope you are not going to get the feeling of being painted into a corner. It would certainly be the first time that I put a question to a judge and ask him to answer it straight away. Yes. So, Honorable Justice Mobiru, as head of the Commercial Court, which is the court of first instance for the major commercial disputes. How does the court view ADR? Is it your friend or is it a foe? Is it supplementing or is it competing? Honorable Justice, thank you.
Thank you very much, Philip, and the audience. Now, speaking from the perspective of courts and the judicial frame of mind towards ADR, the interface between adjudication in courts and ADR comes to the mind of a judge in three main components. First, we perceive ADR as complementary to the judicial adjudication system. We don't consider ADR as a rival. It can never be a rival. We have one goal: to free resources from dispute using a fair process and the quickest process and at a very minimum cost. That is our target. Second, we consider ADR, especially arbitration, as a choice made by the parties for resolving their disputes. Therefore, we respect party autonomy. Parties chose their arbitrator, they chose the law to govern the process and every other aspect of the dispute resolution mechanism. So we respect party autonomy. Thirdly, we realize that the court system is meant to be supportive of ADR. Our role is supervisory. It is also intended to aid ADR in its various aspects. We therefore have a lot of deference to the outcomes of these processes. We only upset them for very, very exceptional reasons. Most of the times, we seek to uphold the outcomes. Now, the roles vary depending on the type of arbitration that was conducted. If it is domestic, we have wider powers of intervention. If it is international, the powers are more limited, as I'll be explaining shortly. In domestic arbitration, the courts have a role at three stages. First, at the constitution of the arbitral tribunal. The second stage is during the process, and the last stage is at the time of enforcement. Now, we start with at inception of the process. There are two categories of arbitrations we deal with in our court system. We have arbitrations arising out of institutional processes, institutionalized arbitration. We also have ad hoc arbitration. At the appointment stage, courts have very limited roles in the constitution of the panel. The parties chose how to select their panel and how it is constituted and the time frames. We can't intervene. But at the ad hoc, we have some parties in their submission to arbitration choosing court to be the appointing authority. There we participate in the selection of who is to be arbitrator. And we are assisted by the existence of now institutionalized bodies that have pre-qualified arbitrators. Selection is easy. We propose to the parties to nominate, and from the list of nominations, we select an arbitrator and refer the matter to the arbitration. At that stage, in both systems, we are very, very keen to enforce submissions to arbitration. We ensure if parties have an agreement submitting disputes to arbitration, that they honor that agreement for as long as the agreement is enforceable, is valid, and the dispute is arbitrable. Once we have those factors, Section 5 of the Act requires us to take our hands off this dispute and leave the parties to arbitrate. So we are very keen at that level. We've seen attempts to avoid being bound by these clauses. I think people get cold feet afterwards and seek to avoid the submission. But we ensure that this submission is honored. Now, during the process of arbitration, we have a limited area of intervention. Section 9 of the Act says we can't do anything about the process or its outcome except as per the Act. If it is not in the Act, we can't do it. I agree with the previous panel. I think it was Justice Chiravire who pointed out that we have very limited discretion in intervening in these matters. We can only grant interim relief by way of protective measures. We can also entertain challenges to panels that are constituted and some rulings of those panels, especially as regards their jurisdiction. That is how limited our intervention can be. Now, at the end of the process, again, we have two tracks. We have challenges to the validity of this outcome. Many times we've seen litigants, rather parties to an arbitral process, coming to courts seeking to set awards aside on multiple grounds. But most of the challenges at that stage tend to take the format of appeals. We've rejected those types of applications. You chose your arbitrator for better or for worse. You are bound by the findings of that arbitrator. Whether they are wrong on facts, that is the outcome. If they are wrong on the law, they never guaranteed a correct award on matters of law. That was your choice. We only intervene when there is a very fundamental violation of the principles of law that form the basis of our structure of justice. But if there are minor wrong decisions on principles of law, you are stuck with your award. It will be enforced. So we cannot intervene except for very fundamental violations of the law, or where it is demonstrated that the arbitrator was aware of certain provisions of the law and deliberately chose to either ignore them or misconstrue them. And it is very clear that is an abuse of the process. And then we can intervene to prevent a miscarriage of justice. So setting aside is limited by the Act, and we are very keen not to step outside the limits of our authority in setting aside awards. We are also empowered where the parties have reserved a right of appeal on matters of law to entertain appeals, but this is consensual. There is no right of appeal against arbitral awards. It has to be consensual. And finally, when we come to enforcement, when we find the award passes all challenges, it must be enforced as a judgment of the court, as any other decision. The only problem is that enforcement has to await 90 days from the time the notice is filed of the award. It's by law. We can't expedite that process except as provided by the law. We would have wished to have it faster, but we are limited. We have to wait for 90 days before it can be enforced, or if there is a challenge, after the challenge has been disposed of. So the court system, and both in the divisions and in the circuits, we are keenly aware of our role being supportive. We don't take ADR systems to be a rival, but they are complementary. And in fact, they save us from the worst nightmare of any judge, is writing a judgment. It's time-consuming, and anyone who takes that burden away from you cannot be a foil. You are in good company when you come to the courts to enforce your awards. Thank you very much.
Thank you very much, Honorable Justice Mobiru. I think you've delineated the different tracks very well. It is very intriguing to see the intersection between the ADR mechanisms and the court systems, how you keep stepping back from ADR into the court and out again and back again and so on. And I like that you view it as assisting rather than hindering the work of the court. And the summary that both systems are about freeing resources from dispute as quickly and cost-effectively as possible. That's a very good foundation for my next panelist. Honorable Justice Monica Mugenyi is a judge of appeal, and she is also a student of arbitration, being a fellow of the Chartered Institute of Arbitration. Honorable Justice, would you like to supplement Honorable Justice Mobiru's response?
Thank you very much, Philip. And good afternoon, dear distinguished participants. I shall not get into protocol, but I'm very delighted to be here. I think it's important now to go into principles. I can't say I knew what my brother was going to talk about, but I think it's important at this stage to get into a few principles. The first principle would be the background to arbitration. We are talking about a changing landscape. So what was there before? My submission is that between 1962 to about the mid-1990s, the country had a fairly mundane, basic banking financial sector. In the 1990s, we saw the advent of SAPs, the structural adjustment programs, that came with all sorts of propositions from the IMF, World Bank, and what have you. And in a nutshell, they led to the liberalization of the economy, which came with the divestiture of state-owned enterprises. And with this came an upshoot in foreign direct investment. Now, when it comes to foreign direct investment, my experience has been the bulk of these transaction agreements have provision for dispute resolution, which usually is arbitration. The preferred choice of dispute resolution is arbitration. And why is this? Internationally, in terms of commercial dispute resolution, arbitration tends to be akin to commercial dispute resolution and the settlement of financial disputes. Financial disputes, in a nutshell, really about disputes that arise from financial services. These include banking, insurance, microfinance has come up today. There is taxation as well. So any dispute in those areas would amount to a financial dispute. Now let's get into the principles. Given the sensitivity of the financial sector to the socio-economic stability of any country, it is important that there is certainty and consistency in dispute resolution, especially financial dispute resolution. And that brings me to, a lot has been said about the positives of arbitration. However, the disadvantage with arbitration lies in its privacy. The fact that it's a private dispute resolution mechanism means there is no recourse to precedent because the awards won't be published. So any arbitrator is starting from ground zero. All you are doing is looking at the set of facts before you and the decision of the parties before you in terms of how they want the arbitration to be conducted. Should they say they want it to be conducted in terms with general common law principles, you can't bring case law. You're bound by the agreement of the parties. Now, in terms of a financial dispute involving colossal sums of money, and this is probably a microfinance institution that is still struggling, the absence of consistency and dependability could raise some issues. However, as has been said by, I think it was John, the confidentiality also works well when it comes to the banker-client general relationship. So there are two sides to it. There is the pros of the confidentiality, and there is the cons that comes with not having a dependable, consistent dispute resolution precedent. Now, that also can be addressed, as has been talked about by John, by your choice of arbitrator. Should you know the nature of the dispute before you, and in your agreement you have agreed to have, say, each party choose one arbitrator, and then the two arbitrators choose the umpire. At that point, it is critical that you choose such an arbitrator as has the expertise for the specific dispute that you're dealing with. So the expertise that is inherent in the arbitration process sort of mitigates the cons of the absence of precedent. Secondly, arbitration is premised on the objective of it being a fair manner of resolution of disputes by an impartial tribunal without unnecessary delay or expense. As has been stated here, disputes in the courts take very long to get resolved. They could take up to 15 years if they go through the appellate system, while arbitration has the award as a final award, not subject to appeal. It may be challenged on grounds, say, of impartiality of the tribunal or an individual arbitrator, but it's not an appeal on the merits of the dispute. So that's the difference, that the award will be final in itself, but may be challenged only on certain designated grounds, for instance, impartiality, lack of impartiality, or any other ground that goes to the expertise or competence of the tribunal. Parties' choice of arbitrator ensures that the necessary expertise merged with the privacy of the process gives finality to the dispute. And then supplemented with mediation, because we do have processes where arbitration could be preceded by mediation. It doesn't exclude mediation. You could have a mediation ensue before the arbitration, and once the mediation has hived out the issues, then you go to arbitration. Given the internationality of foreign trade and investment, financial services have been similarly globalized. Hence, arbitration has emerged internationally as a viable alternative to national courts. And so we have international institutions like ICC setting up processes and capacity for any party to access their processes and access their experts. They have databases of experts which would supplement any institutional arbitration. Necessary court intervention in the arbitration process will sometimes make arbitration as protracted as litigation, and therefore courts intervene to resolve these challenges as and when they arise. What sort of challenges arise in arbitration? Oftentimes, there are challenges to the tribunal's jurisdiction in the first place, or to an individual arbitrator's impartiality, or to the arbitral award itself. Courts will also intervene to provide support to the arbitral process, for instance, by the appointment of arbitrators where a party has defaulted on such appointment. I need to mention that arbitration, especially the protracted arbitration, does not come cheap. The arbitrator's fees are not that low, and therefore its utilization for simple financial transactions, for instance, microfinance or microcredit transactions, could prove very costly to a financial institution, and particularly to its clients, where they are low-scale clients. In a nutshell, arbitration, I think, thrives on the integrity of the arbitrator, the integrity of the process, as well as the ethical standards set by an institution. If these are lacking, owing to the finality of arbitration, a party could feel shortchanged by having an award rendered that is not addressing the specific issues before them. We have had regional integration measures that address arbitration alongside litigation. For instance, the East African Court of Justice does handle arbitration alongside litigation, which also poses challenges in itself, because we have a set of judges that might not necessarily have expertise in any given dispute or the subject matter of a dispute. And once you are bound to have these as your arbitrators, it comes with expertise challenges. I think I shall stop on that note, but just to point out that with the advent of the East African community, we are faced with issues like the Customs Union Protocol, the Common Market Protocol, and the Monetary Union Protocol. The treaty, which is the overriding statute, provides for free movement of capital. So the challenge is, what impact does this have in terms of financial institutions and the transactions that they mete out vis-a-vis arbitral proceedings? How do we have free movement of capital alongside the detailed syndicated loans that we're seeing increasingly coming up today? I want to stop on that note and leave room for further discussion.
Thank you very much, Honorable Justice Mugenyi, for teasing out yet further aspects of this big question around arbitration of commercial disputes. I particularly like the teasing out of the question of ethics and integrity of the arbitrator that the parties have chosen for themselves. And like Honorable Justice Mobiru pointed out, for better or for worse, you chose this person, so you can't go to him to complain that now this person is doing X, Y, Z. I also liked the regional aspects of the consequences of our being in the East African Cooperation and what that would mean with disputes, having said that there's a free flow of capital. I will now turn again to our wise man from the East, Mr. John Ohaga, as our neighbor from the east of Uganda. You've been here this morning, and I'm sure you've interacted with Uganda before. You can see our effort to drive our ADR mechanism for dispute resolution. What would you say would be 2 priorities that Uganda should work on to turbocharge ADR? Thank you.
Thank you very much, Philip. Thank you for that question. Before I answer that question, let me just go back to an issue which was debated, but which I think debate was put to rest by the answer that there is no legislative impediment to foreign party representation. Having acknowledged that, I would like to say that in my view, that debate is purely academic and moot. It is academic and moot for 2 primary reasons. Any arbitration legislation that is based on the ancestral model will have a provision that says the parties can hold their hearing at any venue that they so choose, notwithstanding the seat of the arbitration. And we must understand the difference between the seat and the venue, so that if Uganda was the designated seat of the arbitration, there is no impediment to the parties designating Zanzibar, for instance, as the venue, if Zanzibar was open to foreign party representation. And even if it was open, there is nothing to stop a foreign party representative going to Zanzibar as the venue to deal with a Uganda-seated arbitration. Secondly, the advent of virtual hearings has also rendered this debate, in my view, moot, because it means that as an arbitrator sitting anywhere in the world, you can hear and determine a dispute and entertain submissions and arguments from a party representative appearing anywhere. I'm a chartered arbitrator, and I often entertain parties on a virtual platform, arbitrating their disputes from London to Angola to South Africa, irrespective of where they are located, providing you acknowledge where the seat of the arbitration is and you acknowledge what that means for the arbitration. So I just wanted to give my point on that. Now, with respect to the lessons that need to be learned, I do not think that there is any difficulty with the jurisprudence that emanates from our courts across the continent. When I look at the jurisprudence emanating from Uganda, from the Kenyan courts, they are all pro-arbitration. I think the difficulty is a process issue. There is a real difficulty, I find, in rushing through an arbitration 12 to 18 months and waiting 5 years to have your award finally recognized and enforced, or to have the challenge to your award finally dealt with. That is a process issue. And it doesn't matter whether the judge eventually comes out with a brilliant pro-arbitration decision at the end of that 5 years. The difficulty is that you will have stalled an arbitral process for which both parties have gone to significant expense to deal with as quickly as possible, and therefore I think that process needs to be dealt with. In dealing with process, I think we need to take the lessons from the jurisdictions that have been able to unlock and elevate arbitration to a forum that is highly sought after. So Singapore, for instance, or the UK, or the UAE, these are jurisdictions which have set up specialist courts, specialist divisions, so that not only do they have judges who are arbitration specialists, who understand the jurisprudence, the practice and procedure of arbitration, and all the rules regarding the enforcement of awards, the setting aside of awards, but they are also able to deal with their dockets in a quick and efficient manner, so that the arbitral process that moved quickly before the arbitrator finds a similar rate of speed before the court system. So that's number one, specialist, and number two, a fast-track process, which is, I think, one that relates to the desire or the willingness to allocate resources in order to ensure that both arbitration as well as other ADR mechanisms are supported as quickly as possible. Now, I've listened very keenly to the remarks by Her Ladyship and His Lordship. And there is always the criticism that accompanies arbitration, which is that because it is a confidential process and because it is held in private, therefore there is no jurisprudence that is available to other arbitrators, or it is difficult to establish the jurisprudence that accompanies those decisions. And I want to say this, in my experience, at the end of the day, parties have no interest in jurisprudence. It is lawyers and judges who are obsessed with jurisprudence and the way that they formulate the arguments around a piece of law, the interpretation of one over another. Eventually, parties want a process that has integrity, one that is quick, and one that satisfies the needs of the parties. So that if a lender knows that the borrower is indebted to it in X amount, and the borrower knows that it is indebted to the amount ascertained by the dispute resolver and can structure a payment plan, that is what the parties are interested in. No party is going to sweat over the decision, the jurisprudence, the question whether Section 35 was correctly construed, and so on and so forth. So I think we need to just be careful when we pat ourselves on the back and say how well reasoned that decision was. The party is only interested in it if it is in its favor. But in the end, this is why mediation is so attractive to parties, because mediation says to the advocates, you take a back seat and you allow the parties to engage directly and to be able to find a resolution that satisfies their needs. And that resolution may actually be one that is not does not emanate from the pleadings that were framed and were structured by the lawyers. I'm also a certified mediator, and there are many times as a mediator I've got parties arriving at a resolution that had no relation whatsoever to the pleadings that were put forward by the lawyers. This is a design by the lawyers, and sometimes in some ways we have to acknowledge that lawyers are a cartel. They hold their clients captive, and they try and structure it in the way that our training as lawyers tells us that we must pigeonhole the course of action. We must listen to the client and then try and find where that course of action fits, and then pigeonhole it and say this course of action is one for negligence or it is one for judicial review. Many times our clients have no idea what you've actually pleaded. And so when you sit in a mediation forum and the parties engage directly, you become alive to the fact that parties really just want to resolve their problem in a way that meets their specific needs. I truly agree that integrity of both the arbitrator and integrity of the process is primary. It trumps expertise, and it trumps the time that it takes to resolve a dispute. If a party feels that in one way or the other, the process by which a decision was reached was one that does not uphold the tenets of integrity, then that party will reject that decision, whatever the outcome. However correct that decision might be in law, that party will reject it. And so that is my experience. There are other things that I would like to talk about, but I know that we are short of time, and so thank you very much, Philip.
Thank you very much, John. That was very insightful and very cutting. The members of Uganda Law Society, how are you feeling? A bit hot around the collar. I think professionally we have had challenges. Yes, the client comes and says, I have this pain and that pain and that pain. Yes, and then you must think and say, okay, let's go to the civil division. Let's go to that, pigeonhole it, yes. And then sometimes we lose and think we should appeal. And we persuade the client we must appeal because they are good points of law, and you can make jurisprudence, you can make the precedent. And now we are hearing, does the client want to make law? Is that the client's interest? Whose interest is it? Yeah, it is. To make law is the jurisprudence. Who wants jurisprudence? Who wants to go down in history as having set path-breaking litigation? It is us. The client wants resolution for their dispute and to resolve it with integrity. Very, very insightful. We thank you very much. I'll come back to Angelina. DFCU Bank, you mentioned speedy resolution of disputes. We also heard about confidentiality of the dispute resolution processes. We've also heard about other advantages of arbitration. Could you comment on other priorities you have when you're looking at dispute resolution? Thank you.
Thank you, Philip. I think going to what my lords have indicated, for us, any resolution of a dispute which supports us to get out of any dispute as fast as possible is always welcome. So I was very happy when my Lord Stephen Mobiru indicated that the processes are complementary. So I'll be coming to the courts to seek support in resolution of some of our cases, because the view that we hold is that many of these disputes, especially those in banking and finance, really should not be in any court of law. These are disputes which can be settled outside the courts, because you find, for us, for banking, which is what I understand, if you come to the bank to borrow money, you've either borrowed or not. But clearly, in most instances, we'll admit that money was borrowed and was taken. So for me, the expectation from the court is, that is the question we put first to our borrowers. Did you take the money or not? Whether the interest applied was high or low, or you've been paying additional costs, that is secondary. I think the first issue to resolve is whether money was taken or not. And I think this one, my lords, it's something we can really address in the first 5 minutes of us entering that courtroom, that money was taken. And then we can deal with the other supplementary issues. I think for us, as John has indicated, we are not out to make precedent. We are out to get money back so that we can free up that money to be in a position to give it to other people to spur this economy. That is the interest, ultimately, that we are looking at, Philip. So I think one of the challenges that has come up and which has been well articulated is the fact that the fear of this process of arbitration around issues related to integrity, issues related to costs, issues related to the venue. So many times, and I think what we are hearing is Singapore, the UK, but why would we go to Singapore and the UK? Why? Why not Uganda? You know? Ultimately, I think what we need is to look at the lawyers here. I know that we've been challenged about making precedent, but we also need to diversify into areas which can grow us, and arbitration is one of those. So I think for me, the key challenge for us is how do we make Uganda a destination for arbitration? If we are making Uganda a destination for foreign direct investment, it just follows that we should be a destination for ADR, because we want to ensure we don't hold up these funds. So I think for me, the key outcome for me here is how best do we get the support from the judiciary to be in a position to resolve disputes quickly. I've had a case, for instance, which has gone through the entire court process. It was in the High Court twice, before it was before a judge, referred to mediation. Thankfully, the judge who mediated did it very well. We ended with a good decision, although the decision, we had to spend a whole day in court, but we got the outcome. Then the borrower decided that no, they didn't agree with the judge. They needed to have the decision reviewed. Of course, the High Court was not going to overturn the judge's decision. The matter then went to Court of Appeal and sat at the Court of Appeal for 7 years with no traction at all. So finally, at the Court of Appeal, it is decided, it goes out, it then went to the Supreme Court. And as it went to the Supreme Court, it also went to the Constitutional Court, because now the borrower also needed some questions of the Constitution determined in a matter where they had borrowed money. So ultimately, at the Supreme Court, we reached a conclusion through mediation. You can imagine, having gone through the entire process 12 years down the road, and having gone through all tenets of the various courts. So you can imagine holding up these funds. So I think for me, the key challenge for all of us is how do we get support from the judiciary to resolve some of these issues as quickly as possible and get out of the court process. So mediation, encouraged by the courts, is also welcome, and we'll look to the courts. I think for me, Philip, the cost is always going to be secondary. The speed is going to be the most important aspect of any dispute resolution. And I think, as my lords put it, the process itself needs to be enhanced. We need to ensure integrity of the process. We don't want parties to debate whether the arbitrator was fair or received an envelope in the back. So it's quite critical for us. We need, because ultimately the position is final and it's binding. But I think for us to get that route, there's a lot of training that we need to do as well. I think that's an issue that has been properly highlighted here, not only for the lawyers, the bench, but also some of our enforcement agencies. Many times I doubt whether if I took an arbitral award to the police and told them this is the award we are supposed to be enforcing, if they don't see court order there from the High Court, Supreme Court, then I might have challenges enforcing even that particular order because they have no idea about this. So I think for me, the capacity building goes beyond just the lawyers, but also needs to get to some of our enforcement agencies, local councils, and the like, because arbitration is something I think we've had in our own, in the country for years. It's been there in the north. We had the Matoputs, which were closing out some of the issues in the north. So it's something that we know. Ultimately, it is how quickly we can be able to resolve disputes. So speed for us, Philip, but integrity of the process, integrity of the people is always going to be critical for us in the financial industry. Thank you.
Thank you very much. Thank you very much, Angelina. Our program has come under a little bit of pressure, so we will be wrapping up in about 5 minutes. I will ask Honorable Justice Mobiru and Honorable Justice Mugenyi to be the final speakers. And the last question for Honorable Justice Mobiru, whom I must say, with little fear of contradiction, has had the most rulings on the subject of ADR in the commercial court. Whether it be about drafting an arbitration clause, I think it was from his ruling that I had about a pathological clause. And I said to myself, but I thought pathology, I left in S4 biology, now it is coming back at me. So from that to enforcement, to setting aside, to arbitrator misconduct, it's been really, really insightful reading from Justice Mobiru. Now, Honorable Justice, again, I'm going to set you up. We have heard from the Law Reform Commission that they reviewed the Arbitration Act and made recommendations for amendment in 2021, and it is packed with the Attorney General. We shall hold the Attorney General to account, okay, on that. What have they been doing with this report since 2021, okay? But for you, Honorable Justice, would like you to say maybe 3 things that lawyers and their clients should be doing differently when approaching ADR. 2 or 3 things that they should do differently.
Thank you very much. Now, I think the role of the lawyer begins with the drafting of the submission to arbitration. I've observed there's a tendency to use boilerplate clauses which don't address the type of controversies that usually arise in very complex matters. I think a lawyer drafting a clause at that stage should try to anticipate the type of disputes that are likely to arise and ensure that the clause covers at least the majority of them, or all of them if it is possible. Then secondly, I've seen attempts to raise points of law as a basis for setting aside awards. The advocate is struggling between enforcement of what he believes is a wrong decision on matters of law, but which is not as fundamental as required for the court's intervention. Therefore, it is advisable to reserve such matters if you intend to challenge an award on points of law, that you do so by making a reservation in the arbitral, in the agreement, submitting disputes to arbitration. Now, the other one, advocates should, I think, be alive to the fact that at the commercial division right now, the quickest route to have an enforcement of an award is to challenge it on frivolous grounds. Because if there is no challenge, the successful party will wait for 90 days. You make a frivolous challenge, you have enforcement within a month. That is the standard we have. Our decisions on such matters don't exceed a month the moment you file an application to challenge it. And once the application is done, the enforcement follows quickly. So avoid filing frivolous applications, for setting aside, for challenging awards, if you want to buy time, because you have 90 days in the law, you reduce it 1 month when you make such a frivolous attempt. Thank you so much.
Thank you. Thank you. Thank you very much. That is, again, most insightful. I hope our team, Dr. Nora from ICAMECK, are listening about this capacity building, drafting the clauses. I think some of your materials you've circulated have got the standard submission to arbitration. Yes, we now move to our, fittingly, the final panelist, Honorable Justice Mugenyi, and would invite her to comment on the advice from our wise man from the East, who talked about a specialist court, a specialist setup to hear arbitration matters. Honorable Justice Mugenyi.
Thank you, Philip. A specialist court has its pros and cons. Of course, administratively, it puts up the costs of administration of justice because it's a tag on the consolidated fund. However, I think borrowing from the Nairobi Center for International Arbitration, there is a court that is set up by the Act that set up that center, if I remember right. And that court addresses the specific challenges that could have gone to the ordinary courts. However, issues arise there. Would the members of the court have judicial immunity? Would they be clothed with the powers of a high court judge? Do they have sufficient, is there sufficient vetting before they get into this court? Do they have the competences to preside over these courts? All sorts of issues arise there. But I think, ideally, if judiciaries can have a specialist division within their fold, for instance, the commercial court, but then assign specific judges to address matters of judicial support to the arbitration process, that might be more cost-effective and effective in the long run, because at least then you have special judges who are trained in that area, looking at challenges that come to the arbitration process, to the courts of judicature. Thank you.
Thank you all for your patience. Thank you to my panelists, my very distinguished panel. Please give them a big hand clap. I don't know if that song Nera Nera is still on fashion, is it? Oh. We must do this again sometime. I thank you all.
All right, ladies and gentlemen, let's appreciate the panel, Mr. Philip Karugawa, for a great work well done. Thank you very much. That was insightful, that was educative, that was informative, precise, concise, to the point, and accurate. Let's once again appreciate them for the good work done. So we are transitioning into the next item, which is brought forward from the morning session, and that is the official opening of this important National Alternative Dispute Resolution Summit 2023. Parties are not interested in jurisprudence, only judges and lawyers are. All that parties need is quick resolution of their dispute. John Ohaga of Kenya. That is the statement of the day. At this moment, I would like to welcome our CR, the Chief Registrar, to come and take us through the next part of this program. Let's welcome Madam Sarah to come and take us through the next session where we are doing the official opening of this summit. Are you saying she's welcome?
Thank you very much. At this point, sugar levels are very low, and that's a matter of fact. But I'm requesting all of us to endure for at least the next 45 minutes or 1 hour, because Her Excellency, the Vice President, is just around the corner. She suspended cabinet in order to come and open. And so looking at our numbers, if we risk to go and eat there will be nobody here when the opening ceremony starts. So it's on that note that I request we take a little bit of the water in front of us. And as we settle in and do the arrangements for that ceremony, you'd like to make a telephone call in our centers, not so far from here, you can go and do that one. Just in 5 minutes, you come back and we handle this session. Forgive us, but when you eat, you will surely enjoy the meal, and it will be worth the wait. So let us take a small, very short health break just to attend to those calls we may want to make and be comfortable for the next opening ceremony, which has only 3 remarks. So it is not a long one, don't worry about it. Let's just be in the spirit of ADR. And with this kind of program, you will never forget that you attended it. You will always say that one where we didn't eat on time, but it will be very, very worth it. So, my lords, your worships, ladies and gentlemen, in all your distinguished capacities, you're most welcome. I'm going to, as we take the break, I'll just be talking about those who have attended here as well, so that in case you don't see them after the ceremony, you know they were here. We had our sponsors, Diamond MTN, Uganda Limited was present. MTN, thank you very much. We also had and those were the Diamond sponsorships. The Ruby sponsorship, we had Virunji, Barata and Associates, thank you very much. Max Advocates, thank you. ALP East Africa and Bank of Uganda, thank you so much. We also had the silver sponsorship, that was NSSF, Legalmark, Advocates, Kampala Associated Advocates, S&L Advocates, Nangwala Resida and Company Advocates, Otis Advocates, and ENS Africa. Those were our silver sponsors. We recognize you and we do thank you very much. Let us give a round of applause to them. The partners for this summit, we had Uganda Bankers Association. Thank you so much. IDLO, we already appreciated you. We had Sweden, thank you so much. Pepperdine University, we have already talked about you. Thank you so much. We also had our UN resident coordinator, Ms. Luta Saba. Thank you for being with us. The Uganda Christian University was also represented. The dean was represented by Ms. Lydia Kakoza. We welcome you and take note of your presence. The chairperson of Uganda Bankers Association, she was already recognized early, but Ms. Sarah Arapta, once again, we appreciate that you have been with us. Mr. Wilbrod Owor, CEO Uganda Bankers, he was a panelist, and we do thank you for being here with us. From the Institute of the Surveyors of Uganda, we had Aloysius Gonza, the president of the Institute of Surveyors of Uganda. Thank you so much. We recognize you and for the work that you do in helping us resolve particularly land matters. We also had the president of the Uganda Institute of Professional Engineers, Engineer Andrew Muhwezi. We do recognize you and truly appreciate your presence. We had Engineer Isaac Mutenyo, the chairperson of the Engineers Registration Board of Uganda. Thank you, and thank you so much for being here with us. And all of you who have endured, you're most welcome. So once Her Excellency is here, we will go straight into the ceremony of the opening of this summit. We will have anthems, we will have the remarks, and after the official opening, we shall also have anthems. So that is our program. So the moment is here. I request we all arise as we wait to receive Her Excellency, led by the Honorable Minister of Justice and Constitutional Affairs, the Honorable the Principal Judge, the Honorable the Deputy Chief Justice. They are just out there, I can see them. You're most welcome. Your Excellency, we welcome you. My Lord, the Honorable the Deputy Chief Justice, you're welcome. We will all remain standing and have the anthems played. May we please take our seats? Your Excellency, the Vice President of the Republic of Uganda, my Lord, the Honorable the Chief Justice, who is with us online, My Lord, the Honorable, the Deputy Chief Justice, my Lord, the Honorable, the Chief Justice Emeritus, who is present with us, the Honorable Minister of Justice and Constitutional Affairs, my Lord, the Honorable, the Principal Judge, my Lord, the Honorable Principal Judge Emeritus, my Lords, the Justices and Judges present, the President of the Pepperdine University, all of you distinguished participants, both physical and online, allow me to take on the protocol that we earlier observed and recognized. And ladies and gentlemen, I welcome you very warmly to the opening ceremony of this summit. Your Excellency, we are very thankful and we welcome you. Thank you so much for sparing time to come and open this very, very important summit. Let us appreciate Her Excellency. Your Excellency, briefly, the day has started and we have had a couple of remarks and presentations that were already made, the highlight of which was the keynote address that was delivered by President Jim Gash of the Pepperdine University under the title, Transforming Uganda into an Attractive ADR Destination. We have had very interesting discussions, and before you, members, distinguished from very, very different segments of government, civil society, and also the public. And so we are going to proceed into the remarks that we have for this ceremony, Your Excellency, before you can open it. And to start us off is going to be the Honorable Minister of Justice, who is going to make his remarks. Honorable Norbert Mao, you're most welcome to make your remarks. Thank you.
Your Excellency, the Vice President of the Republic of Uganda, my Lord, the Deputy Chief Justice, and the Chief Justice online, the Principal Judge, President Jim Gash, and the entire team from Pepperdine, my Lords, and I also recognize the Chief Justice Emeritus and Principal Judge Emeritus, all the members of the bench, our co-sponsors, co-organizers, partners, dear friends. These remarks are intended to inform you that our guest of honor is aware of what we are doing. 2 weeks ago, I requested her in her capacity as the chair of the cabinet to put the alternative dispute resolution policy on the agenda of cabinet, and she directed that it should be done. Due to some minor glitches, the cabinet memorandum, which is supposed to accompany the policy, was not ready. As the minister, I take responsibility for that. As President Truman used to say, the buck stops here. So the buck stops with me, Your Excellency. But we do believe that very soon we shall bring the cabinet memorandum together with the policy for the approval of cabinet. Your Excellency, before you is an array of key players, the people who drive the Ugandan economy, the people who are at the center of promoting disputes, settling disputes, those who fish in troubled waters, those who calm the waters, those who trouble the waters. We are all here, Your Excellency. we also have people who are not necessarily at the center of money disputes, but people who also represent institutions who have been at the center of disputes that have defined our history. I'll just single out one, Your Excellency. I'd like to ask the Attorney General of the Kingdom of Buganda to stand up. Your Excellency, as you know, the titanic conflict between the Kingdom of Buganda and the government of Uganda has cast and continues to cast a very long shadow over our politics. Our history would have been different if the then Prime Minister Milton Apollo Obote and the then President of the Republic of Uganda, who were both very young men at the time, had considered alternative dispute resolution. The history of Uganda would have been different. Our president also disagreed strongly with the manner in which the elections of 1980 were conducted, to the extent that he took up arms. Alternative dispute resolution was not considered. As I talk now, Your Excellency, we have a war going on in Ukraine. The war has given birth to another war between one of the parties and his allies, who a few days ago were carrying out a demonstration marching towards Moscow. Now, when people are demonstrating while heavily armed, carrying guns instead of placards, that can easily destabilize the world, especially if the country has a huge stockpile of nuclear weapons, and if they land in the wrong hands, it can drastically plunge the world into chaos. We are therefore gathered here not to tell our courts that we want to bring a substitute system. We are simply asking the courts that, in line with our constitution, allow the people to participate in the resolution of disputes. And that's why today we are talking about conciliation, mediation, and arbitration. We believe very strongly that we must lay a foundation for that alternative dispute resolution. For that reason, Your Excellency, there's a partnership which has lasted about 15 years between the judiciary of Uganda and also the Ministry of Justice and the government of Uganda, with a university based in the United States of America, in the beautiful oceanside city of Malibu. That university is known as Pepperdine University, and there's a delegation led by the president of that university, who is seated to your left, Your Excellency, Professor Jim Gash. They will later let you know that they intend to build a campus in Uganda, because even if you have a good cause, you must build an army to fight for that cause. We therefore will need an army of alternative dispute resolution practitioners to promote alternative dispute resolution. And Pepperdine University has promised to work with us all through these processes. And he will introduce the team from Pepperdine. They have already been working with the judiciary, promoting what we know as plea bargaining. And that is why, Your Excellency, for the first time in the last few years, we have more people in our prisons who are actually convicted as opposed to the case when we had more people on remand than those who are convicted. Your Excellency, since I became your Minister of Justice and Constitutional Affairs, I've observed that the judiciary has become one of the most innovative institutions in our state structure. Finally, Your Excellency, we need speed in the resolution of disputes. We have been informed by key players from the legal professionals, people who are in charge of real estate companies, those who own organizations that resolve disputes, that, Your Excellency, we have 8 trillion Uganda shillings tied up in commercial courts because of disputes that are not ending. Through alternative dispute resolution, this money will be released into our economy. We need this money badly, especially these days that we have some disagreements with our international partners over our insistence on our culture. We have enacted a law which has not impressed many of our partners. We believe they have misunderstood the law. We believe the international media organizations have misrepresented the law. We believe that there are those who simply don't want to understand. So they may want to punish us by trying to attack our economy. But we have money in our economy, and most of that money is stuck in the court systems. Through alternative dispute resolution, that money will be released into the economy, and we will be able to have the means to develop our country while we continue with the ADR discussing the disagreement that we have with our international partners. We believe that Pepperdine University will be on our side to talk to the American government and tell them that Uganda is not homophobic. There are no people running around with knives and spears and axes hunting for homosexuals. Definitely our president and you yourself, Your Excellency, I don't count you among homophobic people. I cannot quote a single word you have ever said which sounds as homophobic. We are simply trying to protect the boundaries that will ensure that our next generation are properly aligned to our culture. The opportunities are immense, Your Excellency, in dealing with the disputes that we have. This conference will also see the launch of some books. There's a book written by a judge. This conference has been collaborative, and we want to single out the International Development Law Organization, IDLO, which is an intergovernmental body that has been a major supporter, a sponsor of this process, alongside Pepperdine University, the Uganda Bankers Association, and many other sponsors whose names I cannot mention all. Your Excellency, we do not see Pepperdine University, the Bankers Association, and even the IDLO just as sources of money. We want to assure our partners that we don't just see you as an ATM from which we get money to organize conferences. Okay, you are a money bank, but you are also a bank of ideas. We have listened to very, very good presentations from those who lead our banks, and we are convinced that there are lots of intellectual resources in those institutions. The conversations will continue so that we end up with the best possible environment. Your Excellency, I'm also a student. I'm studying a master's in dispute resolution. I think I need it badly because I've been at the center of many disputes in my political life, in my political party. The Chief Justice is a student, the Deputy Chief Justice is a student, but let me just ask the class, the MDR class, to stand up so that, Your Excellency, you know that we are not afraid of going back to school to train. May I ask my classmates of Pepperdine MDR to stand up. Your Excellency, we are 11, and it will probably amuse you that organizing this conference is part of our coursework. It is actually our assignment, and you will see us very active tomorrow as we try to share what we have been taught. I think our professors are here. We have Professor Selina and Professor Jack are here. I think they will be watching whether we perform well tomorrow, because we are not supposed to prove that we have been good students. And we are praying very hard that we don't embarrass our professors tomorrow. I told Professor Selina about a character known as Tom Sawyer, who was in a class, and the class hosted a clergyman. And the teacher told the clergyman that the students had mastered their scripture. And then the clergyman asked a question: who were the first disciples Jesus chose? And the entire class put up their hands, but the teacher was suspicious that Tom Sawyer may not get the right answer, given his antecedents. Unfortunately, the clergyman picked Tom Sawyer, of all people, and the book says the teacher's heart sank. Tom Sawyer then gave his answer as David and Goliath. I pray that we don't have a Tom Sawyer moment tomorrow as we struggle to impress our professors. Everybody in the class is suspicious that I'm the Tom Sawyer. But I intend to prove them wrong. Your Excellency, we welcome you most sincerely. We know you have just left cabinet where you were presiding. And I now wait to be directed who I should invite next. By virtue of the authority entrusted to me, my Lord, the Deputy Chief Justice, the Honorable Justice Richard Butera, who has been leading us to organize this, especially with the CJ being physically absent, I now want to invite you to come and make your remarks, and thereafter invite the Chief Justice. My Lord, the Deputy Chief Justice.
Your Excellency, the Vice President, Honorable Minister, we had been advised that protocol was adopted by the Chief Registrar, and we had agreed that for this conference, we know the protocol. Your Excellency, allow me to adopt the protocol that the Chief Registrar had outlined. Your Excellency, the people gathered here are judges from Uganda. We have legal practitioners. We have our partners in development. We have bankers, insurance, and other members of the business community. The purpose of this conference was to work together with all these people on the proposals of the alternative justice strategy by the judiciary and the alternative dispute resolution mechanism by the Ministry of Justice, which will be approved by Cabinet, but for now to be discussed by this gathering. And whatever we come up with is what shall be implemented in the country. There may be areas of reform, there may be areas of developments of the law, but the discussion will approve these programs for implementation. For now, let me first of all be thankful that the Chief Justice is able to join us online and to address us, and welcome you at the conference, Your Excellency. My Lord Chief Justice, we are happy to be with you here online, and we are happy to listen to you, and I invite you to address this meeting. My Lord, you are welcome.
I believe I'm being heard. Your Excellency, the Vice President of the Republic of Uganda, my Lord Deputy Chief Justice, the Honorable Minister of Justice and Constitutional Affairs, my Lord the Principal Judge, my Lords the Justices and Judges of our Courts of Judicature, Chief Justice Bart Katrebe, Your Excellencies the Ambassadors and other members of the Diplomatic Corps, and at this point, permit me and forgive me for adopting the procedure taken by my predecessors this morning. I adopt the protocol which began with the Honorable Chief Registrar this morning. It is a great honor and privilege to welcome Your Excellency, the Vice President of the Republic of Uganda, representing His Excellency the President, to the first high-level National Alternative Dispute Resolution Summit in Uganda. I profoundly thank you for finding time amidst your definitely crowded schedule to honor our invitation to grace this summit. I recognize and hail our development partners who have always made robust contribution to us in the quest by the judiciary of Uganda to execute our constitutional mandate to accord justice seekers in Uganda meaningful access to justice. And similarly, I do recognize our esteemed friends, distinguished guests, and valuable facilitators. I thank you all for accepting our invitation to attend this first high-level national summit on ADR. I take this opportunity to single out and specially welcome the President of Pepperdine University, Professor Jim Gash, and the Vice President and Chief of Staff, Pepperdine University, Professor Danny DeWalt. Pepperdine University has made a tremendous contribution in the enhancement of criminal justice process in Uganda. It's a key player in the pursuit of the alternative justice dispensation regime for which we have this conference. Together with the Honorable Norbert Mao, Minister for Justice and Constitutional Affairs, we have convened this first high-level national summit on alternative dispute resolution in Uganda, in partnership with Uganda Bankers Association, Pepperdine University, and International Development Law Organization, IDLO. This conference is a momentous event for Uganda because it is the crystallization of a paradigm shift in the administration of justice, with the enviable potential to trigger a revolution in the administration of justice in Uganda and beyond. The theme of the summit is, open quote, the role of ADR in transforming Uganda's dispute resolution landscape, close quote. This theme is expected to speak to ADR's stakeholders and sectors in Uganda, to wit, business, banking and finance, construction industry, extractive industry, etc., which have now morphed and grouped into associations and are now clearly defined in terms of industry or sector. These industries or sectors as associations will inevitably position ADR as the logical dispute resolution mechanism of choice. The theme will also challenge the different stakeholders to rise to the occasion and make meaningful contribution to position Uganda as an attractive ADR destination. The concept of alternative dispute resolution in Uganda is familiar to many, yet it continues to be misunderstood and is restricted in its application. The basis for ADR regime in Uganda is in the provision of Article 126 of the 1995 Constitution of Uganda. And this is captured in many other statutes, including the Judicature Act, Chapter 13, Laws of Uganda. However, the enactment of the Arbitration and Conciliation Act, Chapter 4, Laws of Uganda, has streamlined the practice of ADR mechanism in Uganda. The Judicature Act recognizes arbitration, conciliation, and mediation as forms of ADR, which have gradually been infused into the court system. In particular, mediation was first introduced as part of the court process with the Judicature (Commercial Court Division) Mediation Rules 2007. With the noted successful application of these rules, it was introduced to High Court and the Magistrates' Courts under the Judicature Mediation Rules 2013. The court annexed mediation remains a prerequisite stage in an integral part of court process. Indeed, in many instances, cases are successfully and conclusively settled at this stage. The ingenuity of courts embracing ADR mechanisms have resulted in more satisfactory dispensation of justice. Its use is an essential case backlog management tool. This is pertinent since case backlog remains a malignant thorn in the administration of justice. The annual judicial report for 2021/2022 shows that case backlog standing at 50,592 cases, which is 30% against 168,000 pending cases. With regard to arbitration as an ADR mechanism, there has been a steady growth over the past 20 years. It has been bolstered by support from private entities, including ICAMECK, which has given birth to the CIR Uganda chapter. On its part, conciliation in Uganda has, however, not been widely used. And for this, different stakeholders have called for an amendment of the Arbitration and Conciliation Act to introduce detailed and more workable provisions. Against this background, a Hague Institute for Innovation of Law, acronymed as HIL, Justice Needs in Uganda report of 2016 revealed that courts and lawyers are marginal to the experience of day-to-day justice needs of Ugandans. The report made the alarming revelation that less than 5% of dispute resolution in the country takes place in a court of law. And more worrying, that lawyers are involved in less than 1% of all cases before court. It made the further revelation that most Ugandan citizens rely on informal justice processes. The report accordingly recommended the adoption of the ADR mechanisms as the preferred means of resolving disputes in a fair manner if we are to ensure that justice seekers in Uganda are afforded access to justice. It is evident that the relevance of the ADR in its entirety cannot be overemphasized, given the monster of case backlog stuck in our courts. There is therefore a great need for the reinterrogation of ADR mechanisms to speak to multifaceted litigants and disputants who seek the resolution of the ever-growing, wide-ranging, and complex disputes. Court litigation with its adversarial nature usually destroys relationship between the disputants. Parties would prefer a dispute resolution mechanism that maintains mutual relationship. Furthermore, beyond serving as the framework for resolving commercial or business-related disputes, including regional and cross-border disputes, ADR is notably finding itself as the mechanism for resolving complex disputes with traditional societal underpinnings. The best example is with regard to land disputes. Compared to other jurisdictions, ADR in Uganda is only taking shape now. For instance, the 1958 New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards was ratified in Singapore in the 1980s. In 1991, the Singapore International Arbitration Center, SIAC, was established. This was followed by setting up the Singapore Mediation Center, SMC, in 1997. Owing to this development, Singapore has improved access to various ADR options to resolve disputes. Singapore's success in the application of ADR has resulted from the government having aligned the country's national legislation in this regard to accord with international standards. The Singapore government's enthusiastic support, partnered with backing from senior members of the judiciary over recent years, has also driven the city-state's embrace and successful application of the ADR. I therefore seize the opportunity of this ADR conference to call on and urge the government of Uganda to make a robust and well-directed intervention in the promotion of ADR. For instance, by giving incentives to ADR practitioners where all cases against governments are first handled through ADR, as this would save the government a lot of money. There is need for curriculum review and development in legal education and training. There is equally need for relentless national capacity building and strengthening application of ADR in the private sector institutions. I'm glad to learn today from the Honorable Minister of Justice and Constitutional Affairs, despite his faltering, for which he said mea culpa, that the issue of ADR is already before Cabinet, and when the Minister puts his house in order, the Cabinet of Uganda will be able to discuss this matter. Your Excellency, I urge the Cabinet to have wide consultation with stakeholders, the judiciary, private sector, traditional leadership, religious leadership, etc., so that we come up with an alternative dispute resolution regime which takes care of our need, which understands and responds to our need. To members of the legal fraternity, I should point out that litigation has fundamentally metamorphosed in recent years. Parties desire to keep or restore their relationships after the resolution of each dispute. It is thus inescapably incumbent on lawyers and other justice actors to reskill themselves and seriously invest in ADR, which is certainly an irreversible justice mechanism phenomenon. There is also need for the Africanization of the judicial system to adapt to traditional justice needs. The current system of justice is not African. Although they refer to the African justice system as the alternative, I have always protested and said it is the African justice system which is original for us. The one which was introduced and imposed by colonialism is the alternate dispute resolution mechanism, which was today found wanting, and in adopting ADR, we are simply going back home. We're simply going back to a system or a mechanism which resounds meaningfully with our people. So the current system of justice is not African. We practice it for the past 100 years. And one of its most notable characteristics is the undesirable case backlog situation, which shows no sign of going away. Africanization of administration of justice through ADR provides a quick and timely resolution of disputes, eliminates the use of middlemen, and reduces transactional costs. Therefore, courts must move from the mindset of guarding their jurisdiction jealously to opening it up to alternative dispute resolution mechanisms. The average caseload per judge in Uganda High Court is now 945 cases. Each judge of the High Court, on average, has to attend to 945 cases. It is not humanly possible for any judge to handle 945 cases with the speed and perfection that is desired in rendering justice. However, this can be significantly reduced if ADR is employed intensively. The need for a paradigm shift in the mechanisms for administration of justice is better brought out when we take cognizance of the fact that as we speak now, trillions, the Honorable Minister has told us 8 trillion, trillions of Uganda shillings are locked up in the commercial division of the High Court alone, with a huge chunk of this arising from disputes that involve the banking and other financial institutions because of the ineffective traditional mode of litigation we have in place as the core of our dispute resolution mechanism. The state of affairs is even exacerbated when we include the situation obtaining in land disputes, in the land division, in the High Court circuits, and in the magistrates' courts. There is simply no way, Your Excellency, that Uganda can be an investment destination when investments are either inordinately delayed or locked up altogether in unending disputes. And this speaks to the need for the government to play a central role in seeing to it that the ADR mechanism is well rooted in the country as part of our justice mechanism system. It is important to note, and this is quite instructive, as I'm made to understand, that in the United States of America, the biggest economy in the world, 95% of civil disputes are resolved through the ADR mechanism. 95% are resolved through the ADR mechanism, while as high as 98% of all criminal justice processes are determined through this mechanism. The obvious reason for the migration from traditional mode of litigation to the ADR in the United States of America is not difficult to come by. Can only have been due to the stark contrast between the two mechanisms in favor of the ADR. With regard to the alternative justice system strategy that is being launched today, I should point out that this year's theme for the judiciary is, in quotes, the judiciary transformation agenda, enhance access to justice. The transformation agenda of the judiciary was triggered through the enactment of the administration of the Judiciary Act 2020, which operationalized Chapter 8 of the 1995 Constitution, strengthened our independence, and streamlined the management of finances in the judiciary, among other key features. The judiciary transformation agenda is geared towards enhancing access to justice services across the country. To achieve this dream, we are guided by the Judiciary Strategic Plan 5. The Judiciary Strategic Plan 5, which runs from 2021/2022 to 2024/25, under Strategic Objective 2, it identifies the need to strengthen ADR mechanisms as one of the critical measures that should be implemented. And then in a bid to realize this objective, the judiciary has embarked on legal and judicial reforms aiming at strengthening and promoting a broader ADR framework. The proposal to develop a broader ADR framework for the judiciary, alternative justice system, is anchored in the 1995 Constitution of Uganda, recognizing respect for culture, norms, and values in line with fundamental rights and freedoms as enshrined in the Constitution. These cultures, norms, and traditions of societies are central in facilitating the expeditious and cost-effective resolution of disputes if guided by a policy framework compared to the current adjudication framework, which is unnecessarily technical, complicated, characterized by high cost, and is adversarial, thus leading to congestion with the resultant massive backlog situation we witness now. The foregoing diagnosis of the justice system makes a strong case for an alternative justice system as an anchor for informal justice dispute resolution process. A broader ADR framework necessitated developing a strategy that complements ongoing efforts to reform state justice institutions, hence the alternative justice system strategy. Against this background, I realized the need to constitute an ad hoc alternative dispute resolution committee of the judiciary under the chair of the Honorable Deputy Chief Justice, Richard Butera. The committee, comprising the pioneers of the online Masters in ADR program, courtesy of Pepperdine University, has made proposals that informed the alternative justice system strategy that will guide the ADR approach of the judiciary. The committee comprises the following: Honorable Justice Richard Butera as chair, Honorable Justice Mike Chibita, vice chair, Honorable Justice Geoffrey Kiriabire, member, Honorable Justice Paul Gadenya, member, Honorable Justice Richard Wabire Wijuli, member, Mr. Francis Atoke, Solicitor General, member, Mr. Francis Gemara, Senior Counsel, member, Ms. Rachel Odoi Musoke, member, Professor Andrew Kauka, secretary. The AGS strategy has been developed to include more institutions and forms of ADR to ultimately optimize the delivery of justice to all justice seekers in Uganda with the following objectives: serve as a toolbox for enhancing access to justice for all, provide for and support ADR mechanisms, including traditional approaches and institutions, serve as a case backlog reduction, caseload management measure as a critical objective of the existing ADR framework, in, for instance, court-annexed mediation, empower or enable particular sectors or communities, for instance, private or business sector, in terms of expert-based justice rendered relevant to the community or sector. Localize justice and justice delivery and inculcate an ownership principle with users of AGS, pathways, and processes, embracing them as their own in resolving disputes. Create a framework that promotes ADR as a vehicle for the timely resolution of disputes while preserving critical relationships. The AGS has been finalized and will be launched during this summit together with the national ADR policy. I urge you all to open your minds to learning from this summit, as it will offer knowledge and capacity building. This summit will also ignite an assessment of the place and role of ADR in Uganda in light of utilization and emerging national, regional, and global trends. The summit has brought together national actors and stakeholders in the justice system, public institutions and agencies, and the private sector, such as representation from the judiciary, Ministry of Justice and Constitutional Affairs, Uganda Law Society, Uganda Law Reform Commission, deans of law schools, Uganda Bankers Association, and selected members from professional bodies, among others. The Pepperdine University is organizing an international Pan-African Summit of Chief Justices from Africa to be held in the Pepperdine University campus in Switzerland next year, 2024, in the month of June. It is our desire and hope that prior to this, we'll have held an ADR conference in Uganda, which will bring in actors and stakeholders from all over the African continent. This should then feed into the conference in Switzerland and bring Uganda to the fore as a continental leader in driving the ADR justice mechanism revolution. To this end, I will task the Deputy Chief Justice, Butera, and the Honorable Minister of Justice and Constitutional Affairs to come up with proposals for the realization of the All Africa ADR conference to be held in Uganda. I am greatly indebted to Ms. Barbara Kiley, country representative of International Development Law Organization, IDLO, Her Excellency Maria Atkinson, the Ambassador of Sweden to Uganda, Pepperdine University, Uganda Bankers Association, and other partners. For it is the respective and collective support you have rendered that has made this summit possible. I would like to reiterate my appreciation to all participants for sparing valuable time to attend this important summit. I pray that you fruitfully use this opportunity to learn and help advance the case and practice of ADR in Uganda. For me, let me say this. I have made a pronouncement. I have vowed to myself that upon my retirement, which is not too distant, I will settle in the countryside to promote ADR. And in this regard, the Justice of IDLO Foundation is doing everything possible to put up an ADR center in Gulu, where I will be based and from where I will crisscross the countryside to promote alternative dispute resolution as the way forward in resolving disputes. So I will have to be dragged to come to Kampala for whatever function. I allowed the organizing committee under the chair of the Deputy Chief Justice for their tireless zeal and commitment, which is evidenced by this conference, which so far has gone very well. I thank you all for listening to me. May all of you be blessed. Thank you. Your Excellency, permit me to exercise this singular opportunity to invite you to address this congregation of justice stakeholders. You're most welcome, Your Excellency. Thank you.
Your Lordship, the Alphonse Owindolo, the Chief Justice of Uganda, the Honorable Richard Butera, the Deputy Chief Justice of Uganda, the Honorable Minister Norbert Mao of Justice and Constitutional Affairs, the Principal Judge,
In a special way, let me recognize the Chief Justice Emeritus, Bat Katurebe, and also the Principal Judge Emeritus. Someone was very correct to say we really do not want to say so many protocols here because it's difficult to align them well. So I want to thank you all the Chief Justices of Supreme Court, Court of Appeal, High Court, heads of constitutional commissions, and heads of statutory bodies, Excellencies, the ambassadors, the president of Pepperdine University and your delegation, all distinguished invited participants. Let me agree with the Honorable Minister that I think a fortnight ago, he came to Cabinet seeking clearance to host this summit. And I want to congratulate him for hosting this successful National Alternative Dispute Resolution Conference. I congratulate you. It's already successful. We missed you this morning in Cabinet. And when I came here, and the congregation here was enjoying your tips. I thought that when I come here, I would tell you that that's how we enjoy his tips in Cabinet. But suffice it to say that really alternative dispute resolution already are taking place every day at different levels. And that's why we supported the Minister, because he was giving Cabinet strong reasons on how we should mainstream it and make it at policy level so that it is homogeneous with the main line of justice systems in the country. I have also brought you very warm and cordial greetings from His Excellency the President and Mama Janet Kataha Museveni, who had just arrived in Cabinet when I was stepping out. And you know His Excellency the President, with his very humorous way of conducting business, he gave an example of how a long time ago the King of Ankole and other people went to London, I think for a conference. And then the King of Ankole did not know how to speak English. But he went with an interpreter. I think the Deputy Chief Justice knows that interpreter. I've forgotten the name. But he said that interpreter was the cousin of Mama Janet, that interpreter who the king had gone with. So when the interpreter was stepping out to go to the washroom, that the king was so emotional and said, "Where are you going? Where are you leaving me with these people? What am I going to do with these people?" In the local language. Now he was speaking the local language, which I might not translate here. So when I was stepping out, he was saying, now I was like, he was like the king. Where are you going? You are leaving me with people here. Where are you going? So he sent you his warm greetings, Minister, and all of you sent you his warm greetings. But he also gave me permission finally to come. So I'm going to just make a very simple task of relaying his message to you. For instance, I thank the leadership of the Judiciary, the Ministry of Justice and Constitutional Affairs, the University of Pepperdine, the Uganda Bankers Association, and the other partners for organizing this high-level event, which underscores the need to adopt alternative dispute resolution in our justice system. I am happy to note that the judiciary is beginning to explore alternative mechanisms of settling disputes. In the past, I have urged the judiciary to examine the principles of the African jurisprudence. What was the philosophy of the law among the Africans before the British introduced the current legal system? Since the NRM has been mainly preoccupied with addressing the strategic bottlenecks to development, i.e., the poor infrastructure, the lack of markets, the underdevelopment of the human resource, etc. We have not given sufficient attention to the fundamental questions regarding the law as it is now. However, I wish to emphasize that the legal system must be part and parcel of the organic body of the society. You cannot have the law suspended in space and not rooted in society from which it is coming. I therefore welcome the efforts of the judiciary to reorient its philosophy from the colonial disposition of justice to a more Africanized institution that reflects the interests and values of our people. The Africans had an elaborate way of handling disputes before colonial rule. Once the principles in the African jurisprudence was the preference for the truth, this is a departure from the current legal system, where a person hires a lawyer to cover his or her mistakes, to minimize the mistake and maximize innocence. There is no attempt to arrive at the truth. To illustrate this point, let us look at the Banyankole. Let us look at how the Banyankole handled matrimonial issues. In case a wife developed a conflict with her husband, she could do what we call okwangana. Okwangana meant that she would go back to her parents or her brothers. Her relatives would inquire from her why she had left her husband's home. After a few days, the husband would come to Okugarura to bring her back. His wife's family would tell the man to return with 4 or 5 people from his family. The two sides, the one of the man and the one of the woman, would then sit down and listen to both sides. The goal of the two sides was to find the truth. In this Banyankole system, even your own side would turn against you upon discovering that you are a wrongdoer. For instance, if a woman was in wrong, her own family would turn against her and order her to apologize to her husband. That was one of our principles. It was based on the truth rather than just legal battles. The second principle is that the African system did not tolerate impunity. The guilty party was tasked to okuhonga, compensate for his or her mistake. For instance, you would be asked to bring a cow or a goat if the mistake does not include the shedding of blood. If it is murder, it would be okukaraba. That is blood settlement. This helped to eliminate impunity because the price for misbehavior was high. The third principle was harmony. The role of the judiciary is okuramura. You separate two parties that are fighting in a fair manner so that everybody is satisfied. This restoration of peace and harmony were cherished in the African system. Africans viewed disputes as an opportunity for strengthening instead of breaking societies and relationships. Therefore, the modern system of justice has many lessons to learn and replicate from the African concept of justice. These systems related to the people daily and appreciated their need for fairness. Traditional conflict resolution conflict techniques such as mediation, adjudication, reconciliation, and negotiation, which Africans employed in the past, offered great prospects for peaceful coexistence and harmonious relationships in post-conflict periods. Government will support the judiciary to expand the use of alternative dispute resolution. This will help to rejuvenate the traditional systems of dispute resolution. It is my honor to officially open the high-level National Alternative Dispute Resolution Summit. I thank you all. That is his message.
Thank you, and thank you so much. Let us appreciate Her Excellency, the Vice President, for ably delivering the message or the opening remarks by His Excellency, the President. Thank you so much. We are now coming to the tail end of this session, and I hope we are still smiling ADR, and we shall do ADR with our lunch and be very happy and come back here. Your Excellency, thank you so much. We now have only one thing that we are going to do after the anthems. We will take a few representational photographs. Remember, we don't want Tom Sawyer, so there's many evidence that they organized the summit. So there will be a photograph by the immediate table in front, which will join the high table together with their lordships, the justices and judges. The second photograph will be by the students of the master class and the Pepperdine University. And then, Your Excellency, with your permission, we will have just the last photograph. We have the CEOs from the banks, the heads of constitutional commissions. They will come together with the President Law Society and Senior Counsel. When they are here, they would have represented all the advocates. The permanent secretaries, you will also come together with our development partners and the sponsors. Myself and the PRO, we shall represent all the registrars who are here in that photograph. So once I'm in, you're all in that photograph. So with that, now we will rise up, have the anthems, then we have the photos, and then I'll guide on lunch. Anthems in reverse order. Thank you very much. We are going to have the photos right in front here, so I request my team to quickly organize ourselves, and then that first category, those in the first row, you will be coming to take the photos, joined by all their lordships, the justices and judges. Our teams, let us be fast. Front row, my lords, please, I request us to join this photograph. Okay, as we said, it's going to be representational. My lords who are left behind, I would request you come and just climb up. I've been advised that another line can stand right behind. Paparazzi, would you create some space so that their lordships walk through and we have this photograph? I see the last two joining, yes. My lords, thank you very much. That photo is done. We are going to have the master class. The master class members, together with the paper dyeing team, master class and the paper dyeing team, please, the professors. As those come, this group should prepare the permanent secretaries who are present, development partners and sponsors, chief executives of banks, heads of constitutional commissions, agencies and departments, or statutory bodies who are here. President Law Society, prepare to join that one together with all senior counsel. Thank you very much. Let's have the last photograph of those categories that I have called. And that is the one I'm joining on behalf of your worships.
Madam CR, you forgot that the MC represents the service providers in that last photo.
Please, can you come and join that last photo?
So let's have the last photo, ladies and gentlemen. The MC will represent the service providers.
So that is the last. Thank you very much. Let us stand up as Her Excellency makes her way out. And it is just time for lunch. All of us who have taken the photos and all who fall in that category, our lunch is in the hotel side. The ushers are going to show you. All the other delegates, you're in Kazinga on ground floor, and our staff are in the tent. So ushers, please run with those coupons and let us have lunch. Over to you, Sam, to tell us when we come back.
All right, thank you very much. Let's appreciate our Chief Registrar for taking us through that important session with a round of applause, ladies and gentlemen. Great. So feel free to stay where you are. The ushers will be giving the coupons that will take us to lunch. Apart from the people that have been told to go to the other side of the hotel, the rest of us, we will wait for the coupons being given by the ushers to help us to go to have our lunch. Just a little consultation. Ladies and gentlemen, we are having our lunch for the next only 45 minutes. And at 4:30, when you come back, we will directly go to the panels. We have some 3 tracks, track conversations. So you look at the 3 in your program, this program that you have, and choose which track you would like to be part of, the 3 of them. Then the ushers will be at the entrance, guiding you to which room you will go to for the conversations on the 3 tracks. So right now, let's just go for lunch, 45 minutes. When we are back, directly go to the conversations of the tracks. That's when we will come to let you know when you are to be back into the plenary as we end together. So we go for lunch now. After 45 minutes, directly go to the track that you are interested in according to the 3 tracks in your program on page 5. The ushers will be helping you to go to that room. Bon appetit. Lucy, Madam Lucy, kindly bring the coupons for this desk, this table here. They are waiting for you. Kindly do it as quickly as possible. Coupons for the team in front here, kindly do that as quickly as possible so that they can have their lunch.
tukkirire mu kibaati wamnawa tewali future. Omuzimu gw'omuntu kusiba. fasting. yakayuza yakayuza
when you unmute.
I'm telling my presentation to these guys. The next session. Your changes over there. Okay. Has Martin gone through? And he's okay with it? So maybe we send them that now and tell them this is our preliminary opinion. Meet with them to discuss it. Yeah, because now, Joyce, is there anyone copied in that particular? Maybe call her and find out, because I was supposed to send it to her. Remember how council passes it. So maybe if you can get, because already I had gotten an email to her, so if they can send us an email to the president.
Ladies and gentlemen, welcome back from lunch. I hope you had a good lunch. I would like to quickly pass on this information for our next step on the program. Right now, it is time for the tracks. Stakeholder and sector utilization of ADR. So we have 3 tracks. Track number 1 is going to be in this room right here where we are, and it's about emerging areas and trends of the 21st century arbitration. That includes developments in renewable energy, going green, navigating emerging trends in infrastructure, and construction disputes. So in case you would like to be part of that track, you can stay in this room. And Honorable Justice Paul Gadenya will be leading us in the conversation here. Then we have track 2. Track 2 is about Uganda's growing fintech opportunities and the role of ADR in the technology space. That's going to be moderated by Ms. Agnes Tibayeta, and it's going to be in Choga Hall. Now, Choga is just down here after on the left side of the reception. So in case you are interested in track 2, right now you may want to quickly walk down to Choga Hall. That's the track that has metaverse, artificial intelligence, blockchains, fintech, and technological risks. And then we have track number 3. Track 3 is about understanding the place of conflict management, mediation, and conciliation for sustainable development. Now, in case you are interested in that track, I will request you to also make your way out and you go to Aswa Hall, Aswa. So we will go there and take about 20 minutes of conversation, and then we will be back to the plenary for a few presentations. So let's get to our different tracks. So Honorable Justice Paul Gadenya, Criminal Division of the High Court, is the moderator in this track inside here. Ladies and gentlemen, I would like to make this announcement again concerning what's happening right now. It's a time for the different tracks where we are dealing with stakeholder and sector utilization of ADR. And we have 3 tracks. Track number 1 is about emerging areas and trends of the 21st century arbitration. That has something to do with renewable energy, oil, gas disputes resolution, going green, infrastructure, construction disputes, etc. And that is going to be in this very room. And already Honorable Justice Paul Gadenya is here to moderate that. For those who have chosen track number 2, which is about the role of technology, that one is meeting in Choga room, which is just down here on the left side of the reception. And for those who have opted for track number 3, about understanding the place of conflict management, mediation, and conciliation, you are going to be in Aswa room, and people are already going there. So let's get there, and we will take a little time, just about 20 or so minutes in that conversation, and be back to the plenary.
Can we have one extra seat here? Eh? It's coming. Please let me ask you to take your seats. Take your seats. I want to welcome you to this. Yeah, but okay, the challenge. 1 minute. Okay, then you have to. I'd like to welcome you to this afternoon session. In this session, we are going to consider a broad topic entitled Emerging Areas and Trends of the 21st Century in Arbitration. Under this theme, we are going to cover 3 major areas. 1, developments in renewable energy, oil and gas dispute resolution. 2, going green, sustainable solutions to ESG disputes. 3, navigating emerging trends in infrastructure and construction disputes. My name is Gadenya Paul, your moderator for this afternoon. And the distinguished members of my panel are 4. Because we don't have a lot of time, so I'll make the introductions very brief. We have Professor Jack Cole. He's a professor of law and faculty director in international commercial arbitration, LLM concentration, Strass Institute for Dispute Resolution, the University of Pepperdine. Professor Jack Cole is seated right over there. Next to me is Owechtibwa. Just a minute. Christopher Bwanika. He's the Attorney General of Uganda Kingdom. That's why he's called Owechtibwa. He's an advocate of the High Court of Uganda. He's a founding partner of Kalenge, Bwanika, Kisubi and Company Advocates. He has an LLM from Queen Mary and Westfield College, University of London, and he has 2 postgraduate diplomas in arbitration. Owechtibwa, you are most welcome. Mr. Milton Ocheng, I need to get your bio. Let me improvise, because the bio was not given to me, but I'll improvise. Just a minute. Just a minute. This is too small. Mr. Milton F. Ochen is a managing partner, Milton Advocates. It's a law firm based in Kampala and specializes in construction law and arbitration. He holds a master's in science in construction law and dispute resolution from the British University in Dubai. He has a certificate in mediation from Pepperdine University. He's a member of the Chartered Institute of Arbitrators, London. He's a member of the London Court of Arbitration. These are too small for me. And he has 15 years experience in the construction and arbitration. It's too small for me. Please welcome Mr. Ochen. And then our colleague, the other side, I want to get his names correct, is Miss Olivia Charimpa Matovu. Okay. She's a partner and head of dispute resolution practice in ICAMECK Advocates. She's the honorary treasurer of the Chartered Institute of Arbitrators, Uganda chapter. She's head of training and accreditation, ICAMECK. She's a member of the Chartered Institute of Arbitrators of the UK, the Kenya branch, and the Ugandan chapter. She's also a member of the Young International Arbitrators Group of the London Court of International Arbitration. She's I think they are repeated. She's a member, Africa Users Council, London Court of Arbitration, and she's a member of the Uganda Law Society, the East African Law Society. She's, of course, an advocate of the High Court and subordinate courts in Uganda, and she has Masters of Law in International Dispute Resolution from Queen Mary University of London, UK. She has other qualifications that I'll not mention, but they are relevant to the subject of arbitration. So those are our 4 panelists this afternoon. I'll now set the ball rolling. Now, as all of you are aware, the arbitration has been affected by a number of factors. In the last year and this year, the conflict in Russia versus Ukraine. In the previous years, we had the COVID pandemic. It affected the trading regime and arbitration in very profound ways. The economies have also had challenges because of disruptions in the supply chain in as far as goods are concerned. And you can see that a number of countries are really having serious challenges in raising revenues to finance their budgets. So there is no doubt that these factors, including climate change, have affected the way things are being done in the world today. And the world of arbitration has not been spared. Now, to kick us this afternoon, I want to start from a general perspective, and then I'll come down to construction, and then we shall go to energy, and we'll finish with ESGs. Professor Jack Hall, despite this turmoil, why is it that arbitration is still first among equals in terms of resolving commercial disputes and other forms of disputes?
Thank you, Mr. Chairman. I will invoke the protocol, and I'm grateful for it, especially given the amount of time. In the concentrated time I have, I'm making the case that arbitration is still first among equals. All of the conditions that were just mentioned confound dispute resolution and keep us all very busy. We have supply chain issues based on great price volatility. We have restrictions on transactions involving Russian banks. We have all manner of other things that at the business planning level keeps lawyers really busy trying to figure out how to draft better force majeure clauses or stabilization clauses, as the case may be. My general case for arbitration being first among equals is that it has characteristics that are still valid today, and in comparison to other techniques, although I must say mediation is a very powerful technique, in comparison to others, still come out on top. So first of all, there's the obvious effect that a well-drafted arbitration clause centralizes the dispute, and for parties that means that you're not going to end up in the other counterparty's courts. That's a very valuable thing to be able to predict. Equally, when the process is over, you'll have an award that will be enforceable in 160 countries through a fairly summary process in most of them. Those who respect the New York Convention usually approach it with great alacrity. Third, of course, you get to pick your arbitrators. So when our topic is about issues of green or issues of engineering, construction issues, all of the things that we're talking about today, picking your arbitrators is a wonderful aspect, because in the world of courts, you can't necessarily pick who your judge will be or the depth of knowledge they have with respect to a particular area. And so you pick arbitrators for their technical expertise in many cases. And finally, it's, I think, because of arbitration's protean nature. Here I'm referring to Proteus. Some of you may know Proteus. This is an epic character that is supposed to, incidentally, live at the mouth of the Nile River. But he had two characteristics in common with arbitration. First, he had the ability to change his shape to avoid danger in all manner of ways. Secondly, he had a very well-developed sense of survival, a survival instinct, and I think the institution of arbitration does as well. Let me give you my one example. 25 years ago, the first case that came up under the NAFTA dispute resolution investor-state chapter, that's chapter 11, was filed against Mexico. It arose, to simplify it greatly, it arose out of an American investor's attempt to build and operate a hazardous waste landfill. So I already see this sort of green connection coming up here. It was brought in circumstances where, generally speaking, the pleadings were not readily available. The tribunal actually told us, would you please not talk to the press? Equally, when we got to the hearing at the World Bank, there was security at the front keeping out those who were not authorized, and in the hearing room itself, up on the upper reaches, no one was allowed in except counsel and the arbitrators. So far, so good, except we, of course, won an award for many millions of dollars against Mexico, and about that time, people begin to notice. The position was this: wait a minute, let's see if we've got this right. Behind closed doors, you're adjudicating the rights of a sovereign state with respect to regulation proposed by them to protect the environment, and the public was not allowed in, and we may not see the rationale behind the decision. And so the drumbeat became louder and louder and louder among elements of so-called civil society, those representing strong green sentiments. And so much so that important people began to say, maybe this investor-state arbitration thing ought to be done away with. It seems like it lacks legitimacy because they can, is it an ATM for corporations? You just show up behind closed doors and they cut you a check, and then what about poor Mexico, who claims that they were trying to regulate on behalf of the citizenry to improve the environment? And so, in the end, the system worked in this way. Mexico cut us a check. But having a survival instinct, the institution of arbitration in general, and the particular institution of investor-state arbitration, realized that they had to take advantage of their protean nature, their flexibility, and accommodate these legitimate interests. And so it didn't take long at all for there to be open hearings. You come to the World Bank, you sign up, there's an ante-room where you can watch a live feed of the hearings. Secondly, amicus briefs were invited. Third, many of the documents that were generated during the arbitration were made public, including, ultimately, the award. So, what's my point? My point is, there are several times along the way when I've seen arbitration threatened, and that can be, today we can even talk about whether they can handle all of these problems with the supply chain and the banks and everything else. And my answer is, yes, they just keep adapting. Party autonomy is a big part of that, but the inherent flexibility of arbitration, combined with its ability to generate finality in a meaningful way under a treaty, which you still can't promise with respect to mediation, is the thing that keeps it. You saw earlier today when the word arbitration came up in the mouths of most of our commentators, because it has these characteristics. Is it perfect? No. In fact, I like to tell my students, it's the worst system ever created, except for all the others. And so we're constantly working to improve it, harnessing new technology, harnessing the flexibility built in to find expediting measures, doing things like, instead of sending me boxes of written briefs, I now get one of these in the mail, a very green solution to what used to be an enormous problem. And so arbitration's protean nature is part of what keeps it first among equals, and I'll stop there.
Thank you, Professor Cole. The arguments we normally hear from developing countries is that they always get a raw deal when it comes to issues of international arbitration. How can African countries benefit more from international arbitration?
Could you repeat?
Okay.
My apologies.
African countries have always complained that they normally get a raw deal when it comes to international arbitration.
Mm-hmm.
And the debate is, how can African countries benefit more from international arbitration as a means of solving disputes?
Well, if you're talking in particular on what remains controversial, the investor-state system, statistically, the notion that somehow states lose more often than they win is wrong. The data show that, in fact, between jurisdictional defenses and defenses on the merits, states tend to win slightly more than investors. The real question is, given that states lose sometimes, and the number is extremely large sometimes, you have to do the calculus. Do we attract enough investment to make up for our exposure? And that's the question states are asking themselves. The trend, of course, to feel more comfortable about the situation is to redraft BITs to give more latitude to states in their regulatory initiatives, especially with respect to the environment. And so you see modern BITs look far different than the older ones, and they have carve-outs for health and safety regulation and other things that are by definition, or at least by presumption, not expropriations, for example. And that's been the trend over the last, I would say, 15 years.
Thank you very much, Professor Cole. In the interest of time, we'll now move to another area. I may get back to you in the course of the discussion. At the beginning of this panel discussion, I did observe that the war in Ukraine, Russia versus Ukraine, and the COVID and all these other issues have caused profound implications on a number of things, particularly in the area of the construction industry and infrastructure. Now, Ms. Abwanika, could you tell us how COVID and the war, the conflict between Russia and Ukraine has affected construction?
Thank you, Chair. The situations you're talking about, technically what is called force majeure. In our basic law of contract, of course, we know disasters or acts of God which prevent performance of contracts, acts which will suspend performance of contracts. In the construction industry, various forms of contracts apply, and normally there are such clauses. Now, every project depends on the procurement method used or the framework, but we have various contracts in the construction industry. Like in Uganda, we have projects which are sponsored by the World Bank, IBRD or IDA, where, you know, the form that is used provides for a specific contract. Some other projects use the FIDIC contracts, and we have also our PPDA, which we are mandated to follow. There are clauses that deal with situations of force majeure, where when such
situations occur, performance must be suspended. Similarly, the COVID situation, of course, suspended activities. The war in Ukraine now has affected the global supply chain, as you mentioned. When such situations occur, then the relevant contractual provisions are considered to see whether the situation fits in that kind of situation. I think that in the limited time, that's the comment I can make.
Thank you. In this country, the construction and the infrastructure sectors of the economy are the fastest growing segments of the economy. So could you kindly tell us the common disputes that we normally find in the construction and infrastructure industry in Uganda?
It's very true that in Uganda currently there is a lot of construction, infrastructure development. Professor Gash earlier talked about factors that can attract investment, that can make Uganda an investment destination, and infrastructure is key. And truly, currently, according to the Uganda Investment Authority website, I think over 35% of our total new expenditure is on construction and infrastructure. For the road network, we are revamping our railways. Air transport, we are developing another airport. Inland water transport, we have over 170 vessels. In the energy infrastructure, over 750 kilometers of electric transmission lines. We're also developing the national backbone infrastructure for ICT, and Uganda is also embracing e-government, where digitalization of all activities is taking place. All these projects, again, as I said, are undertaken under particular contractual frameworks, depending on the particular procurements. And as I mentioned, the kind of procurement also dictates the form of contracts, and some of the frameworks actually provide for standard form contracts with general conditions which don't give a lot of leverage to the contractor to change, particularly like on the dispute resolution clause. You asked me which common forms of disputes arise. Of course, in construction there are cost overruns, time overruns, and which always give rise to claims, and those depend on the particular framework followed. But following the discussion that we've had today, I want to bring on the floor a very peculiar conflict that affects energy, and rather that affects infrastructure in Uganda. Because those which are regulated by the contracts are very easy to deal with under the contractual framework. But in Uganda, we also have the land question. In the various areas where these projects are undertaken, there have been delays. Delays have given rise to claims and disputes and conflicts under the contract. But these delays are owed to land disputes in terms of resettling people, and I want to focus on that, having in mind the alternative dispute methods that we have considered. when you look at the other frameworks, I talked about the FIDIC type, the PPDA form, you'll find that the dispute resolution, the alternative dispute resolution methods we talked about, like negotiation, mediation, are not provided for in those frameworks. And it is adjudication and arbitration. Actually, the World Bank guidelines on procurement dictate arbitration, and so many other forms. Under the contractual frameworks, the relevant dispute resolution clauses are followed. But when I come back to the land disputes that I talked about, I think that we should focus on the traditional justice systems and also community involvement in dispute resolution. As a country, we need to benchmark from countries like Kenya, which have community committees which are involved in resolving disputes, particularly where these big infrastructure projects take place. I listened to the speech of the Chief Justice about informal justice and our traditional systems. And when I talk about land as one of the common conflicts and disputes which leads to delays of projects, I think we should strongly recommend for ADR methods to be used to resolve this common dispute using the communities, given what we've gone through this morning, that people tend to believe in the justice systems that they understand. And taking Kenya as a case study, as I mentioned, the community participation and involvement of members from the community, like the committees that Kenya set up, helps a lot in resolving these disputes. Thank you.
Thank you for those comments. Maybe Professor Cole, maybe just to follow up on that issue, could you briefly comment on the usefulness of dispute resolution boards in infrastructure and construction projects?
Well, my colleague could probably speak to that in terms of what he finds in his standard form contracts. We're talking about dispute resolution boards, this idea that there would be dedicated to each project a committee of experts that would act quickly. So if you have a hole there and the dispute is this the right type of rebar, or is this substitute not acceptable under the contract, they would make an engineering decision, and that would be binding on the parties. Therefore, you wouldn't have to take the long sort of process of an other kind of ADR. And so it's on the spot, it's immediate. Typically, it's semi-binding but not binding, but party autonomy is such that you could structure it any way you want. You could make them in the nature of arbitrators, if you like. But it's certainly in the collection of tools in our ADR toolbox, that is sometimes overlooked. The British know about it a lot. The Americans don't talk about it much, but I think it makes a lot of sense because it's quick, it's expert, and it solves the problem. And the main thing is you can fill the hole and move on to the next stage.
Thank you. In the interest of time, we'll now move this side. And you all know that I think next year or the other year, Uganda will start exporting and extracting its oil from the Albertine region. And I now want to speak directly to Mr. Ochen. Mr. Ochen, in terms of the conflict mapping of conflicts in oil and gas, what are the common conflicts that are in that industry, or those that Uganda is likely to face? as it extracts its oil.
Thank you, Chair and participants. The disputes that arise, first of all, we need to understand that disputes, energy sector as a whole, you do have disputes arising from the subsectors of renewable energy and non-renewable energy. For example, in this discussion, we're looking at oil and gas, and then and renewable energy, where you have the solar plants and what and so on. One thing we must know that we all know is that the energy sector as a whole requires substantial investments in terms of investments in terms of exploration. First of all, the discoveries before that, and then going into phases where some key agreements are signed, and then the FID, the financial investment decision is made. As a country, as Uganda right now, that commitment has been made. So largely, we are now into the phase of infrastructure development, as mentioned by my colleague there, where we are seeing the airports, the Telenga Ridge is being built, and so on. So basically, disputes that are common are classified into about 4 categories of types of disputes, where you have, for instance, state versus state disputes. These ones normally occur over boundaries. We've seen the cases of Malta and Libya, Iran and the neighbors as well, where there's a dispute because a natural resource will cross across some boundaries sometimes. In Uganda, luckily enough, most of our resources are within inland, so those trans-border disputes are not likely to occur. The second category of disputes, you have investors versus the state. Like I said, there are commitments which are made, and huge sums of monies are invested. Therefore, when governments change their positions, for example, there are actions which can be brought by an investor against the state. And in this case, for example, issues of expropriation, which he had talked about, arise as a cause of action to be able to apply. Of course, we must also note that we do have the bilateral investment treaties and the multilateral investment treaties that nations sign. A country like Uganda has signed some. So when an investor comes and then invests, they are able to take action. They are able to go into dispute with the country as a result of violation of that treaty. So these are basically, these are known as the state investment disputes. We did, the Ministry of Justice last year, I think, advertised, without, of course, disclosing I'm just giving an example, the details of the dispute. About, they advertised, they wanted local law firms to support the ministry in handling some disputes, and this was one of the disputes between an investor and the government of Uganda, arising from the St. Balikudembe market. So some of those arise. The third one are basically disputes amongst the oil companies, the petroleum companies. As you know, we are into the construction phase. So you have multinationals coming and taking up the main contracts, and then there's a whole chain there's a supply chain of subcontractors and suppliers of services, operators, and so on and so on. So normally when those disputes occur, it takes the value chain. So there are this category of disputes, and mostly they are, this is where most of the disputes actually occur. And normally, when you're advising them, it's good to transplant. One way of dealing with those disputes is that if you have the master contract for the infrastructure development, that same dispute resolution should be passed on to the parties, because assuming the master dispute resolution clauses on arbitration, and then for the subcontractors and suppliers is saying something else, and yet there's a transfer of liability that keeps on passing along the chain. So that's the third. The last category that is common in this area is you have disputes between individuals and, for example, the companies, the petroleum companies that are doing whatever work they're doing within the industry. Most of them can be brought as tort claims against these companies. Sometimes you have the PAPs, the project affected persons, in case the project, they did not prepare well in advance. So these ones also come. Of course, I'll also like to say that for a case of Uganda, this is, it's been quite managed well in terms of individuals bringing disputes. I'm yet to see one that has happened. But these are the four categories. Again, perhaps, I don't know whether it will happen, but under the Public Finance Management Act of 2015, Parliament passed a law that there will be returning the sharing of revenues from the oil productions to the local communities where these resources are being extracted from. We're yet to see disputes arising from that, but that could also be a potential area where there are no equal sharing, or when the act is not being followed. Those are basically the four recognized types of disputes that we encounter in that area. Thank you.
Thank you, Mr. Chen, for that. We are short of time, but we'll take that discussion to Advocate Chalimpa. Yes, the oil sector can be a blessing, but can also cause a lot of problems in terms of pollution, in terms of its effect on other issues of life, including governance. So, of late, the ESGs have become common subject in as far as the environment is concerned. These are the economic, social, and governance principles. So, could you kindly take us through, very briefly, about the origins of the ESGs and how they are going to impact on investments, particularly in the energy sector, in as far as Uganda is concerned?
Thank you, Chair. Well, the acronym ESG has its origin in the UN Principles of Responsible Investment report, where it was deemed fit to have an assessment of countries, of institutions, on whether they are, before investing, whether they have applied the ESG standards. And ESG, essentially, as you said, is the environment. So assessing nations, assessing institutions on whether they are taking care of the environment, dealing with climate change issues, what is their strategy on that? And then in terms of the social, looking at the social impact that the institutions have, both on their internal part, looking at their stakeholders, the employees, their well-being, their suppliers, and all other stakeholders within, but also outside in terms of the communities within which they serve, whether they are making a social impact on those communities. And then finally, with the governance, looking at the leadership of those institutions and their commitment to ensure that the environment is preserved, and then their commitment to ensure that in their management of the affairs of the institutions, the staff are being treated equitably, there is diversity, there is inclusion, and that the social well-being of their people, including the communities around them, is being catered for. But most importantly, also to ensure that the companies are accountable, not just their internal stakeholders, but then to the community at large, and in terms of the impact they build. So that was those standards are used to determine whether investments can be made in different institutions, and whether, you know, even as a nation, if you're looking for foreign direct investment, the question is, is ESG part of your agenda? And therefore, it has shaped a lot of investment decisions. But beyond investment decisions, it's also shaping consumer decisions in terms of certain products of certain institutions may not be purchased if there is no visibility of how that institution is dealing with ESG requirements. And in terms of, even before we look at ESG per se, we have seen that the issue of environment has been on the global agenda for long. It was first looked at by the UN under the Earth Summit in 1994, where a treaty was signed to reduce the impact, the negative impact on environment. And then subsequently under the Kyoto Protocol, where again states committed to ensure that they were going to deal with climate change issues. And then we look at the UN Sustainable Development Goals, where you find that the issue of environment, dealing with climate change, dealing with issues of clean energy, clean water, preserving forestry and the ecosystem, the natural ecosystem, are part of the UN Sustainable Development Goals, and then under the Paris Climate Change Agreement. And in fact, for Uganda, I'm glad to say that we have taken the agenda on. We now have the National Climate Change Act, which was enacted in 2021, which actually domesticates the Kyoto Protocol and the Paris Climate Change Agreement of the UN. So it's a big issue in investment, and especially in the oil and gas sector, to deal with issues of pollution.
So, in your view, how can the non-state actors enforce these ESGs? What is the best method of enforcing them?
Non-state actors, now we look at the private sector, ourselves, law firms, companies. I think we should all have ESG strategy embedded. First of all, we should have ESG policies in our institutions that take care of the ESG, and then it should become part of the operations of the company. There should be a monitoring and tracking in terms of how are we dealing with the ESG requirements. And then I think also in terms of sensitization of the staff, of the community, because you will find, for example, he has talked about the oil and gas sector, you'll find that probably the funders, the financiers, or even the employers are requiring contractors to comply with ESG requirements. But if the staff who are actually the actual people on the ground operating and doing the work are not aware of the standards, then all of it is in vain. So it's important to inculcate an ESG culture in the institutions themselves, in the private sector, to ensure that everybody is alive to them, is alive to contributing to a better future, a better planet for the next generations, is alive to taking care of the societies around us, and also is alive to ensuring that we attract investment, because those are some of the criteria that are being used to determine whether to invest or not.
Thank you, Ms. Chalimpa. Colleagues will note that China is one of the biggest investors in Africa, and I believe generally for most of the developing world. Mr. Chen, I just want you to very briefly comment among the most preferred methods of resolving disputes in Chinese investments in Africa.
Yeah. Thank you, Chair. The question of China, we've seen in the last 1 decade or so, Chinese investments in Africa, Africa being a preferred destination of China in terms of putting in money. And we should note that most of these companies are state-owned when they come in and they make these investments. Of course, as investors, they come with some terms and conditions. I have had the benefit of looking at some of the investment agreements. They require a substantial amount of guarantees in terms of conditions that they put on you as a nation. Amongst them, for example, they require that their companies or nationals be treated equally as nationals of the country. They require, amongst other things, that they will not be denied justice. They require that, of course, because they come with the money, they have a higher bargaining power, because then they're coming with the money to invest. And so they come with so many conditionalities and guarantees. And that question of China cannot be taken lightly. So what happens is that we are committing a lot in terms of a continent or Africa to the Chinese, which is not a bad thing, but I think Professor did hint on it that we need to be able to have better negotiation of the BITs, to be able to have proper dispute resolution mechanisms. But of course, China is, for example, if we're relating with Uganda, is also a signatory to the New York Convention. But of course, they have provisions in their civil procedure rules which make it a bit discretional when it comes to enforcement of those rules. And normally, some agreements, they will tell you that they'll go to Beijing to be able to sort out the dispute from there. These are some of the areas that we have to learn to negotiate, because much as they're coming with the money, but they also want to invest this money here. So we should be able to be having a good negotiation. But of course, the dispute resolution mechanisms are tiered. They're multi-tiered. Of course, you have aspects of negotiation, you have mediation that will lead into arbitration, and so forth and so on. But also particularly, you have expert determinations where necessary. But time will not allow us to do justice to some of these questions, I understand. So, but the question of investments from China, we have to be able to negotiate better. Otherwise, on those terms and conditions, when it comes to the dispute resolution, we most likely will be always on a receiving end. Thank you.
Thank you, Mr. Chen. My lords, ladies and gentlemen, time has not been our biggest ally this afternoon, and so we will not have many questions. We'll have at least 3 or 4 questions. Those who want to pose questions, please be brief and indicate the particular presenter you would like to answer that question. If it's general, state it so that any of the presenters can answer the questions. So could we have some questions? Some questions? Yes, I don't know who's moving with the mic. There.
Thank you very much, our moderator and the panelists.
Yeah.
My name is Victoria Nachi-Intu. I am Senior Resident Judge Masaka. And it's a pity that we have to kind of run through this.
Yeah.
From Professor Ko, I'd like to get the citation of the case you mentioned, the one on Mexico.
Of the Mexico case.
The Mexico
You want
case.
the case citation?
Yes, please.
Yes, it's Metalclad versus the United Mexican States. It's under Chapter 11 of the NAFTA. It was it proceeded under the ICSID additional facility rules. The award came out in about 1999.
All right.
So it was 25 years ago. And I can tell you more than you'll ever want to know about it, but happy to chat.
Thank you. I think I'll get that later on. And then
Okay.
to Olivia, thank you very much.
Yeah.
I'd like to know if this, the EIAs and in light of keeping people and planet and the profits in consideration when we are doing all of this investment, that you're not just ticking a box in having these environmental impact assessments. I've seen cases where what's appeared to be an investment for good has displaced entire communities, and something has been done for them without taking into consideration their own views, their thoughts, displacing communities, resettling them, building what I call a matchbox kind of estate for people who are used to living off the land. So mine is to ask, are we not just ticking a box again, really, in the drive for profits in some of these EIAs and just saying that, okay, yes, now we are required to have ESG. Do we have those at heart? As recently watching Lord Attenborough, David Attenborough on Our Planet, and I've seen the disruption that's been caused by so much of these investments. So what comfort can you give us that these contracts are not just as good as the paper that they are written on? Thank you.
Thank you. Other questions? Yes. This side. I think, Olivia, that's yours. Yeah.
Thank you, the moderator, as well as the panelists for the discussion. My question goes to Olivia. Our partner at night is my name. I'm a practicing lawyer.
It's not, is the mic on? Okay.
Yes, yeah. My question relates around ESG. And I think currently it's a talk of in every boardroom, to have compliance with ESG and to ensure that whether financing or projects are compliant with the ESG debate. Now, my understanding, the ESG issues tend to be socially driven, and they're actually public interest in nature. Now, my concern relates around consent, as we know it, that is required in arbitration, and how some of those social-driven issues, as opposed to legal, can find themselves in the consensual framework of arbitration for them to be arbitrated. You have governance issues, you have social issues that affect the wider public that may not be parties to arbitration arguments, consent being a relevant factor to arbitrate such issues. And I think it's becoming a global discussion as to whether arbitration is the right place to adjudicate disputes that are of a public nature. And I consider some of the disputes arising under ESG to be of that kind.
Okay, thank you for that question. Do we have questions this side? Yes, at the back there, and then we'll come to the front. At the back.
Thank you very much. I'm John Merem, Senior Counsel. Mine is a general question. From my experience, most construction disputes arise from error in documents, delays, and at times blockage in communication. What happens where you have parties whose capacity is not balanced, especially between the developed investors and the common counterparts, and then where there is a total breakage of communication? How do you encourage ADR in such circumstances? That's the end of my question.
Thank you for that question. The lady there. Bring the mic there. This side. You have one?
Yeah.
Okay.
Good evening, ladies and gentlemen.
Good evening.
I'm called Mary Tunjide. My question is, we know that ESG mainly centers on leadership, and I'm inquiring what improvements have been done to improve stakeholder engagement in order to make sure that there will be implementation of the policies and the contracts to ensure that they will follow the ESG requirements. Thank you.
All right, thank you. We'll take the last question if it's there. Near the police officer there. That's not a police officer. Camera lady.
My name is Lydia Kakoza.
Yeah.
I have a comment in regard to dispute resolution in the energy sector, in the construction sector. The way forward for ADR in these sectors is dispute avoidance. Rather than waiting for disputes to occur and then you take time to resolve them, many organizations are going into dispute avoidance, and you find that organizations like the World Bank, through the dispute boards, address the disputes on a daily and most probably even trying to avoid them through the forms of contract.
Yeah.
Thank you very much.
Thank you. Can I quickly ask the panelists to quickly respond? I'll start with Olivia.
Thank you. I think to the first question from my Lord Justice Victoria, you asked whether this won't be, ESG won't be just taking a box and really no impact, social impact on the ground. I think one of the strategies in ensuring that's not just a tick box is that now the drive is to, first of all, ensure that there are disclosures in terms of what the different organizations and what the different governments are doing in terms of this ESG agenda. So there must be a disclosure out there for people to see exactly and people to comment. And secondly, there's a requirement for compliance monitoring. So for instance, you've committed to do A, B, C, D under the ESG agenda. There's a monitoring strategy to ensure that you're actually complying with what you have committed to do. And if not, in fact, like I said, under the National Climate Change Act, actually, there is a right for parties to go to court where there are breaches in terms of especially of environmental preservation and protection. So there's also a right for parties to pursue the actors and players for them not complying. And in other jurisdictions, we've also seen examples of people going to the courts to litigate against, let's say, institutions or companies that made commitments on this ESG agenda and failed, and the courts have condemned them. So because of that, I believe then the tick box element will be dealt away with. And then I think the other question came from Patson on socially driven, ESG being socially driven, and therefore whether it has a place in arbitration or ADR. We can look at the ESG disputes in two fronts. There are those that are indeed socially driven, community-based class actions, and some of those really go to the courts, mainstream courts for dispute resolution. But there are those which are actually inter-party. For example, I gave an example of the fact that under, for example, the oil and gas sector, some of the contractors are required to have to comply with ESG standards. And under those agreements, we have arbitration clauses in case of a dispute. So you'll find that if there is non-compliance on the standards, that can go to arbitration. Then you have financials. Some of the funders of some of those infrastructure projects and other projects in the oil and gas sector are also requiring compliance with ESG. So for instance, if we're being funded by the World Bank, as it's channeling the money through, it requires that before it's passed on, those standards are met. So if there is a default, then either between the government agency that is being funded and maybe the World Bank, there would be an arbitration clause that would lead them to that. And then we have the investor-state arbitration that would arise in case of breach of bilateral agreement or bilateral agreements, whereby the contractors especially now will be seeing the government suing the contractors for failure to comply with the ESG requirements, and that would go through the arbitration arm. So we have to look at the disputes in the different perspectives. And then the final one was about leadership, what improvements have been done to ensure stakeholder engagement. This is a journey that is being walked. But I'll probably just give an example of our neighbor, Kenya. For example, the Central Bank of Kenya has incorporated ESG in the financial sector, and it's one of the requirements. So the leaders in the banking sector have been engaged to ensure that ESG is part of the agenda. And in fact, even as they are lending to their different customers, the ESG assessment is also applied to the customers themselves in terms of what are they doing in their various businesses to ensure that ESG is being addressed. And I trust that even here in Uganda, we'll see some of those. For example, I think at the beginning of this year, the Deputy Governor, Bank of Uganda, stated that the Bank of Uganda is also taking on an ESG strategy, and that would mean that even them, in looking at the leadership of these financial institutions, they want to see whether the ESG agenda is being complied with or it's in those institutions. So the stakeholder engagement is a journey that is ongoing, and I believe as we continue with these discussions, it will continue to get the leadership on top of their game, especially if investment is supposed to be assessed based on the ESG standards. Thank you.
Thank you. Mr. Chen, your final comment? Yes, you can, yes.
Okay, thank you. I had a comment from Lydia regarding my sector. Lydia, yes, it's true. Unfortunately, like I said, we didn't have enough time to do justice to the topics of discussion. But yes, it is really true, dispute avoidance. But it all starts from the contractual framework, the agreements, whether, what standard forms are you dealing with. That will lead you to how the risks have been distributed in the contractual framework, and in the event of disputes, how should it be dealt with. But yes, practically, there's a lot of, especially during contract administrations, where they're dealing with, they're emphasizing dispute avoidance. In some cases, there are contractual provisions that encourage early warning provisions and notices that do apply. All this is geared towards at least avoiding the dispute occurring. In the event that the dispute cannot be stopped or altered or resolved from happening, of course, depending on the size of the projects, there's always encouragement to have dispute review boards that give recommendations, or dispute adjudication boards that then can render binding decisions, and in case the other party is not satisfied, it will definitely go into arbitration. But most importantly, the practice is that that multi-tiered approach is intended to safeguard and make sure that by the time parties are putting gloves off, a substantial part, attempts have been made to avoid a standstill in terms of the project execution. So definitely, again, it goes back to negotiation and the shifting of power. Chair, there was a general question, but you'll know where to put it from Senior Counsel, JMM.
Yes, I will ask Mr. Bwanika to answer that question.
Yes, Senior Counsel, JMM. The question was about disputes arising from errors in contracts. Yes, and mainly focusing on the dispute resolution clause. There is that common saying that it is relegated to the end. It is the midnight clause after parties have hammered the commercial terms. Actually, it's desirable that a lot of time and attention be put to the dispute resolution clause, because that is the recipe for disputes. Very well crafted dispute resolution clause will go a long way in assisting the resolution process, and also providing for the mode. Actually, coming to that, I have an issue there. When you consider the common contracts that we use, like the PPDA form, it doesn't have that multi-tiered process for negotiation, conciliation. Just like the World Bank format, it's adjudication or arbitration. And, from decisions of the project manager or the engineer, as it were. So there's no leverage. If there's leverage to develop a bespoke construction contract, then all these ADR methods we are talking about would be very, very well captured. So I don't know what the resolution of this conference will be, but with the little leverage where you have general conditions of contract which you can't change much, to provide for these dispute resolution methods, negotiation, conciliation becomes a problem. Of course, where the contractual framework provides for boards like dispute avoidance boards, like Mrs. Kakoza talked about, there is no problem. Of course, it is desirable that there is early intervention to avoid disputes. Communication, John Mary presented the issue of communication that between the developing investor and the weaker contracting party from say, the developing state. Of course, that is a big problem, but at contracting stage, that also can be addressed. My colleague talked about the bilateral investment treaties. If there is in place an appropriate bilateral investment treaty, that can also assist in mitigating the issue of communication. I think that is all I want to say about that.
Thank you very much, Owechitiwa. Professor Cole, do you have
just a couple things. On the question of dispute avoidance, you might want to look at what the Koreans are doing. They have an investment authority there, and with respect to foreign investment of all sizes, they have an ombuds program that provides sort of an early warning review of what's going on with the investors long before it gets to arbitration. On the question of whether arbitration is a good fit with ESG, I think it depends on the issue. If it's a contract issue where one party is saying, I'm ending the contract because you haven't kept your end of the deal in terms of your ESG commitments, I think that's something an arbitrator can handle. On the other hand, if it's a group of shareholders saying to the corporation, we think you're falling short in your global obligations, that may be a little softer, might be more befitting to have some sort of collaborative policy making, some sort of mediation, collaborative rulemaking, and arbitration seems like it'd be a clumsy instrument for that. And there are a couple other things in there, but I'll just let them go.
Okay. My lords, colleagues, ladies and gentlemen, may I request you to put together your hands to thank our presenters for taking us through those four broad areas. We don't have time, so this is the end of the panel discussion. Thank you.
A round of applause, ladies and gentlemen, for the panel. Well done, Honorable Justice Gadenya and the whole team of experts, people who are very experienced in these things. Thank you very much. Welcome back from the different tracks, from the different groups. Clearly you are tired. Nobody has responded to me. Am I safe? Ladies and gentlemen, welcome back. Let me request you to do that to your neighbor. Hold his hand or her hand and say, welcome back to this room. Kulikayo, you can say it in your own language. Welcome them back in your own language. I don't know how you say it in your language, but welcome them back in your own language. Kurukayo, tabarukayo. How do we say welcome back in your language, ma'am? I just said it. Ah, interesting. Okay. And Honorable Minister, how do you say welcome back in your language?
In Isinjiro, we say kurikayo. Apo edugo.
All right. Okay. So it's been quite an experience in the different groups, different rooms, different tracks, as we were dealing with the three major issues. One, the emerging areas and trends of the 21st century arbitration. Two, as we dealt with Uganda's growing fintech opportunities and the role of ADR in the technology space. And three, understanding the place of conflict management, mediation, and conciliation for sustainable development. We would like to appreciate all the moderators that took it on and all of you who went to the different groups. Let's appreciate everyone for their contribution with a round of applause. And now, this is the beginning of the end. concerning today. And at this moment, we would like to do a brief event of launching a very pertinent book, and then we will have closing remarks. The book we are just about to briefly launch is titled Alternative Dispute Resolution, the Ugandan Court Experience. Alternative Dispute Resolution, the Ugandan Court Experience, written by Honorable Justice Geoffrey W.M. Chiriabwire, a Ugandan judge serving as a justice of the Court of Appeal and Constitutional Court of Uganda. He is also the Vice President of the East African Court of Justice in Arusha, Tanzania. He is a Fellow of the Chartered Institute of Arbitrators and a World Bank ISCID arbitration panelist. He served in the Attorney General's chambers in Uganda and then in the private corporate sector in insurance and banking before becoming a judge in 2003. He has also done adjunct teaching of law in a number of universities, and the book we have contains re-edited conference and workshop papers by Justice himself, presented at various fora on the subject of ADR that we are dealing with in this summit, and how the courts in Uganda are now mainstreaming its application in civil and criminal adjudication. As courts get saddled with increasing workload and case backlog, this book that is just about to be launched champions the use of ADR as one of the case management tools that could help ameliorate this problem. So the book will prove very useful to judicial officers, administrators, practitioners, and students alike. So at this moment, I would like to welcome the Honorable Justice Geoffrey Chiriabwire to come to that place where we have the dummy copy of the book, and then also welcome the Honorable Minister for Justice and Constitutional Affairs, the Honorable Norbert Mao, who is going to officially launch this book by signing on that dummy and making the declaration of the book being launched, and we will call it an evening. Put your hands together. Welcome the Honorable Minister of Justice and Constitutional Affairs, fondly known as Chairman Mao, together with the author of the book, the Honorable Justice Geoffrey Chiriabwire. And I'm going to request the author to invite whoever he would like to come in front as we do launch the book. So whoever you say should come, will come. All right. Let me request the people in charge of this wonderful book to kindly bring what we can use to sign on the dummy. Somebody at the entrance, help her to come in quickly. Ushers, you can help out on that. In the meantime, the Honorable Minister could be saying one or two words about the book before we do the launching.
I wish to congratulate the Honorable Justice Geoffrey Chiriabwire upon writing this book. By his own account, it has had a long gestation period. I don't know whether the longer the gestation period, the higher the quality, but my own judgment is that it's a very important contribution to the knowledge base on alternative dispute resolution. He told me that he took the time while serving on the bench of the East African Court of Justice. Many men, when they are away from their families, indulge in other forms of activities which sometimes have outcomes. Some of them even come up with children. Thank God our tabloids definitely will have no interest on this baby. about this baby here, the product of many nights alone and very productive. We believe that this is going to be the first of many books that you gathered here will be writing. Let this be an inspiration to all of us. My Lord, the Chief Justice, this is a big challenge to all of us to record what we normally do. Finally, the Honorable Justice Kiriabwire has disclosed the inspiration behind this book, and that is the reason why, even though the MC wanted me to monopolize this ceremony, the author of the book insisted that two people who have been very strong sources of inspiration, namely the Deputy Chief Justice of Uganda and Professor Jim Gash, President of Pepperdine University, should join here. And I think before we sign, they should say something very briefly. I'll start with Professor.
Thank you. I will be brief. In 2008, I was teaching in London, and while I was gone, Justice Kiriabwire came to Pepperdine and for a while stayed in my office. And so we knew each other before we actually met. So he had been in my office. And then in 2010, when I first came to Uganda, I met Justice K. We call him Justice K because our students have a very difficult time pronouncing Kiriabwire. But he has lived up to his name. The name, as many of you know, as I've been told, comes from an ancestor of his who worked. They said, Kiriabwire, he eats at night. He works all day and eats at night only because he's working all day. And in order to be on the commercial court and on the Court of Appeals and on the Arusha court and to write a book, it's clearly the fact that he's living up to his name. But I've become a huge fan of Justice K, as well as Winnie and their children, and have hosted them in my home in Malibu, and I'm so proud to be affiliated with Justice Kiriabwire as he launches this next chapter of dispute resolution in the form of an excellent book, I'm sure. So God bless you, Justice K.
Thank you, Honorable Minister, thank you. I think we have had alternative dispute resolution efforts for a long while. Justice Kiriabwire came from the private sector into the judiciary. And some of the habits we are now discussing are coming from there. He wanted quick disposal of disputes. And that's essentially what it is. So when he came into the judiciary, he went to the commercial division, because that's where he fitted, and carried forward these efforts of quick dispensation of justice. And that's where we are coming from. The activities at the commercial division are what he is recording. He carried those activities over to the Court of Appeal. At the Court of Appeal, I worked with Justice Kiriabwire when we just arrived at the Court of Appeal. We had a committee that checked on what we have at the Court of Appeal, proposed ways of quick disposal of the cases we had, and I think our records are still available. Since then, he has been working on appellate mediation at the Court of Appeal, and it is doing us a good service. As you all know, he championed small claims in the judiciary, and it's a big success. So if you are interested in knowing what's happening behind those stories, the book will tell you what it means to make efforts on quick dispensation of justice in the judiciary. I think that's the story. Thank you very much. Let's quickly launch the book. That is the content.
The Honorable Minister is saying that the DCJ should choose which color of the marker that he likes better, and he has chosen one that we can see black, not blue for some reason. So the book is hereby being signed and launched and given out to the public today to go and add value to the conversations on ADR in Uganda. Big chapter in Africa. Awesome. Honorable Minister, I didn't know you would use that color to sign. He says he's a founder member of a certain party, so.
Therefore, with great honor and appreciation, I declare the book entitled The Alternative Dispute Resolution, the Ugandan Court Experience by the Honorable Justice Geoffrey Chiragwire officially launched. Thank you.
Round of applause, ladies and gentlemen. And right now, I am going to request us to come just here, take the picture with this dummy against the background of what is branded here. And then after that, the DCJ will immediately just give the concluding remarks for the day, and we call it an evening, ladies and gentlemen. Let's have people on both sides to balance the boat so that it doesn't capsize. So let me have two people to come this side. Maybe one more person. In case you are not in the photo, you can only be clapping. Awesome. So, ladies and gentlemen, let's get the concluding and closing remarks from our Deputy Chief Justice, a man of honor, a professional of integrity, a leader of great repute. A round of applause.
We have been observing a protocol since morning. I shall not depart from that. I'm very grateful to you all for taking off your time to come here to attend this summit and make the contributions that we have all made. Thank you for coming and for giving your active participation throughout the first day of this important summit that will last for 2 days. That's today and tomorrow. I take this opportunity to extend my sincere gratitude to the Honorable the Chief Justice, who spared his time and talked to us online this afternoon. I would like to express my sincere appreciation to the speakers and panelists for their dedicated time and valuable contributions this first day of the summit. I would also like to thank the President Gash and Vice President DeWalt for their dedication to assisting Uganda in our efforts to deliver effective and efficient justice to our people. Along with Pepperdine University and its professors Selina Schutt and Jack Cole, who assisted me and my fellow members of the cohort who are currently working on the Master's Dispute Resolution from Pepperdine. This past week, Professors Selina and Jack were instrumental in assisting us in preparing the national ADL policy and planning this historic summit on the future of ADL in this country. From the remarks of His Excellency the President, we have all this support and the ball is in our hands. Dear participants, The experiences shared amongst ourselves on alternative dispute resolution ADR have been diverse, interesting, and educative. We have been taken through the challenging landscape of financial disputes, stakeholder and sector utilization of alternative dispute, ADR. We have discussed emerging areas and trends of ADR in the 21st century, growing opportunities and role of ADR in the technological space, understanding the place of conflict management, mediation and conciliation for sustainable development. We have better appreciated the role of ADR in our justice system. Practicing what we have shared would make us more efficient and effective in the administration of justice to the citizens of this country. Sharing experiences on alternative dispute resolution, ADR, with the seasoned and tested members of the bar, the bench, and ADR practitioners has been of great benefit to us all. In open and candid discourse, we have appreciated one another in the area of justice. This has been a worthwhile engagement. The reason for this summit is for us to generate consensus that as we continue to adjudicate cases using current approaches, we need to reflect and consider ADR as another workable approach that will help us improve the administration of justice. The judiciary has developed initiatives on case hearing and disposal. Under the Judiciary Strategic Plan 5, 2021-22 to 25, the judiciary has identified strategies that speak to case backlog and case disposal. The plan identifies one of the judiciary's strengths as innovations in adjudication of cases such as pre-bargain, ADR, small claims procedure. Strategic Objective 2 identifies the need for strengthened ADR mechanisms as key measures in the administration of justice. We need to continue aiming at having relevant intervention for expeditious disposal of cases. In line with the strategic plan, the Chief Justice constituted an ad hoc committee on the development of alternative dispute resolution strategy. He talked about the membership of this committee in his opening remarks this morning. The mandate of the ad hoc committee is first, to develop alternative dispute resolution strategy to guide on how the judiciary should best approach ADR. The other functions include capacity building and the implementation of alternative dispute resolution approaches. The judiciary has been graced in the developing of the ADR strategy with the support from the International Development Law Organization, IDLO, and Pepperdine University. We thank them for the support they have extended to us. The ad hoc committee has held a series of meetings to discuss the draft of the alternative dispute resolution strategy. A stakeholders consultative meeting on alternative dispute resolution was held on the 1st of June 2023. This summit gives us another occasion to discuss broader viewpoints on ADR strategy. An alternative dispute resolution strategy is a useful tool that will help us administer timely and cost-effective justice to the people of Uganda. Our neighbors in Kenya have developed a similar strategy in which the judiciary has identified ADR pathways that can be mainstreamed in the formal justice system. I extend our gratitude to you all for the support you have given us towards developing ADR strategy. Before I conclude, I wish in a special way to thank the Principal Judge, Emeritus Justice Bamwine, Miss Robina Shinobi, Justice Kiryabwire, Justice Musa Sekana, and all of you who have published in the area of ADR. Thank you very much. I encourage all of us who can to publish and practice in this area so that our people learn from your experiences. I thank you all and wish you a pleasant evening and fruitful deliberations tomorrow morning. We will start early and manage the time better. Thank you very much.
Thank you very much. The Honorable Justice Richard Gutera, Deputy Chief Justice and Chairperson of the Summit Organizing Committee. In case you don't mind, let's appreciate him better once again for the last time. Clap like this is the last clap of your day, since this is the last person I'm telling you to clap for this evening. Thank you very much, ladies and gentlemen, for your participation today, for your involvement in the different sessions that we have had, in the different groups and tracks. It's been awesome. Go with me to the program right now. Tomorrow, we have day 2, which will be the last day. And tomorrow, we are going to be getting into the depth of the things we were talking about in brief. The way they talk about the news and they say, here are the headlines. And then they say, now, here are the details. Tomorrow, we are getting into the details. We will be looking at a brief introduction to ADR as it relates to the different global trends, what is happening in other jurisdictions across the continents. And then we will look at the role of the judiciary in advancing mediation and arbitration to enable effective resolution of disputes. Not to enable resolution of disputes, but effective resolution. We will have more details on unpacking the tensions that are happening currently between the courts and the arbitral tribunals, and a number of many other things. So let's come here by 8:30, let us be in the room, and we will be guided on how we will be empowered, equipped, and given the skills and the knowledge we need to go out there and shine as we dispense justice, not only in this country, but wherever the Creator will send us. Many documents are already on the Summit website, and you can access them this evening. And if you want to access the different presentations and the different remarks that have been given today by the different awesome people, you can visit the Summit website at www.adrsummit.com. adrsummit.com. www.adrsummit.com. Or you can scan the QR codes on your tables. On your tables, they are small pieces of paper. These ones here that look like this. So this is what we are calling the QR code. So what you can do, you can get your phone and scan it, and then it will take you directly to the website. When you reach there, go to the top menu, select Summit Resource Center, and there you will be having access to everything that has been dealt with and talked about today. Signing out, my name is Samuel A. Bakutana, a certified executive coach, award-winning leadership consultant, the recipient of the Leadership Impact Award in Uganda 2022, a global speaker and author, husband of charity, father of 2, national president of the Fathers Union in Uganda. See you tomorrow morning by 8:30 a.m. Good night, ladies and gentlemen.